May I have your attention, please? All rise. Lawrence County Municipal Court is now in session. The Honorable Donald R. Camper presiding. All those having business before the court draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. I'm Judge Capper. We have a lot of review hearings to do today, so people are here for reviews. Your name's going to be called. Come up to the table to the right with your group when you're called. I'm reviewing your file to see if you're compliant with court orders. All reviews.
Emily Amicon, Jeannie Covelli, Daniel L. Cox, Damon Cox, Dakota Kraft, Tracy Crockrell, Danny R. Dodson, Terry Fan Jr.
All right. Emily Amicon has been called. Is she on? Okay, she's on blue jeans. Okay. See her?
Yes, fine. I'm right here.
All right. I'm getting it set up. Hold on. All right. This is case number 2285. What's going on with you, Emily?
I made a $20 payment towards the looks like my fines and stuff.
Where
I
are
made more.
Where are you today?
I'm still at the still.
Okay. Are you in a treatment facility or?
Yeah, I'm in St. David sober living. I just got a new job and I'm 7 months pregnant, so financially it's just kind of tight right now. But once I get my next paycheck, I can make a bigger payment towards it.
Okay. All right, I'll let you continue as long as you're compliant. You can attend by teleconference.
Okay.
Your next hearing will be October 27th. 9 a.m.
October 27th.
Yes, ma'am. Last Friday of October.
Okay, if I make compliant, I'll pay it off until after the 10th quarter.
You do not have to attend.
Okay.
You pay it off. Jeannie Covelli is
Yes,
here.
sir.
024667. You're paying on your fines, of which I reduced to $250. Do you have a payment?
I got $125 for you at 2 o'clock.
Okay.
And then another balance next Friday.
October 27th, if you have paid it off by then, you don't have to come back.
Cool. Not that I don't like to see you, but thank you.
You're welcome. You can come back and visit if you want. Daniel Cox.
Hi.
Daniel Cox is 08425. Daniel Cox. not up here, it'll be a warrant issue.
He also hasn't been following up with his outpatient at OVP either, so I wanted to
Okay.
let you know that.
All right, thank you.
Thank you.
Naaman Cox.
Your Honor, he was here this morning. He came to Mr. Major and wanted to do a hearing stand before he came into court.
Okay. Naaman Cox, come into court. We'll come back to him then. Dakota Kraft.
May I approach, Your Honor?
Thank you for your letter.
May I
Got
approach?
that? Yes. Okay, it's a very good report. You've come a long way, and I acknowledge that, and thank you for how you've responded and how seriously you've taken things.
Yes, sir.
So, good job there. And, I mean, you still have some fines left to pay. Can you make any payment today?
As soon as I cash my check, I can come back and make a payment.
Okay, and for everyone, not just you, but on October the 7th, which is not this, next a week from tomorrow, is Union Township Cleanup Day. You come here, but you'll go to Union Township and help with their cleanup project, and you get double credit if you do that day. So you get 2 days of community service if you owe community service, or if it goes toward your fines, you get $100 credit for doing that 1 day of community service. So
Yes, sir.
for anyone who wants to take advantage of that. Okay, I'm going to go into November with you, Mr. Pratt, because you've done so well.
Thank you, sir.
I'll make it November 13th. It'll be your next hearing. Keep
Sir.
up the good work.
Thank you.
Thank you, Your Honor.
Okay, we've got Naaman Cox back. So call him. He has an acceptable screen. 21-306, 22-16-63, 21-19-17.
He has an assessment scheduled today at 1 o'clock, but he can actually go there as soon as he finishes here.
Okay. Well, you probably should take a look at his screen then. He still has some community service to do. You heard what I said about the double credit. You got quite a bit left.
Yes, sir. I've got either 8 or 10 hours that I need to get signed for that I've already completed, but I don't have nothing to prove it with me today.
Where'd you do that?
Decatur Township.
Okay, get something in, turn it into probation about that.
But I've also got most of this week off and probably most of next week off, so I'm able to rack up some hours.
Okay, very good. October 27th will be your next hearing.
Not me. I think so.
Okay, so don't leave. You need to hang around for that.
Do I just wait till 10 to come back in for that?
Yes.
Your Honor, could we see the screen? Thank you.
You're welcome. Okay, October 27th, and you got a hearing later this morning. Tracy Crockett. 2589. Okay, things have not been completed. Danny Dotson. 2223, 192448. You were at our class, are you still there?
No, I completed.
Okay. All right, you just have fines to pay then.
I got a payment,
How much are you paying today?
25.
All right, see the clerk with your payment. I need to check the last report I have. It says he's set to complete shortly thereafter, but I don't have an actual letter of completion.
Okay, I'll get one sent.
It says he was going to complete July 28th. The letter I have is July 22nd. It doesn't say he's completed, so if you could give me one saying he's completed. Okay, October 27th is your next hearing. Get things paid off and you won't have any more hearings.
So,
Terry Fannin Jr. is 21-315 and 21-1131. And he's at Southern Hope, but he's not here today. Do you have any explanation on that?
Our office staff took a lot of our clients on a field trip to the zoo today, and he went with his girlfriend and baby, who I guess forgot about court, but he hasn't been doing well, and he came in this week and paid $50 on his fines as well.
Okay, that is correct. So I'll reschedule him and you can let him know.
Okay.
Okay, I'll make it next Friday, which is October 6th.
Okay.
Thank you.
Thank you.
Clarence Falk, Kimberly Gannon, Hannah Gooden, Matthew Hoff, Jonathan Jarvis, Travis Jeffers, Jessica Leggett, Evan McConnell.
Clarence Falk, 04578. You're paying on your fines or working them off, looks like you.
Yeah, I've been working some Saturdays with Josh because I got my community service done, so now I'm working it off and I'll be here on the 7th to get the double credit also.
Okay, October 27th is your next hearing, 9 o'clock. Finish it up, you don't have to come in.
Yes, sir.
Kimberly Gannon, 21-3329. And, okay. Positive report, but it looks like there's still things you're working on. You did make a payment on your fines today.
Should have paid him off, I think.
You're going to pay them off? or-
I already did.
Well, I'm not showing that, but check with the clerk, I'm still showing. You made a payment this morning then?
Yeah, for both.
Okay, I guess that's correct, they just didn't mark it out. All right, well, you're not completed though, according to the report I just got, so there's still stuff you're working on. But I'll give you more time before you come back. Is she doing okay on screens?
Yes, Your Honor.
Okay, November 13th.
Thank you, Your Honor.
You're welcome.
Thank you. Have a great day.
Good. Hannah Gooden. Hannah Gooden, 22-2509. OVP. Brianna, can you check on Hannah Gooden? She was at Ashland.
What was her
OVP.
last name one more time?
Gooden, Goodan.
Okay, let me check on her.
Your Honor, she was not community service and she was over the DA.
Okay, I'll put her aside to get a further report from OVP. Matthew Hoff, 23,385. That's a very good report. Good job. And you work some toward your funds, payment on your funds.
I'm gonna do the double credit.
Okay? November 13 will be your next hearing, 9 o'clock. Keep up the good work.
Thank you, sir.
Thank you, Your Honor.
You're welcome. Jonathan Jarvis, 23,900. Okay, you paid your fine, you have community service to do.
Yes, sir.
When can you get that finished?
I just made it back into the area the last week or so. Last time we spoke, I was in Springfield with ARC. I completed my treatment, and last minute I decided to stay on an intern to stay with ARC, and I just transferred to Calixburg.
Okay, so you're living locally then?
Yeah, I'm now able to.
Okay, you've got 5 days of community service. You do that on the 7th, you get 2 of those knocked out in 1 day.
Yes, sir.
I'll set your next hearing for November 3rd.
November 3rd.
Yes, sir.
Thank you very much.
9 o'clock.
Thank you.
Get it finished, you don't have to come back.
Thank you, sir.
Travis Jeffers, 23,239. Okay, and you were gonna go to some counseling. Did you do that, or?
I have not yet. I'm gonna try to start calling next week, find somebody.
So,
I got all my community service since
you
the
did,
last time.
your community service paid your fines, and basically what your entry says, you have the option of going to the driver intervention program, which is a 3-day program. If you want to do that, or if you can go to counseling. The problem, I think, was, do you have health insurance, I think?
Yes.
So, ironically, it's harder to get treatment if you got health insurance than if not. But OBP probably can help you. He has health insurance.
Okay, I can talk to him.
Brianna is from OBP. They're a medical facility, so they can take some health insurances that some of the other facilities don't. So I want you to talk with her, or you can go to the 3-day school. The closest one is inside the county now. We don't have one locally.
Okay.
Get that done and you'll be completed.
Yes, sir.
I'll set your next hearing for, since you've done everything else, I'll give you a couple months. November the 27th. If you have it finished by then, you don't have to come back.
Thank you, Your Honor.
You're welcome.
Also, on Hannah Gooden, she had been compliant until her last visit. She failed her screen for meth and benzos.
Okay.
So they are going to reach out to her and let her know that she had court.
And I'm going to go ahead and issue a warrant for her since she didn't appear and sounds like she's relapsed.
Yeah. So, all right, thank you, Your Honor.
You're welcome. Thanks for the report. Jessica Leggett, 21-1151. She's at Mendegreets.
I'm an outpatient.
Are you working now, or what's going on?
Yes, I'm working at Subway.
Okay, very good. we'll work with you on, I know you're just getting started back, so you probably don't have a lot of money laying around, do you?
No.
Okay, so we'll pass on payment on your fines today.
Okay.
I'll set your next hearing for November 3rd. So, good job, keep it up.
Thank you.
Evan McConnell, 22,754. Hasn't done anything on his case and hasn't appeared. Supposed to be at Southern Hope. I'm assuming he's not, or I would have got, be getting a report from them. Evan McConnell, Southern Hope, not here, no report from them, so there'll be a warrant issued for failure to appear.
Cody Mead, Kelly Mintz, Benjamin Shepherd, Alfreda Steele, Danielle Summers, Joyce Turley, Jacob Williams.
Cody Mead,
Yes, sir.
23,152, 22,1690, 22,2101. And you're under common pleas watch also, is that correct?
Not anymore.
You finished with them?
I just got, from February 11th to 9/11, I just did 7 months. So my felony paper is knocked out, it's killed.
Okay. All right, well, then you got stuff here to do.
Yes, sir.
So you've got basically fines and court costs to pay.
Yeah.
You have a payment today?
I don't, but, we just had our 4th child on 9/11. And, she's been healing up. I've been back to slinging shingles. I get paid today, but it won't be later on. So I'll have some money probably first thing Monday.
All right, I'll make your next hearing October 27th. Get out here and do that double credit day.
Double
Just
credit
your
day.
fine. October 7th?
Yeah.
You get a $100 credit if you can do community service that day. Towards your fine. October 27th is your next review hearing at 9. October 7th is a double credit day, that's a Saturday.
Right.
Come here at 7:30 a.m.
I got sentenced on a Wednesday. Friday I came and seen you. The Wednesday killed my felony paper out. But where I have 2 OVIs, I'm supposed to do non-reporting.
I don't understand what you're saying.
Like I have non-reporting probation. Still through you guys, right? Like I'm supposed to start, is what I'm saying.
We gave your jail concurrent with what you got in common pleas. You got level 4 probation, I'm reading from the judgment entry, which is not non-reporting, so.
All right, thank you.
So, you've got your fines and court costs to pay, and you got, I don't know, you've got a license suspension too, I'm sure.
Yeah, for a year. I got a question on that. I think last time I seen you, you told me if you got more, which I got at least 1,600 suspensions. But yeah, I think you said something about more than 2, you can't get a work permit.
Yeah, I can't give you a work permit under.
So like, for me to get back and forth to work, is there anything I can do to like make a payment to where, or something to where I can get a work permit?
You can petition the BMV. I don't know if they would make some special circumstance, but you dug the hole too deep for me. I don't think I can, and I'm not going to give you a permit with all the problems that you've had before. So I know that makes it tough to get around, but.
I mean, I know I get people make
Whose
mistakes.
fault is it?
I mean,
It's
people
your
make,
fault.
people make mistakes, but how
You
do I
made a lot of
better?
them. How
How do I continue trying to better myself if I can't get back and forth to work and cost
I
them
don't know, need a
there.
bicycle, hike, whatever, you'll have to figure it out, but you dug this hole, so. I'm not gonna turn you loose out on the road. Do you have insurance? You probably can't get insurance either.
I had to keep an SR22 bond. I got my license back before, and I missed the payment by one day, and that, at 12 o'clock, they suspended. I didn't know that. And then I got caught driving again, like about not even a month later, and I found out they were suspended. And ever since then, it's been getting them paid, almost getting them paid, oh, get pulled over. Oh, start getting the fine, start doing the right, boom, get pulled over. See what I'm saying?
Well,
I know it's my fault.
It's hard when you don't live in an area with public transportation. It's hard to get around without a car, but I mean, you're not allowed to drive if you don't have a license, so.
I know.
So, sorry. October 27th, your next hearing, 9 o'clock.
All right, thank you.
Kelly Mintz. Kelly Mintz,
Kevin, next, I'll check it, Your Honor.
18326. There'll be a bench warrant for Kelly Mintz for failure to appear. Benjamin Shepherd, 213595.
Did not check it, Your Honor.
Bench warrant for failure to appear. Alfreda Steele.
Yes, sir.
132847, 132828. All right, I think, Ms. Steele, I told you last time you needed to appear. You haven't, okay, you did make a payment September 28th, so I'll let it pass this time.
Yes, sir.
All
I
right,
didn't know I was supposed to come in.
as long as you make a payment, I won't require you, because for a long time, you didn't make a payment on this case, so.
Right. I finally got things situated, so, and I'll make another payment around the 3rd.
Okay, October 27th is your next hearing, 9 o'clock.
Okay, thank
As
you.
long as you make a payment, I'll let you appear by teleconference.
Okay, no problem.
Thank you. Danielle Summers, 212640.
Ryan, this is up there.
Okay, we're not to you, Mr. Collier. Okay, this is a good report. I read the whole thing word for word. Good screens, good report, good job.
Thank you.
Okay, you only owe $75. I'm going to give you some more time. It's taken a while for you to get to this point, but I think you're on the right track.
Thank
November
you.
13th will be your next hearing.
Okay, I'm paying 50 on my fine today.
Very good.
Thank you.
Continue with your counseling. That's one of the best reports I've seen you have. So November 13th is your next hearing. Good
Thank you,
job.
Your Honor. Thank you, Your Honor.
Jace Turley, 23,354, 355, 353. Has certificate of completion, Lawrence County Recovery, and a report from them. Okay, and
He's very compliant, he's doing very well.
very good.
Your Honor, he was ordered on 8/4 to have visual community service before his next hearing, he is not showed up here.
Okay, what about that?
I did community service in Ironton last week for 6 hours. I went out to the farms.
Okay. check in, I want you to go check in with the probation office. You've got 4 more days to do it.
Yeah. Yeah, just 3 after that.
So QRT's monitoring him also?
Yes.
Okay. I'm going to put him out then to December since you're monitoring him. December the 8th at 9 o'clock, and hopefully that'll be your last hearing. If you complete everything by then and get a good report from QRT, you won't have to come back.
Gotcha. Thank you.
You're welcome. Jacob Williams, 22-806-807, he's at RRS.
Yeah, Your Honor, he had an assessment yesterday, so he's just getting started.
Okay.
Your Honor, I also have a report, he was ordered on 8/28 to do some community service, and he has not been anything.
What do you say about that, Mr. Williams?
Don't really have an excuse for it.
Okay, well, you go back in the back then to the holding cell. Yeah, we have a cell back in the back. People don't know that. That's where you go, or can go, if you don't do what you're supposed to. You won't stay there. Eventually, you're going to go to jail, but temporarily, you'll be back here.
Stephen D. Lynch, Jared Nance, Robert Reynolds, Christopher Roadkill.
Stephen Lynch.
Yes, sir.
18502. You did make a payment, and all you have to do is finish off your funds.
Yes, sir.
You can get that double credit day. It's coming up.
Yes, sir.
You should finish this up by the next hearing. October 30th,
Thank you, sir.
9 o'clock. Jared Nance.
Now pressure on it.
Yes, 220812. Yeah. Okay, good screens. Working on restoring your relationship with your child or children. I don't know how many you have.
I got 3.
And it looks like you're about to go into sober living.
Mm-hmm.
It's okay. It's a very good report.
Thank you.
You've done quite a bit of community service. That's all done. Working on, if some of this is restitution, your fines you can work off, but if there's restitution, I don't remember if there was restitution, no, you'll have to pay that. Because restitution goes to a third party, it doesn't come to the court.
I don't think I had any restitution.
Okay.
Not sure of.
All right, next hearing, November 3rd. Good report. Keep it up.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Robert Reynolds, 2510. Is not finished, hasn't appeared, so it'll be a warrant. Christopher Roadcap.
Yes.
211172. Community service is done, you've done extra toward your fund.
Yes, I will do that, that thing on the 7th.
Okay.
I just finally got back to work, so next Friday I'll start, paying some on the fines too.
November 3rd will be your next hearing, 9 o'clock.
Okay, thank you.
Okay, that finished the review hearings. We're going to start the arraignments now. If you're here for arraignment, or if you missed a hearing on an old case, you'll be called with the arraignments. When your name is called, come up to the table to your right and stand there. I'll go over the charges with you. You have a right to remain silent. You don't have to make any statements. If you choose to make statements, what you say is going on the record. It can be used against you if you admit something about your case. You have a right to have an attorney. You have one appointed if you can't afford one. You have a right to bail. You have a right to make the state prove any charge against you beyond a reasonable doubt. If you enter guilty or no contest, you're waiving those rights. You should not do that. If you don't understand what's happening, if you have questions about what's happening, if you want to talk to a lawyer, if you want to try any of those reasons, enter a not guilty plea. That's the safest plea you can enter. It preserves the rights you have as a defendant. Call the first case.
State of Ohio versus Mitch Wright. Case number CRB 081383 and TRC 082919 A and B.
All right, this is for a review hearing that was set last Friday, and it's alleged you didn't attend. Is that correct?
Yes.
All right, do you have an explanation for that?
I was out of town working and I mixed my court date up. That's all it was.
Okay, looks like he has done some toward his funds.
Yeah, I paid $1,200 a day.
Okay. All right, well, looks like there's a small balance in it.
Yeah, 138.
Okay, so you should be able to take care of that in the next time frame?
Yep.
I'll set it for November 3rd. If you've paid it off, you don't have to come back.
All right, thank you.
You're welcome. That's for review. Both of those are review. November 3rd for review at 9 o'clock.
State of Ohio versus Melissa Hardy. Case number CRB 23585. Melissa Hardy.
Ma'am, are you Melissa Hardy?
Yes.
Ms. Hardy, the state's filed a complaint against you alleging that at Rome Township on September 27th of this year, you knowingly caused or tried to cause physical harm to Tammy Hardy, and that Tammy's either a member of your family or a member of your household. That's a first-degree misdemeanor. The maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you wish to plead to this charge? Remember what I said, if you don't know what to do, not guilty is the safest plea. You want to enter a not guilty plea?
Yes.
Do you wish to be considered for a court-appointed lawyer? Do you have a job?
No.
Do you have no income?
No. My therapist had recommended that I stop working, and he has reached out to me multiple times to ask my mom to go to counseling with me, and she has not done that. And this has been almost a year ago. So I was going to recommend that we could do that together.
Okay, well, I'm going to appoint Mr. Morford to represent you. I'm entering a not guilty plea for you, and I'm assuming this must be Tammy Hardy that's over here. You're Tammy Hardy?
Yes, I am.
Would you speak to the prosecutor, please, ma'am? Then, Mr. Hill, if you can let me know conditions on bond, if any.
Your Honor, two things that believe that we can tell the court, and that is that Tammy Hardy does want a protection order at this time. Is that right?
I do.
And she's also in favor of Melissa having counseling. I guess,
I'm willing to do the group counseling as well, I think it would be beneficial.
so I guess that if we have a,
Oh, later on. I'm sorry.
so you want to start off with a protection order?
Yes, sorry.
So she's going to consider doing group counseling at a later date, but I think she wants for Melissa to get started. I don't know whether she already has a program she's
She has
involved
a
in.
counselor already. You have a counselor you're seeing, right?
Yes, and about 2 or 3 months ago, I had contacted a couple rehab facilities and I hadn't qualified because she had recommended it to me.
For substance use?
Yeah.
Still willing to do that?
I would be willing, but I don't think it's necessary because I haven't been drinking, but I was drinking on the day that this happened.
And that is her issue, Judge.
Okay. Do you have a medical card,
No,
but you don't have any income?
no,
Are you Ohio resident, or where do you live?
in Ohio.
Where? Proctorville?
It's Hilo Ridge, no.
Okay, right over from here then.
Yes, it's the same address.
You're not living with Tammy now,
No,
and that's not a problem for you to stay away?
no.
Okay, so I'm going to order you not go around or contact her or post things about her on social media while things are pending, and then eventually, it sounds like maybe we could get some joint counseling together, but how about RRS, since you're close to Chesapeake then, so I'm going to refer you to an agency that's right here in the village that can do some counseling with you. Where do you go for is that mental health counseling that you're doing?
The doctor I was talking about, he was Dr. Frederick, and since then, and she wasn't going, I quit seeing him and also because there was a problem with my insurance, he wasn't getting paid.
Okay, well, why don't I've got another solution for that. Why don't you go to PATH, and they're also local.
We work with them all the time.
Mr. Gwynn can help you get that set up, so we'll have you substance and mental health, and it's all local, really close.
And it's
Should be
all
easy for you to get
outpatient.
there.
Is it all outpatient?
Should be outpatient, at least initially, I'll let them make that assessment if you need inpatient. Okay, so referring you to RRS and PATH. Mr. Gwynn is here, he'll talk to you. Come back in a couple weeks then, Mr. Morford?
Please, Your Honor.
That's the 13th of October. Protection order is issued. Maybe drops later. For now, at least for maybe the next 2 weeks, no contact, and we'll reassess that. You're welcome to be here, Tammy, if you want to be. You're not required to. You're not a party to this, but if you want to come, of course, anybody can come. It's open to the public. Anybody can come to any of these hearings they want.
I want to support my daughter, I just want her to get help.
I understand. Okay, the bond is continued as posted. Next hearing, October 13th, 10 o'clock.
This is you.
That's me. Thank you, Your Honor. That's when you come back, till the 13th, October 13th.
Okay, who do I need to
And
talk
Bobby
to?
is right there behind you. He will help you to sign that.
State of Ohio versus Jameson Watts, case number CRB 23532 A and B. Jameson Watts. Jameson Watts.
Jameson Watts. Come up to the table, sir. Mr. Morford, I think you're his attorney.
I am, Judge, that's why I stood here. I thought the name was familiar.
Yeah, he had here pre-trial on September 22nd. Apparently, he was not here for that. Have you had a chance to talk with him?
No, Your Honor, I have not.
We'll recall after you talk with him, he gives you an explanation why he missed the hearing.
Thank you, Your Honor.
Do not depart the courthouse, sir. Your word to remain, and your case will be recalled later.
State of Ohio versus Courtney Hampton, case number CRB 23537, A, B, and C. Courtney Hampton.
Courtney Hampton, come into court. Anybody that has hearings this morning needs to be in the courtroom, not in the lobby, not out in front of the courthouse. Come into court. Ma'am, you're Courtney Hampton?
Yes.
The bail's handing you a copy of the charge. It's a domestic violence charge. It alleges that Fayette Township, on September 28th of 2023, you knowingly caused or attempted to cause physical harm to Mark Oden, who's a family or household member of yours. That's a domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. Then there's another charge of assault, and that alleges that September 28th, also in Fayette Township, you knowingly caused or tried to cause physical harm to Tracy Atkins. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand these two charges?
Yes.
Do you understand your rights?
Yes.
How do you plead to these charges?
Not guilty.
You want a lawyer appointed?
No.
Have you hired a lawyer?
Yes.
Who's your lawyer?
Crystal Water.
Okay, I'll put Mr. DeLauder down as your lawyer.
Your Honor, this is a C case also.
Okay, I missed that. There is a C case. It's a third charge. It alleges the same time and place you knowingly caused or tried to cause physical harm to Marion, I guess it's Marion Casey. That's also an assault charge. First degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. I'll enter a not guilty plea on that also.
Not guilty.
Mr. DeLauder is going to be listed as your counsel. I'm entering a not guilty plea for you. Does any of these other people have charges?
No.
You're the only one with a charge?
Yes.
Okay. Did Mr. DeLauder give you dates when he was available to come to court?
Yes.
He did? No?
No,
Okay.
not yet. I spoke with him this morning. This just happened yesterday evening.
I'll set the next hearing for, check, make sure how his docket is looking.
He was on a press charges.
October 13th, that's 2 weeks from today, for a pre-trial at 10 o'clock. Do you live in the same household with any of these folks, or are you separate from them?
Mark, he has been staying with me.
Okay. I'm going to order that you stay away from him. Is that a problem?
So, it's my house, so I just gotta go get some of my clothes and my...
Is he still there?
He is. He won't leave.
Okay. Well, if you want to come back sooner then, I can set the hearing sooner than 2 weeks. I can have a hearing faster than that if you want.
No, if you don't care.
Okay, we'll make it for next Friday, October the 6th. Now, you'll need to let Mr. DeLauder know, and I don't know if his schedule will allow him to be here on that day, but he can ask the court to change it if he wants.
Okay.
So is it still set for October the 13th?
6th.
The 6th, okay.
6th. I'm trying to get her in here sooner since we may have an issue about who's going to live where.
And that's at 10?
That'll be at 10.
Okay.
She's already posted a bond, so that's continued. And is there protection orders requested then?
We are, Your Honor.
Okay. I'm ordering you to stay away from the Mark Oden and Tracy Atkins and Marion Casey. said what the charge was. All right, October the 6th is your next hearing.
All right, thank you.
State of Ohio versus Christina Dawn Webb, case number CRB 23586.
You're Christina Webb.
Yes.
Bail's bringing you a copy of the charge. It alleges that on August 27th in Fayette Township, while not being lawfully engaged in hunting, you were the owner or keeper of a dangerous dog or vicious dog that you failed to keep physically confined or restrained on your premises, and that you've been previously convicted of failure to confine in the past.
I've never been convicted of anything dealing with this.
Okay, I'm just reading what the complaint says. It could be wrong. It could be totally wrong, but I don't follow the charges.
Right.
That's their job. You're charged with failure to confine a dog. That's a misdemeanor of the 4th degree. Maximum penalty is 30 days in jail, $250 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead to this?
Not guilty.
You want a lawyer appointed?
Yes, please.
Are you working?
Yes.
What do you do?
A preschool teacher,
Are you paid by the hour, or how do you get paid?
hour,
How much per hour?
12.
You have family you're supporting? Do you have any children?
I have 2 kids.
Okay, you're eligible for court appointed counsel then. I'll appoint Mr. Smith to represent you. Set, yeah, she can sign a $1,000 signature bond. It's a 4th degree misdemeanor, so unless there's a time waiver, we can come back pretty quick.
Judge, I hear the 13th or 16th.
And you waive time till?
Yes, oh, yes.
Okay, let's make the 13th actually better. October 13th, pre-trial at 10 o'clock. Okay, we have some arraignments to do at the jail, so we're going by teleconference with the jail to arraign those defendants.
State of Ohio versus Gary Carey, case number TRD 154670, PRC 151852, A, B, and C, and Corey Little is on deck.
And ma'am, are you Gary Carey?
Yes.
I'm Judge Capper. This is an arraignment for missing a review hearing some time ago. It's alleged that you missed a hearing on February the 17th of 2017 on both of these cases. One was a conviction for an ODI. It looks like you still had fines left to pay. And the other was a conviction for driving under suspension, and there was still an amount owed due on that. And there had been a warrant outstanding for several years. So it looks like you got picked up on that warrant. Do you understand the charge against you?
Yes, Your Honor, I do. I didn't know I had that one.
Well, it must have showed to somebody because you're back in jail. How'd that happen?
That's right, well, I'm just gonna say, and I was here before, it didn't show when I.
Well, sometimes we don't always get things right. Mistakes are made and things slip through the cracks, so.
Right, well, that's all I say, I apologize, I will.
How long you been in jail? Oh, okay. How'd you get picked up? What happened to cause you to get picked up?
I was driving with someone that had no license, and they were
Okay, and they checked your ID and found you had a warrant?
yeah.
Okay, I'll send you your time, sir, for not coming to your hearing previously back in February of 2017. I'm going to give you a new review hearing date. Now, you understand how this works. You have a review hearing, You keep coming back to court periodically till you finish everything you were ordered to do. Once you're finished, you won't come to court anymore. If you don't show up and you still have things left to do, then you automatically get a warrant issued. And it may take a while to get you picked up because the sheriff is not going to go hunt you down, usually. But as soon as you have police contact, boom, there you go, to jail. Okay, so we'll set this, I'm going to release you unless you'll get out unless you've got a holder from another court for some reason. I'll set it for November 17th. So I'm giving you some time to work on this. So you can do community service, you can pay, whatever you can do to get this taken care of. We'll give you credit for every day of community service you do of $50 toward that. And on October the 7th, a week from tomorrow, you can get double credit by coming at 7:30 a.m. to the court and doing community service that day because it's a township cleanup day and I'm giving double credit. And you know where the court is, right? You know where you got to come. Okay, you're going to get out of jail here as soon as we process the paperwork. You still have this stuff left to do. Get it taken care of. You're welcome.
State of Ohio versus Corey Little, case number CRB 23283B, CRB 23216, CRB 22491, CRB 22407. Ryan McLean is on deck.
Your Honor, Mr. Little was referred to as on his previous cases, and he was recommended for inpatient treatment, and he disappeared.
Okay, now I have a note that he had hired Luke Steyer back in April of 2023, but he missed some hearings and has had a warrant outstanding for quite a while.
That's correct, Your Honor.
Have you had a chance to talk with him?
I wasn't aware he'd come into custody.
Yeah, he is. So you want to talk with him?
Yeah, let me give him a call and see.
And I'm assuming you want the court's files?
Yeah, I don't have my files today.
So I don't know if he has anything in common pleas. Also, there's some felonies in this mix. He had left treatment before, right?
No, he was assessed and then never came back. He was supposed to go inpatient.
Okay. Your attorney's going to call and talk to you, Mr. Little, then I'll recall you back before the court after that's happened.
Thank you, Your Honor.
State of Ohio versus Ryan McLean, case number CRA 23584, and Betty Ross is on deck.
Ryan McLean is up next. All right, sir, are you Ryan J. McLean? Mr. McLean, I'm Judge Capper at the Lawrence County Municipal Court, which is located in Chesapeake, Ohio. That's where your case is filed for some reason. This is an extradition, or actually a Rule 4, kind of like an extradition within the state of Ohio. If there's a warrant for you in a county that doesn't touch the county where you're located, then you have a right to a hearing to make sure you're the right person that's being sought by that county and whether you should be made to go to that county on the charge that's filed there. It's alleged that there is a warrant for your arrest out of Common Pleas Court of Washington County, which is Marietta, and that Washington County does not touch Lawrence County, so you have a right to a hearing. You have a right to have an attorney. You have a right to have one appointed if you can't afford one. You have a right to remain silent. You don't have to say anything about this. If you choose to make statements about it, though, it's all going on the record and can be used against you. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Do you understand those rights?
Yes.
Do you want to have a hearing about whether you are the person being sought by Washington County, or do you want to agree to go to Washington County?
I'll agree.
Okay. So you're going to sign, we're going to fax down something called a Rule 4 hearing waiver. you're gonna sign that, and then what's gonna happen, they don't tell me anything about why you're being arrested or what the charge is in Washington County. Usually they give me what the charge is other than, okay. Well, here's what I'm gonna do. I'm gonna set a bond for you at $10,000. So, and I'll let you use a bail bondsman. So if you got $10,000 yourself, you can post that. Then when you show up and I'll release you, order you to go turn yourself in Marietta. Once you do that, you get the whole $10,000 back. If you can't, if you don't have $10,000, you can hire a bail bondsman. You just got to pay their fee, whatever they charge you to post the $10,000. Then if you don't show up in Marietta, they're going to be hunting you down because they don't want to pay the $10,000. Do you think you can post a bond, or you want me just to tell Marietta officials, Washington County officials, that you're here and they got to come fetch you and take you back to Washington County?
I would definitely go to report there, and I'd really love to find out, would it be possible to have any lower bond? I could pay almost that, but not quite that.
Okay, what's the bond you think you could make?
With a bondsman, I might be able to pay like $600, $700, so like $6,000 to $7,000 bond.
I'll reduce it to $5,000. So $500 probably will get you out. So you want to talk to a bail bondsman then?
Yes.
Okay, we'll have one contact you. How much time do you want to try to post it? Are you pretty confident that you can post it?
I should be able to by the end of the day.
Okay, because what's going to happen, here's the way this works. I'm not going to tell Washington County authorities they got to come and get you till we find out whether you're going to be able to post bond, and I'm not going to know that today. I can put it back on the docket for Monday and see if you were able to post bond.
That'd be great.
Okay, that's what I'll do.
Okay.
So I'll give you all day today to post it, till 4 o'clock today. And the bail bondsman will probably, if we tell him that you're going to post bond, you'll probably hear from him within the next couple hours. So you should have some time. So I'm going to give you $5,000 cash or surety. If you post that bond, you must turn yourself in to Washington County before Friday, October 6th. So that gives you next week to turn yourself in. Then as long as you do that, we're good. Now, I'm going to put you back on my docket for Monday, so if you can't post bond and you're still sitting in the jail, then I'll give Washington County a time frame in which they have to come pick you up. I'm not going to make them come down here and then pass each other on the road because you posted bond.
Okay.
So this waiver will be sent down for you to sign. I'll put him on my docket for Monday, which is the 2nd. And we'll just do that to check to see if you're in or out of jail.
Okay.
Mr. Sowers acknowledged he will go down to custody.
Okay, someone here's already contacted the bail bondsman, and he said he's on his way to come talk with you. Now, if something happens, you're in the hospital or whatever, you have to get word to this court. You can't just blow things off, because if you're out of jail and then don't turn yourself in Washington County, then I'm going to release the bail bondsman. I'm going to tell him, go find this man and bring him back into custody. And he's really good about doing that. He will track you down and take you into custody, and then you're going to be back sitting in jail. You understand that?
Yes.
Okay. Any questions, Mr. McLean?
No, Your Honor.
Okay, good luck. Take care of this next week if you get out on bond so that The main thing I'm looking for is that warrant needs to be withdrawn from Washington County by next Friday, or you gotta be back here and do a live explaining.
Okay,
Okay, that's all.
thank you.
You're welcome.
State of Ohio versus Betty Ross, case number CRB 16530. And Michael Tilley Jr. is on deck.
All right, you're Betty Ross.
Yes,
Looks like you got placed, just what I was talking about. You had a bond with Mr. Sowers. It's alleged you failed to appear for a review hearing on September 25th. And then it looks like he picked you up and placed you in custody because you didn't come to your hearing.
Yeah, I had a flat tire, my car broke down, but I turned myself in that next day.
Okay, well, let me check, but I think he asked to be released from your bond. Well, here's what he told me. I'm reading from a text that he sent me Tuesday. I just arrested Betty Ross, placed her in Lawrence County Jail. She did come and meet me on her own, but she had no good reason for missing court yesterday. I talked to her yesterday during court, told her to get there. She said she would, but still didn't go. I reviewed her case, and she's only made 2 payments in 7 years, has forfeited an OR bond in the past. And ask that he be released from your bond.
Your Honor, I do have a new job, I work at His Robinson Stomach.
Okay, well, here's what I'm gonna do. I mean, because this has happened before. This is not your first rodeo with missing court and getting picked up on warrants and so forth. To me, I've never spent the night in the jail, but I've visited people there before. It's a scary place. I would not want to go there. I would do whatever it took to stay out of that place. But you don't seem to be very scared of it. Because this has happened before. So what I'm going to do, I'm going to sentence you in contempt and order you to spend the weekend in jail and finish up your case by the weekend in jail. You've already been to jail before over this case for not doing what you're supposed to. You did pay a little bit on your fines, but never paid it off. So she can be released Sunday at 6 p.m. You can spend the weekend in jail. Released Sunday at 6 p.m. Case is completed by jail.
State of Ohio versus Michael Tilley Jr., case number CRA 23165. Flint E. Topping is on deck.
Sir, are you Michael Tilley Jr.? I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake, and this is your arraignment hearing. You have a right to remain silent. You don't have to make any statements. So what you say is going down on the record. So that means if you admit something about the case that helps the prosecutor, he's sitting right here listening to it, he can use it against you later. You have a right to have an attorney. You have a right to have one appointed if you can't afford one. You have a right to bail and to make the state prove this charge beyond a reasonable doubt. You understand all those things? Okay, let's go over your charge. It's grand theft. It's a felony of the 4th degree. And it alleges that on March the 11th of 2023 in Perry Township, you purposely deprived Sarah Osborne of property, and that was an automobile, a 2009 Hyundai Sonata, without her consent, or any other person that was authorized to give consent. So that carries a maximum penalty of 18 months in jail and a $5,000 fine. Do you understand the charge?
I do.
Do you have the money to hire a lawyer?
No, sir.
Do you have a job?
No, sir.
You have no income at all?
No, sir.
Okay, I'm going to appoint Mr. Steyer to represent you. And I'm going to get him in the courtroom, so we'll hear what the prosecutor wants on bond and decide how that's going to work next, as soon as your lawyer comes in here. So need Mr. Steyer in the courtroom. And I'm assuming perhaps this is Sarah Osborne that's in the courtroom now?
Yes. Yes, Judge. Yes, Your Honor.
I'm appointing you to represent Michael Tilley Jr. He just said on the record he wants to marry the complaining party, but he's accused of taking her car.
Well, expressed itself in strange ways.
Yes, it does. So it's a felony for her. I'm appointing you to represent him. What's the state's position on bond for Mr. Tilley?
Well, Your Honor, Ms. Osborne, the alleged victim of this incident, this crime, doesn't want it pursued. However, she has told us that Mr. Tilley has made a great progress recently in abstinence from illegal substances, which tells me that he's had a problem with illegal substances, and we want to make sure that he follows through with that. If he wants to marry her, he ought to be clean and have this behind him. So we're okay with no R bond today if he would be agreeable to being assessed to be in some sort of treatment, whatever is recommended. And what we would want him to do is to agree to waive time, and we'd leave the case here and let him be successful in treatment. And when he gets a clean bill, then I think at that time, Ms. Osborne wants the case dismissed. So at a later date, we'd be agreeable to that, if he's successful.
Where do you live, sir?
Right now, at the moment, I live in Jackson, Ohio. I do believe he's there with them, we've been together, so.
Do you, just, hold on. Do you have a medical card?
Yes, I do believe so.
And are you receiving any sort of substance abuse treatment now?
I'm not really.
Okay, that's all I asked, yes or no? Okay. I think we're agreeable to that, but he said he's living, did you say Jackson, Ohio? So I don't know who we have here that would be able to help out somebody in Jackson.
Anybody that has an office in Jackson or has some connections in Jackson that we can get Mr. Tilley treated or assessed?
But I couldn't hear what you said.
New Life Recovery.
New Life.
Your Honor, Eric Holmes is part of New Life. I have his number. I'm willing to contact him.
Okay, thank you very much.
Okay.
Was this vehicle recovered, or is it out in the ether somewhere?
It was recovered, and then a couple weeks after it was recovered, I actually ended up totaling it, so it's not even here anymore.
Okay, so the vehicle, but that's not an issue, if him still having the vehicle. Okay. And where, do you live in Jackson County also?
No, I live in South Point.
Okay. But I'm taking from what's been said, you don't want him ordered to stay away from you, or do you want him ordered to stay away from you? No?
No, I'd like to be able to go see him.
Okay. Well, you probably know better than anybody here. Let's figure out, does he need inpatient? Is this, what's, methamphetamine is big, fentanyl, what's the problem?
At the time, it was methamphetamine. He's done very well. I think we could try outpatient, and then if for any reason he doesn't comply, then we can talk about inpatient.
Okay, sounds like a plan. We're going to have someone hopefully contact you today from New Life Recovery.
Staying down here with you, or?
No, not currently.
Okay, so we definitely need to go up to Jackson area.
I think I've got Eric's contact information.
What I'm gonna do, sir, is I'm gonna give my card to your, friend here so that she has it, she can get it to you when you get out of jail. I'm gonna ask that you contact me as soon as you're out, okay?
With him being in an OR bond, will he be out today?
He should be able, assuming nothing else is holding him, he should get out.
Do you have a cell number where you can be reached, or it doesn't have to be cell? It could be any kind of phone number. Do you have a number where you can be reached, Mr. Tilley?
I got my grandma's phone, but
Okay, we'll take that. 740, I'm assuming.
yes, sir. 740-286-9717.
What's your grandmother's name?
Betty Tilly.
What was
Is that
it?
where you're living? You're living with Betty?
Yes, sir.
Okay. State okay with an OR bond?
Yes, Your Honor.
I'm texting Mr. Holmes now.
If not, it's 740-388-3070.
Okay, Mr. Tilley, let me explain this to you. You have a felony. There's two types of criminal cases, misdemeanors and felony. Felony is the more serious. If you get convicted of a felony, you can go to prison. Before that happens, you have to get indicted by a grand jury. That's how serious it is. Your fellow citizens have to say, yep, this is bad, we think this guy did this. So that's what a grand jury indictment is. You can avoid all that by going to treatment and doing what you're supposed to. Then the state's already said they're not going to take you to the grand jury. They're not going to indict you. They're not going to even give you a chance of going to prison. But if you blow this off, then that's going to be the next step. Then they will take you to the grand jury. You will get indicted. You will go to another court. You'll go to the common police court and have at least it be on the table that you could go to prison over this. So the best thing you can do is get in treatment, do what you're supposed to, and get the case dismissed. That's a win all the way around.
Yes, sir. I just want you to realize that I'm very active on birthday.
Okay, 2 weeks to come back?
Let me take a look at my calendar. I think that should be fine. 2 weeks is the 13th. I'm actually on the docket already.
And time waiver until then?
Yeah, I've executed that, Your Honor.
And he can sign a $2,000 signature bond. Order to New Life Recovery. I've given them your phone number, so they should be contacting you. And I guess we have, can you get their number also? So I'll put the notice on him also to contact them.
I also gave her Eric Holmes' number to New Life.
Okay.
So when she picks him up, he can call.
If you could send that to me too, I'd appreciate it.
Yes.
Thank you.
Okay, anything else we need to do?
Nothing for the defense.
I'll see you in 2 weeks, Mr. Tilley, and if you're compliant and inpatient, then you won't have to show up. But if you're outpatient, I want you to show up for that hearing on October 13th at the court in Chesapeake, which obviously Ms. Osborne knows where that is because she's here today. Okay.
And I take the court's file.
Yes.
Thank you.
State of Ohio versus Flint E. Topping, case number CRA 23564. Delilah Well is on deck.
Flint topping is Mr. Smith's case. I had him down for a preliminary hearing today.
Judge, he was indicted. We had an arraignment in front of Judge Ballard this past Wednesday. He's got a pretrial set this coming Wednesday. I'm going up to the jail to speak with him about that case, so I think...
So this can be nollied?
We can nollied.
Yes.
This case will be nollied because there's already been an indictment issued.
I'm going to come see you, Flint. We'll talk.
Hey, it's already been, I've already been indicted.
Yeah, that's what we were just talking about. Yeah, it's getting dropped here. I'm going to come to the jail and talk to you. We'll talk in private.
You're going to the common police court, or already has been there?
He's there. Yeah, Judge Ballard arraigned him on Wednesday.
State of Ohio versus Delilah Well, case number CRA 23578, A, B, C, and D, and CRB 23579. Edward K. Russell is on deck.
Delilah Well is also Mr. Smith's case.
It is, Judge. I talked to Mr. Hill this morning, and in exchange for a reduction of the bond from $25,000 to $10,000 cash surety, my client is willing to waive the preliminary hearing. There was a domestic also charged in this matter, and I understand the alleged victim does not want a protection order. And
we'll nollie that along with the waiver on the other felony charges.
Okay, so you're waiving preliminary hearing?
Yes, sir. And
reduction in bond?
yes, the $10,000. I spoke to her dad. What's he here? He's talking to Gary S. Howards right now, so that will be posted today.
Okay, I'm reducing the bond to $10,000 cash and surety. Based on that, Ms. Well is waiving the right to a preliminary hearing.
Yes, sir.
Do you understand that, Ms. Well?
Yeah.
You've talked to your lawyer?
Yeah. We spoke Monday and again this morning.
All right. So that's 23,578, A, B, C, and D. She's waiving preliminary hearing on it. It will go to the grand jury on the felonies. CRB 23,579 is nollied, so they'll be nollied to the grand jury. It's going to the grand jury also, but there's no preliminary hearing on it since it's a misdemeanor. Okay, there will need to be waivers granted and go to jail for her to sign, and her lawyer to sign, waivers of preliminary hearing.
State of Ohio versus Edward K. Russell, case number TRD 2385 and TRD 2889.
Edward Russell. Sir, are you Edward Russell? I'm sorry, I couldn't hear what you said. Are you Edward Russell?
Yes, I am.
Okay. Mr. Russell, Mr. Russell, you have been named in a charge from January 27th of 23 on a driving under a suspended license. That is a unclassified misdemeanor, maximum penalty 500 hours of community service, $1,000 fine is the maximum penalty. So as you didn't appear when you were ordered to on February the 14th of this year at 4 p.m. There's also another old charge, 2889, was a conviction for driving under an OVI suspension, and so as you did not appear for a review hearing on that, September 30th of 2021, and got a warrant. So you've got these two charges still pending. Do you understand the charges against you?
The driving suspension I do, but I don't quite remember the drive.
Well, it was driving under an OVI suspension, not an OVI. You got convicted, according to the record I'm seeing, September 14th, 2020, of driving while you were under an OVI suspension. So, do you have any other questions?
No, I do not.
How do you plead to the charge you failed to appear for the hearings on these two cases?
Plead guilty.
And how do you plead to the last driving under suspension, you never entered a plea because you didn't show up for the hearing? That was the February, well, it happened January 27th, 2023. So as you were driving with a suspended license, how do you plead to that allegation?
Guilty.
Okay, I'll accept your guilty plea. You understand that means you're admitting the charge is true?
Yes.
And the officers was Trooper Branham from the Ohio State Highway Patrol says, I was sitting stationary at US 52 near milepost 21, and I observed the defendant pass my patrol car without working headlights. I stopped the defendant, and he told me he was under suspension. And it looks like the suspension was some sort of driving under the influence in West Virginia, Cabell County Magistrates Court from February of 2020.
Yes, so I had gotten an OPI in West Virginia when I was going through and I got that and it caused me to require an SR-22 bond on my insurance to drive. I had thought that I had appeared before the original guy, I'd offered to take it. Besides that, the reason why I got the driving suspension this time is my SR-22 lapsed because I lost my job. and I was driving some food.
Okay. Yeah, actually, the previous one in 28889, case number was driving under an ODI suspension. That was a different date, though, I think, let me check.
Right.
May 27th of 2020, and then this last one was January 27th of 2023. It was this year.
Right, so I think the one with 2020 actually appeared pretty bad.
You did.
Here in jail.
But you did come to your review hearing.
I didn't know that was the reason. I apologize.
Okay, actually, it looks to me like, from looking at the printout, your suspension from West Virginia was from February of 2020 to September of 2020. So, but it looks like you also had a non-compliance suspension. So what I'm going to do, they didn't file it as an OVI suspension. They did, so they were correct. They didn't charge you this last time with driving under an OVI suspension. They charged you with just driving under suspension. So that makes a big difference because I'd have to give you jail time if it was under an OVI suspension. There's mandatory jail time on that. You never did your community service that you were ordered to do previously.
Thanks, Jasmine. I thought that
I don't know anything about that. There's nothing in your order about common pleas. You still have cases in common pleas court? Are you on probation or anything with common pleas?
Yes, I am. Yes, I am.
Okay. Do they have a holder on you also?
I'm not sure if they have a holder on this.
When did you come into the jail?
I turned myself in Wednesday.
At the jail?
Wednesday. No, at my probation officer.
With Mr. Sexton?
Yes, I did.
Okay. All right, well, here's what I'm going to do then. You've got cases here. I'll sentence you to time served for contempt of not coming to your hearing on the 2389. And then on 23085, I'll give you a $200 fine. Because you didn't come, it's higher than it would have been if you would have come to court. So you got to get some extra penalty for not coming to court when you were supposed to. Court costs, and this is actually a non-jailable offense. I'll give you 30 hours of community service, and that's higher than it would have been if you would have come to court back when you were supposed to. 30 hours of community service. Set review hearing on that for November 3rd.
This year.
Yeah, coming up. That's the first Friday in November. And on your old case, I'll set it for a review hearing November 3rd. So,
do you want that probation on PUS or
yeah, you can put
level 4 or 5?
level 4. Level 4 probation for 2 years. November 3rd is your next hearing at the court in Chesapeake. Then you got to deal with common pleas, whatever they want you to do. Any questions?
So there's currently no holder for you?
No, I'm lifting my warrant on you until November 3rd. Now, if you don't show up November 3rd, we'll do this all over again. You'll get another warrant.
Right, exactly.
Okay, that's all.
State of Ohio recalls Corey Little, case number CRB 23218, A and B, CRA 23216, CRB 22491, And CRA 22405.
This is Mr. Steyer's case. We let Mr. Steyer have the time to speak with Mr. Little. Have we got anything established?
Yes, I spoke to Mr. Little. We don't have a good well, we have an explanation for why he missed the day he missed. We don't have a really good explanation for why he hasn't appeared since. However, I've spoken to an individual he referred me to who would be willing to post a cash or surety bond for him. So what I'm going to ask is that we set this matter for for a pre-trial. I think it was set for trial previously, but it's been several months. I'm going to need to refamiliarize myself with the case. I assume the state will need to do the same thing and regroup and decide if we want to set it again for trial or if we want to just figure something else out, and ask for a cash or surety bond to be set at this time. I'm going to ask for $1,500. The individual I spoke to is his employer. He's already spoken to Gary Sowers. I think that's how he would probably go about posting the bond. But I think any amount that we give Mr. Sowers, he would ensure Mr. Little's appearance.
Well, somehow we let him off the hook last time, because it looks like he posted a $20,000 bond April the 7th of this year.
Well, I would imagine that bond, is that a cash or bond or a surety bond?
Surety bond.
Well, that I would assume is still in.
It's never been canceled.
Well, then I would just ask if that be reinstated at this time.
I think we need to check with Mr. Sowers and see, and probably I wouldn't be willing to let him out unless he's on an ankle monitor, because he's a runner.
He's got at least one felony pending, is that right? And was he supposed to be in treatment?
Mr. Sowers texted you about wanting released.
He wanted released.
He was going to be here to request to be released from the bond.
He did ask to be released from the bond.
No, still.
So let's back up. I'm only going to release him if he's willing to go into treatment. I mean, I'll set a bond, but it's going to be high.
I would
ask. If he's not going to agree to go to treatment, then he's going to get a high bond.
Well, I would ask that he be assessed again, because it's been a period of time since the assessment, and then we go with the assessment.
I'll order the jail to do a screen on him. The last time he did a screen here, he tested positive for amphetamines, cocaine, ecstasy, methamphetamine, and marijuana. And then in April, that was in May, April, it was methamphetamine and marijuana. So let's do some additional work on this. I'm okay with him going to treatment, but it's got to be with an ankle monitor.
Do you have a medical card? Okay, if he doesn't have one, I would assume that any of the treatment centers would be able to work with him to get one, though. Is there anyone who'd be willing to take Mr. Little?
I'll take him after we've dealt with him.
Sir, you're going to need to be assessed by Bethesda, and your release is going to depend on whether Bethesda will take you for treatment or not. You understand that?
All right, yes, I guess. There's a lot of backbeat to this, that's what I can't understand.
Okay, and also, if you get out with an ankle monitor and you cut the ankle monitor, that's a guaranteed trip to prison.
Yes, sir.
Okay. We had someone do that recently.
So I would ask to have this case recalled after he's been assessed by Bethesda.
Can we get that done?
I'll get that now.
Okay, thank you. It'll be recalled. Yeah, I wanted to do a urine screen at the jail.
Can they hear you to tell them to know you said that?
They usually are listening.
Okay, perfect.
I think he's got others.
State of Ohio recalls Jamison Watts, case number CRB 23532, A and B.
All right, Jamison Watts is Mr. Morford's case. You had a chance to talk to him?
I have, Judge.
And?
He thought that he was supposed to appear in court on September 26th. Since he's last been here, he's had a couple of events that have disrupted his life. Apparently he had some friends stay with him and his wife, who is blind. Those so-called friends took their Chime bank cards, wiped those out, and he had some things stolen and just got distracted, I guess, Judge, would be the best way to put it.
Okay.
Yeah, no, they shot his house up. Not only took his money, but left a parting gift of a bullet-riddled house.
How's the state want to proceed with this? You probably don't have your file. He was
I don't.
supposed to be here September 22nd for a pretrial. He failed to appear. He came in today.
What are the charges, Your Honor?
He has trespass at Walmart, which tends to tell me he had a prior conviction. He's got a theft charge at Walmart. There's actually 2 criminal trespass charges. No, just one. There's 1 criminal trespass charge and 1 theft charge.
Well, if he were to want to resolve these things today, our recommendation would be a suspended jail sentence and community service in an amount that would be justified by the fact that he has not only the theft charge, but the criminal trespass charge, and a further order to stay out of Walmart, and a fine and probation. That would be our recommendation if he wanted to conclude the case today.
Probably have the video of it, but you need to come to my office and look at it. I need something just other than what you're saying. That you pay to have a chance to be.
I guess I'll do that. How long is that?
Do you want to do this?
You need to take some time to talk with him.
Do you want to do this? Or do you want to fight? Let's recall, Judge.
Case
I
will
don't
be
want to.
recalled later in the docket.
I'll come and talk to you.
State of Ohio versus Jesse T. Conley, case number CRN 23410, PRC 23909A and B, CRP 23411. Jesse Conley.
This is Mr. Steyer's case.
Your Honor, Mr. Conley was scheduled to appear on, I believe, the 22nd of September. Failed to appear. He contacted me. I advised him he needed to get in here as quickly as possible. He's arrived today. I'm going to ask that that his case be set back onto the docket on a date convenient to the court. I don't have his file with me today. I don't believe the state does either.
What's the state's position on this? I mean, this has been going on for a while now, since July, and it is a possession case. I don't see any, he did have a clean screen on July 28th, but I don't see, there's no notes or anything of treatment. And there's an ODI from July 3rd for this year.
Is that still pending, Your Honor?
Yes. And it's a refusal, it's not a drug screen.
I can screen today, too.
I don't have my file with me today, Your Honor. I apologize for that. Mr. Conley indicates that if he was screened today, he would be clean. I would ask that maybe we do that, and on the basis of his screen, decide which way to go in terms of getting back here. And once we get back here, figure out where we are.
Okay? Go do a screen. Come back.
Is there somebody to help him with that?
Go to the probation office.
Okay, just go on to the probation office and tell them you need to screen. Thank you.
State of Ohio versus Jason Sweeting, case number TRC 231411A and B. Jason Sweeting.
an arraignment. And sir, you're Jason Sweeney?
Yes.
Am I pronouncing your name correctly?
Sweeting, yeah.
Sweet, there's a T in it, isn't there?
Yeah.
All right, this is a allegation of operating a vehicle under the influence of alcohol with a refusal. It's alleged this occurred in Fayette Township. That's a first-degree misdemeanor, maximum penalty is 6 months in jail, $1,075 fine, 3-year suspension. And the second charge appears to be driving the wrong way on the divided highway. That's a minor misdemeanor, maximum penalty is $150 fine. Do you understand these charges?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead?
Guilty.
Guilty means you're admitting the charge is true, and by doing that, you waive the right to have a trial and have a lawyer. Do you understand that?
I do.
And that's what you want to do?
Yes, sir.
Okay, I've got a report from, this is a Lawrence County Sheriff's Office arrest, and Sergeant Sisler wrote a report to the court dated September 28th of this year. He says, on the stated date, I was traveling eastbound US 52 at the 19-mile marker. A tan SUV came across the grass median from the westbound lane, almost hitting 2 vehicles. I turned on my overhead lights and stopped the vehicle in the left lane. I radioed out. The vehicle had a Kentucky registration, he gives the number, and approached from the passenger side, spoke to the driver, who was identified as Jason Sweeting, who I asked for ID, registration, proof of insurance. He handed me his wallet with his ID, and I removed it from the wallet, gave him his wallet back. I asked for his registration, and he opened the glove box and handed it to me. While speaking to him, I could smell a strong odor of alcohol coming from inside the vehicle. I asked him if he'd been drinking. He advised that he hadn't been. I asked him how much he had, and he advised probably too much, but I'll go with the standard 2 beers. I asked him again for his proof of insurance. He said he couldn't find it, said he did have insurance. I asked him to get out of the car, which he did. I asked him to come back to my car if he could see without his glasses on. He advised he could not. I asked him to take his glasses off and if he could see my finger. He took off his glasses, laid them on my hood. He was unstable on his feet and kept falling back into the cruiser. I asked him to step away from the vehicle, and he asked if he could just lean on it, and I told him no. I asked him if he had to do a few tests first. I told him he could refuse to take the test, but then he would lose his license for a year if he did that. He advised he understood but wished to refuse field sobriety tests. I advised him his Miranda rights, placed him under arrest. Deputy Chin arrived with shackles so he could be secured. He was taken to the patrol car, transported to jail, was offered a urine screen. I asked him if it was okay if Deputy Atkins moved the vehicle to the other side of the highway. He advised he could just ask that we lock the car, took photos of the alcohol that was in the car, had Deputy Atkins move the car. He was then transported to Lawrence County Jail, offered a urine test. After reading the BMV 2255 form, he refused to take the urine test. He was given a citation and released to his aunt from the jail. All right, Mr. Hill, did you take any position on the sentencing?
Your Honor, reading this, I don't want to read too much into the situation, but it sounds like a pretty dangerous situation that could have caused a severe accident if things had gone any worse. I guess my question would be whether this is a situation in which Mr. Sweeting should be referred for some counseling, some alcohol, substance abuse counseling. as part of the disposition.
And Mr. Sweeting, anything you wish to say?
It's never gonna happen again. I'm stupid. I went to go get medication and had a little too much to drink beforehand, but I'll do any type of treatment or anything.
Now, it says he wrote on the ticket that you, even though in the narrative that you told him that you did have proof of insurance, he wrote on the ticket that you did not furnish proof of insurance. Do you have?
It's on my phone that broke. It's digital that they sent us.
Okay. Well,
Yeah, that it's insured.
You need to bring that in, and you have a Kentucky driver's license?
Yes.
Because I can't give you any kind of driving privileges unless you show me you got proof of insurance.
I can go get my mom's phone. She's in the parking lot.
Okay, well, you can show it to the probation officer.
Okay.
Proof of insurance, because he was the one that would issue the permit. Okay, what I typically do on a refusal to take the test is impose a $1,000 fine, so that's what I'm going to do. $1,000 fine because you refuse to take the test.
Okay.
First offense.
Will I have time to pay it?
Yes.
Okay.
I'll order you to pay the court costs. You'll get a 6-month license suspension. That will be effective the date of the incident, so starting September 28th. 20 days in jail, and I'll suspend all of your jail days on the contingency that you do 5 days of community service and go to, there's a 3-day, what's called driver intervention program, and if they recommend additional treatment, I'll make that a part of your probation that you have to do that. The closest driver intervention program now is inside of the county, so that's Portsmouth. Your probation officer will give you the contact information for them. I'll set a review hearing for him for March the 29th of next year. So you have to finish everything before March 29th or come back for a review hearing. If you have stuff left to do, you got to show up. If you don't show up, you automatically get a warrant. If you finish everything before then, you don't have to come back. You get your 3-day school done, and either they say you don't need additional counseling, or you finish additional counseling that they set up for you, then you don't have to come back in for that hearing.
Okay.
Any explanation for driving across the median?
I was turning around.
Okay, you were going to make a U-turn through the median?
It's grass.
I'm assuming you did not see the state trooper sitting there?
No.
Or driving there, so. Okay, $100 fine on that. You're to go to the probation office, meet with Mr. Major, and then after that, you're free to go. Any questions?
That's it. Thank you so much.
You're welcome.
State of Ohio recalls Hannah Gooden, case number TRC 222509, A, B, C, and D. Hannah Gooden.
Good morning, Your Honor.
All right, Ms. Gooden is here. She had a review hearing this morning. She's saying she had a problem with her vehicles while she's late. She's here now. And you were at OVP, still going there?
Yes, I have a review letter. I was trying to get it emailed over to you guys, but I have it on my phone.
Okay, I'll take a look at it.
Okay, let's see.
Your Honor, if I may, she was ordered on 8/4 to do some community service for her.
Yes, I do have to complete the community service. We only have one vehicle right now, and his dad works full-time, so it's been very, very hard for us to, I watch my child 24/7. It's just been very hard.
And I think Brianna gave me a report also. Okay, I want you to email that to your probation officer. I want you to meet
Okay.
Mr. Major, get that emailed in.
Okay.
And so we can put it in your file. You've got 5 days community service, you gotta get that done.
I will get that done by the next time you see me. Yeah, I paid off all my court costs last time I was in.
I see that. I'll set it for November 6th, will be your next hearing,
Okay.
9 o'clock.
All right.
Cancel the warrant.
I got mixed up this morning where I came in for the continuance so many times at 10 a.m. and it was 9 a.m. and then I realized what time I left, then we ended up having a flat tire. It was just a rough morning.
Okay.
What day did you say, November?
6th,
Okay, November.
check in with Mr. Major before you leave.
At 9 a.m. Thank you very much, Your Honor, and I apologize for the inconvenience.
Thank you. Okay, we're finally starting some pre-trials.
State of Ohio versus James C. Jones, case number TRC 23-536.
Mr. Kermeen's case.
Your Honor, I filed a suppression motion on this matter. If we could set this for evidence. I don't know the court schedule, but I have availability on October the 20th and October the 27th.
Well, I will not be here October 20th, so I gladly set it then, or I can set it another day.
How about the 27th, Your Honor?
See what that looks like. Okay, set October 27th at noon.
Be here.
On the motion.
Thank you, Your Honor.
You're welcome.
No?
Yes.
Can I talk to you?
Yes. Just wait for me.
State of Ohio versus Liam Maynard, case number TRC 23671, A and B.
This is Mr. Kermeen's case, that's the pre-trial.
Your Honor, I've discussed this matter with Mr. Heald, and I think we're going to need to set a suppression on this matter as well. I plan on filing the motion on Monday.
Okay, so we're going to pre-trial the motion first, then, or
However the court would like to do it, it's fine with me.
have you pre-tried it yet, or?
Not on the motion, Your Honor, so.
Okay. All right, when are you back sometime before October 27th then, or?
I am here. Here, October 16th.
Okay, October 16th for pre-trial. Pre-trial on the motion.
Yes. Thank you, Your Honor.
You are 10 o'clock.
State of Ohio versus Sean Woods, case number TRC 23811, A, B, C, and D.
Kermeen's case for pre-trial.
Your Honor, I've received discovery and I've gotten through most of the video. Need to have an opportunity to sit down with Mr. Woods to determine the direction that we're going to take in this case. If we could also maybe set that on the 16th.
Okay, it's getting to be a pretty heavy docket, but we'll do it. October 16th for pre-trial, 10 o'clock.
Actually, Your Honor, he has indicated he's not going to be available that day.
How about the 13th? He's available.
If it matters, I'm not going to be here that day.
The 13th.
I was going to say, I'm here already on the 27th, Your Honor, if that would work.
All right, October 27th with a time waiver.
Thank you, Your Honor.
State of Ohio versus Russell A. Daniels, case number TRC 23501.
All right, this is Mr. McCown's case, set for a pre-trial.
Good morning, Your Honor. May we approach?
Yes. 2 weeks. That whole week is that 13th. That's Tuesday. Yeah. Yeah. All right, October the 10th, Mr. McCann, Mr. Daniels want more time to discuss the case, so I'll continue to then for another pre-trial. 10 o'clock.
Thank you, Your Honor.
You are.
State of Ohio versus Jessica Albright, case number CRB 23-328.
This is Mr. Smith's case, set for pre-trial.
Yes, Judge.
My notes were, this was a case that the state would consider dismissing if there was counseling or further problems.
Judge, yes, and I have a letter on her phone from Serene Insights where she is treating, says that they are working with her on her anger management issues. She's actively engaged in sessions, has completed her mandated portion of anger management mental health component of treatment. She can now identify her anger and anxiety triggers. And it looks to me like she's graduated, but there is still, Gertrude still remaining in therapy. Yeah, that's the way I'm reading it. It's completely that they're encouraging her to stay in and monitor her mental health situation. We're ready to dismiss it yet, or?
You have something, so she's
Yeah,
completed?
she's completed, but they're encouraging her to stay. The way I read it, she's done it. They're encouraging her to keep going, but it's not mandatory.
Here, Roger. Okay. Is that our case already? Your Honor, I've read what's on her screen there, and it's a report from a counseling agency in Wadsworth. Is that where it's, at least that's what the address said. Not a local facility, but they said that she made progress.
Yeah,
and
Wadsworth. It's about 3 hours from here.
were you going there, or was
The
it?
video sessions.
Okay. Our latest report from our victim and his family was that the victim, Jason Huffman, who's not here, is still with her, and that she's doing well. And that report seemed to indicate that this may be a long-term thing for her, but she's been compliant. So this may be a situation where it's appropriate to go ahead and dismiss the charge today.
Is that with or without cause? I don't have a note on it.
I don't either. I can't remember what we discussed.
Well, we don't have anything in here about costs. Normally we would, but since I didn't make a note of it.
Be an outright dismissal. All right, ma'am, your case is dismissed.
Thank you.
You're welcome.
Oh, great. Well, what I'll do is
State of Ohio versus Jonathan Clay, Case number CRS 23552, TRC 231312, A and B.
Right, John Clay is hearing by teleconference, and his attorney is Mr. Smith.
That's correct, Judge.
This is an F3 possession and an OBI, are the two main charges.
Your Honor, this is a situation probably we're just going to need to nolly this to the grand jury.
Mr. Clay, did you post a bond? I don't see one in my file. Did you post a bond? An OR bond. That's okay. The judge answered my question. I was curious if you had posted a cash surety bond, but it appears you just signed a signature bond.
So does the state want to nolly everything to the grand jury then?
Yes, Your Honor.
Okay, the entire case, both case numbers are nolly to the grand jury.
Thank you, Judge.
So, Mr. Clay, you need to appear in common pleas on your own if you get indicted. It's likely that you will be indicted by the grand jury, but I can't tell you when that would be. It might be 2 or 3 months from now when you get indicted. And well, first of all, let's make sure we get the right address for you. I've got 221 Westview Drive, South Point. Is that correct? You will get a notice if it's sent there? That's correct?
Yes, sir.
Because what will happen is that they'll send, I'm assuming they first send the summons.
They normally do, Judge, and if it's undeliverable, then they request a warrant.
So the best thing for you is that you show up on your own, and then you don't have to post another bond or take the risk of going to jail. But sometimes those summonses don't get answered, or they go to the wrong address. That's why I was asking about to make sure you get the right address. And if you have, obviously, you know something about a computer because you're on one now. There's a website for the clerk's office in common pleas. If it was me, I would keep monitoring that to see when I've been indicted and when I'm supposed to show up and make sure I show up. Because if you show up on your own, they pretty much have to give you a signature bond. If they have to drag you into court, you're probably not going to get a signature bond. You're probably going to have to post a bond or sit in jail till your trial. So I've had a lot of people go from this court down to the other court, and for whatever reason, they don't get notice or they move or whatever, and they wind up getting arrested on the felony even when they showed up here on their own. So take it upon yourself to make sure that you get yourself to court after this case gets indicted. Okay, just a little free advice.
And Mr. Clay, if your phone numbers, I have 2 of them, if they would change, make sure you let my office know. But if it's assigned to Judge Ballard, I will get your case back in common pleas. If it's assigned to Judge Finley, I might not get it back. It just depends on who she appoints. But it's real important to keep your phone number up there at my office, okay?
How often did you think that you call the clerk to check on the indictments? Like once a week?
Once a week would be a good idea.
I do it every Friday if it were me, maybe twice a week, no less than once a week.
Okay, so your case here is dismissed, but it's going to come back after you get indicted. I just don't know when that'll happen.
Okay. Thank you, guys. I'm sorry, I had time to read my wife tested positive for cancer driving in every day.
I asked you not be, so you're probably okay.
State of Ohio versus Christopher Workman, case number CRB 22614. Christopher Workman. Christopher Workman.
People that have cases need to be in the courtroom. This is Mr. Smith's case for pre-trial.
Just get it behind us, I go to work.
Judge, I spoke with Mr. Hill this morning, just spoke with him again. It's my client's intention to change his plea to guilty, and I understand in exchange for the plea of guilty, the state will recommend a 10-day jail sentence, all suspended, and a no-contact order with the alleged victim.
Mr. Hill?
And Your Honor, we've consulted with the victim in this matter. He was agreeable to that as being recommended, a suspended jail sentence, and a no-contact order, which we actually have it prepared for everyone to sign.
All right, is that correct, Mr. Workman?
Yes, sir.
Anything you want to tell me before I sentence you?
I just apologize to the court. It's a family matter, and I feel bad about it, and that's the honest truth.
Is this George Yates related?
Stepdad since I was about 8 years old, sir. Yes, sir.
Okay. I'll impose a $200 fine, order you to pay court costs, 10 days in jail suspended. You're ordered not to go around or contact George Yates.
Yes, sir.
2 years of level 5 probation with a review hearing March 29th of next year at 9 a.m. He is to check in with Mr. Major, then he's free to go after that. That's the probation office.
Thank you, Judge.
You are.
To the left. Send your file around.
State of Ohio versus Mary Hampton, case number CRB 23321, CRA 23320. Mary Hampton.
Your Honor, Ms. Hampton contacted me this morning and indicated that she and her daughter have the flu, and she has provided me with a photograph of a letter on letterhead from Family Urgent Care. It looks like Cabell Huntington Hospital Family Urgent Care, stating that she is under care and is cleared to return to work, which I guess is kind of the same issue, no longer, what's the word I'm looking for, contagious, on 10/2. I would ask to continue this to next Friday if we could. Order a date convenient to the court.
She's supposed to be with QRT. Is she been compliant?
She is with QRT. I'm still not getting reports. She's with OVP. That's still an issue. She has not kept in contact with me. It's not time for her meeting yet, but I expressed to her this morning, I just kind of wish she would have contacted me before this morning. I can't say she's non-compliant. It's not time for her meeting yet, but I do not have reports from treatment.
And the letter I have is dated, it doesn't bear today's date, it is on letterhead, and it says she's clear until she's been returned to work on 10/2. I'm asking for Friday or a different date that's convenient to the court.
Next Friday you're talking about?
Next Friday, yeah. I'm just asking for a 1-week continuance.
All right, at the defendant's request, case continued October 6th.
And obviously we would waive time constraints to accomplish that.
Yes. Thank you.
Thank you.
Thank you, Your Honor.
State of Ohio recalls Corey Little at the Lawrence County Jail. Case number CRB 23218, A and B, CRA 23216, and others.
Okay, we need Corey Little at the jail. All right, so we do have Mr. Little back after he's been assessed.
He's going inpatient.
Recommended inpatient. Is he agreeable with that?
He had indicated to me, that he was agreeable if that was the court's order, Your Honor.
And the court's order, and I also will order an ankle monitor.
Just for the sake of the record, I'm gonna, and to make sure he understands this, it being noon on a Friday, odds are pretty good he won't be fitted for an ankle monitor until Monday, but that is what it is. Obviously, if they can get him out quicker, if they get him fitted quicker, he can get out quicker, but that's a mean feat to pull off on a Friday. I would ask that his bond then be reinstated with that ankle monitor, and then we'd be set a new date back.
Okay. Have you seen the screen?
I did see the screen.
Is that?
Cocaine.
Cocaine.
Okay.
Your Honor, and something else too, and that is that we've received reports today of new charges involving drug possession. Chesapeake Police, they submitted the reports and they hadn't been notarized. So we've got to wait till they get notarized before we can file them, which will probably be Monday. But
And I think there's someone behind you, Mr. Steyer, that's asking for the bond not to be continued. Is that correct?
Well, Your Honor, Dorothy had called me about it. I think somehow my bond got issued to a wrong case, and I think the bond you've got is an older bond. I don't think it's the same case that you're currently, the way I understood Dorothy. So I think
It's April, when was this filed? It's April of this year. This is March 31st, so I think it probably was. What happened was he took off and somehow we didn't do a bond forfeiture initially.
Yeah, I had arrested him for jumping bail, and then he's gotten a new bond. He's got several charges. He's no stranger to the court, obviously, but so I haven't talked to the co-signer that originally posted that bond with me to see if they're okay with continuing or if they want it to be over. So my first knee-jerk reaction was to ask to be released. With an ankle monitor, it makes me a little more comfortable, you know, so if there's going to be the ankle monitor, I'll just leave it up to the court, whatever.
Okay, well, I prefer you stay on because that gives me another layer of protection that if he does run, you're going to go through it. So I'm going to, and it looks like you got a free one the last time because I don't think we did a bond forfeiture when he left. He was ordered to treatment, looks like in probably end of May or 1st of June, and then he ran or didn't.
He just walked out and disappeared.
Disappeared. He's been all summer out of the loop, but we never did a bond forfeiture on him for some reason. It just fell through the cracks. So, Mr. Little, I can see the top of your head, but I can't see the rest of you. I assume you're there. So I'm ordering that you get an ankle monitor, and I talked about this before, and you said, yeah, but I want you to understand, this is really serious business, because I've been down this road with a few people. Nobody yet has said, oh, Judge, if you put an ankle monitor on me, I'm going to cut it off and run. Nobody has said that. Everybody says, yeah, I'm going to stay, I'm going to do what I'm supposed to. But a certain percentage of people that put ankle monitors on decide for whatever reason it's a good idea to cut them off. I had one guy that did it because he wanted to go to a party in Charleston, West Virginia. So he cut his ankle monitor off, went to that party. It must have been a heck of a party because he was out about 2 weeks, got picked up. He's now in prison for 3 years. And I had another one last week. Now, I think his name was
Cronin, yeah, here's mine.
He was with you too, and he ran, he had an ankle monitor, cut it off. When we get him back, it's out of my hands. He's going to go to the felony court, and they have already said, this is their policy, 3 years. You get 3 years for cutting an ankle monitor off. So, and I always tell people, if you think you can't help yourself, but you're going to cut the ankle monitor off regardless because you just can't stand it, you'd be better off just staying at the county jail and riding this thing out rather than agree to an ankle monitor and getting out and going to prison for 3 years, because you're not going to get 3 years in prison if you just stay and this case goes on to the grand jury. There's no way you'll get 3 years in prison. But you cut the ankle monitor off, you are going to prison for 3 years. Do you understand me? I'm not your mom. I'm not your 7th grade English teacher. I mean what I say. This isn't like your option. Like, well, they don't really mean that. I can get out of this. No, you're going to prison for 3 years if you cut the ankle monitor off. Do you understand me?
Yes, sir.
Okay. And you still want the ankle monitor?
Sir, I just want to be able to work, feed my family, and do my treatment.
Well, just so you understand, that's not where we are right now. Right now, we're going into inpatient treatment with an ankle monitor, and you'll have to eventually be able to go out and work. But if you decide, oh, I need to work right now, so you got your monitor, that's gonna cause the problems we're causing. So just, you're talking about working and feeding your family and all that, and I'm not saying those aren't laudable goals, that's not where we are yet.
Yeah, that's the long-term goal. You gotta get clean first. You haven't been clean for a while. You're gonna have an opportunity to get clean, but you gotta get on board with this. You can't say, oh, I gotta leave because I gotta feed my family, then go out, get a little job, probably roofing or something, and using drugs on the side. That's not gonna work. You understand me? You gotta make this your project. You gotta be on board with getting clean. If you're not, don't do this, because it's not gonna work and you're gonna wind up going to prison. So, I don't know. I don't see you saying, oh yeah, I wanna get clean, this is what I really wanna do. It sounds like you just wanna get out of jail. If your only motive is to get out of jail, not gonna work.
There's 9 different defects going through the headphones. Yes, absolutely.
Okay, you want to get clean, long-term, you're a young man, so you're going to have a long time to work if you get clean. We get you clean, get you out there, working, supporting your family. I want that too, but it's not happening next week. You understand me? And it's not going to be on your timetable. You're not going to come in here. You got to go to this treatment facility, do what they tell you to do, and do it when they tell you to do it and how they tell you to do it. You're not going to go there, boss them around, buffalo the other people that are getting treatment, cause disruptions, because I've had people do that too. That's not going to work. You're going to wind up back in jail if you do that. You understand me? Corey Little is not in charge anymore. Do you get it? Okay. I'll release him with an ankle monitor. We probably should come back in 2 weeks for him.
2 weeks, Your Honor, is the 13th. I'm on the docket that day. As far as the other charge, I would just ask to have that set for arraignment on the 13th.
We've got a half dozen charges that I don't think have been disposed of. Tried to in the past. I've got violation of protection order, got at least 4 of those, and a domestic violence charge. I think they're all still pending. Now we got new possession charges that are coming on Monday. And so our feeling on this is, I've lost track.
Yeah, I've got a stack.
And so these got to be either resolved, or I'll take the new charges to the grand jury without even batting an eye. There's no sense in keep on piling on this stuff if this guy's not.
Well, I don't even know what the new charges are, whether they're felony possession charges or misdemeanor possession charges.
So what's that? I just like being communicated, Mr. Stark. You got a couple weeks to figure it out.
Right, and I'd just like to have it set for arraignment that day, and when I have my file with me and have all this and can speak to Mr. Little, we can figure out where we're going with this.
If he wants to stay here in this court, all that's got to be worked out, or the state can take it to the grand jury and he can.
Right.
At least I think if you stay here, if he does what he's supposed to, he's not going to prison.
Correct.
If he goes to common pleas, it's at least a 50-50 chance of going to prison.
Right.
Maybe more. Okay, October 13th will be the next hearing.
Thank you, Your Honor.
Thank you.
Okay, we'll do whatever the orders I need to do, and adult probation needs to be notified. Oh, and Mr. Little, since you're still there, Mr. Sowers is staying on your bond, so not only if you cut the ankle monitor, are you going to go to prison for 3 years, but he's going to have to track you down, so it's not going to be like the guy that went to Charleston, he only got a week or 2 out. You're not going to get very much time out, because he will come and find you and take you to jail, then you go to prison. So, get on board, do what you're supposed to do. By far the best solution for everything you're facing. Okay, that finishes us up at the jail.
State of Ohio versus Dylan Hernandez, case number CRB 23381. Dylan Hernandez. Did not check in.
This is Mr. Steyer's case. I made a note, no appearance required. If costs were paid, there would be a dismissal. But I don't see the costs have been paid.
Let me, I don't see costs are paid on the computer, Your Honor.
Okay. It'll be a warrant in 7 days if he hasn't paid the cost.
Thank you, Your Honor.
135.
State of Ohio versus Tanya Landhart, case number CRB 23447 A and B, 23963 A, B, and C. She did not check in, Your Honor.
And she's supposed to be with QRT, I don't know. Megan's left.
Is she gone or is she just out of the courtroom?
Do you have any notes on Tanya Jo Landhart?
She's been compliant with me, but I still do not have anything that she did an assessment with treatment.
When were you
I know
last,
she had an appointment.
when were you last in contact with her?
About a week, 2 weeks ago.
Okay.
She did send me, I asked for some other information from her, and she did send me the other information that I requested. But I have not talked to her in the past couple of weeks. I did text her, she said she was gonna get me something for treatment.
I have a letter from Bethesda dated September the 8th.
She was transferred out of, she was the one that was Jackson, Gallipolis, and we were finding somewhere closer.
She went to
for her.
Jackson, and she was scheduled to have an assessment with Field of Hope
Okay.
in Jackson.
Last thing I have is from Bethesda. How do you want to proceed, Mr. Steyer?
Your Honor, I would ask for a brief continuance to attempt to contact her and get her in here. I'm here next Friday. If that's getting too full, a date convenient to the court.
It's getting pretty full, but so are all the other days.
Well, I recognize that, but I just didn't know if it was a particularly bad day.
Except the 20th. October 6th.
Thank you, Your Honor.
And Mr. Holmes, did you get my text about the gentleman in the jail?
I did, Your Honor. We have an office in Gallipolis that he can attend. Our office from Jackson moved to Gallipolis just recently.
I'm not sure how far Jackson and Gallipolis are from one another. I just don't know the geography of that area. Is that
30 minutes.
Yeah.
is that any? That's closer than we are here to Jackson, then, right?
I would say.
Okay.
It's about an hour and 5 minutes.
Well, that'll have to do to get us going. I don't think
Somebody
you know
was
anything
going to
else in
talk to him,
Jackson.
or you're going to talk with him?
Yes, Your Honor, with your permission, the jail asked me to come back here and find out more details.
Okay. I don't have his file. I think we've already went out to the clerk's office. If you want to try to, you have his name and.
Yes, I spoke to Mr. Major. I think that I'm going to speak to his lawyer here.
Okay. All right, thank you.
State of Ohio versus Cody Lucas, case number CRB 23366. Cody Lucas. Cody Lucas.
Hang on.
Cody Lucas.
Did not check in.
Again, this is one I said, my notes was it would be dismissed if the costs were paid, no further problems, but the costs.
Okay. We have two different matters with Mr. Lucas. It appears we have an OVI and this domestic violence. The domestic violence was set on a 90-day continuance to be dismissed if costs were paid. My notes appear to indicate that Mr. Lucas failed to, they were set on different dates, and my notes indicate that Mr. Lucas failed to appear on August 18th, which I guess would be on the OVI, and now we have a failure to appear today on the other matter.
That OVI, just to make sure.
has a warrant.
He already has a warrant?
Yes.
Okay, now he's got two. At least you another warrant.
Yeah, he didn't pay anything.
Well, and he's got an OVI apparently, for that, so double warrants.
State of Ohio versus Williams Spalding, case number CRD 23512, CRD 23697.
All right, this is Mr. Shire's case set for pre-trial.
And Your Honor, I had previously been appointed to Mr. Spalding on the TRD case, which was a driving under suspension. Then after he left that day, we found that there was I believe it's a CRB case. I think it's a shoplifting from Walmart that's alleged.
Yes.
I don't believe has been arraigned on that. We would waive reading of that at this time, or perhaps.
Not guilty.
Okay, I think I just entered a not guilty plea on his behalf on a day he wasn't here because there hadn't been service. I need to probably discuss that matter with him and also catch up on the issue with the driver under suspension. He had court this week in Huntington. I was told it was on Monday. I went to the courthouse Monday before I came here, and there was no court. That was the municipal court. I don't practice there often enough to know what their schedule is. So I showed up, and there wasn't court. He contacted me later and told me, oh no, court's on a different day. I was unable to be there. So I don't know what the status of his case in Huntington is.
The fine will be paid within the next 3 weeks.
And so once that's paid,
they'll drop the charge.
Okay.
Suspension will be lifted.
So once he pays that fine in Huntington, that will lift the hold on his license in Ohio. Well,
So you can come back after that.
soon after that. So we need to come back after that. I'd ask to come back in about a month to give it about a week or so to, or you might think it's better to go a little further out. I don't know how long it takes for that sort of thing to process.
November 6th?
Let me make certain that that date's okay, but I don't think it's a problem. And nope, I'm not on the docket, but I'm available that day. So that day will work.
Defendant's requests, both cases are continued to November 6th for pre-trials.
And may I take the court's file on these?
Yes.
Thank you.
Thank you, Your Honor.
So wait around a minute, I'll talk to you.
State of Ohio versus Joseph D. Whaley, case number CRB 23419, CRB 17133, CRB 17170, CRB 23521A to Z.
Your Honor, it's my understanding that one of these matters, I didn't catch the numbers well enough to know which one it is. One of these matters is a new matter set for arraignment today.
I don't think so. Well.
That's what I was told by the
That was
state.
not served yet. That's 23-521, that's the note. Yes, it needs to be served.
And I have, Your Honor, a report from PATH regarding Mr. Whaley's progress. It is actually addressed to Judge Waldo because we had court with Judge Waldo yesterday. It's dated yesterday, addressed to Judge Waldo, but he's seeing PATH for both courts' purposes, so I'd like to send that forward if I could.
Okay.
And that's his copy. That's your copy to keep for the file.
On this new charge, 23-521A and B, do you wish me to read those into the record?
No, we would waive reading. I would ask to enter a plea of not guilty at this time. I haven't reviewed them myself yet, though, so I'll give you just a second to review these.
Do you want these back, these? Or-
You can keep those for the file, Your Honor.
Thank you.
Let me speak to Mr. Hill for just a second.
Well, we have domestic violence from August, and we were doing a 90-day continuance on that. Then we got the new charges. And
It's a different person.
it is a different person, and I don't care if you have time to look it over. I think that, all of this is set within the framework that is already. I think they should 6 months in jail that are suspended, not yes, we really want to get these treated. Now, the new charges, they're okay with the suspended jail sentence, and there's going to be restitution.
Well, I'm not ready to do that today.
That's
If he's paid the court costs, you will, are you ready to dismiss on that?
Yeah, has he paid?
But if you pay the court costs, it will DVD, because if you do that, it'll be dismissed. But then we'll have to deal with this.
On the DV?
Domestic violence suspended. If he's gonna be dismissed on payment of court costs.
No, I have not.
Okay.
I had to pay down
All right, that's fine. So let's take this out about the bond and I'm back on about the discussion.
How much is left on it?
I don't know what, it's about $135. Okay. Only pay before the next time. Absolutely. Have the money when you come back.
This is.
Have the money when you come back.
Okay, Your Honor, what we were just discussing, there's a domestic violence that is unrelated to this allegation that was set on a 90-day continuance to be dismissed on payment of court costs. That matter, we don't have the money for the court costs today. I think that money went toward issues in Ironton yesterday. He thinks he can get that together. What I'd like to do is to set this out about a month. We would waive time constraints to accomplish, because I know there's an M2 and an M4 here. We would waive time constraints to set it out for about a month. Let me do discovery, let me discuss the matter, figure out where we are on that, and kind of regroup at that point. And it's possible he may have the court costs on that other charge. He's also just been placed on probation by Ironton Municipal Court, which a term of which is continuing this treatment path. So that's going to be ongoing through Ironton, as well as, I would assume, a bond requirement here.
Okay, I'll let him, on the new case, he can sign an OR bond. That's 22,521. 2,000 OR. Set everything for a pretrial November 6th. I think you already.
Yeah, we just said something that day.
Continue with his counseling. November 6th, 10 o'clock.
Thank you.
You're welcome.
I'm going to bring this forward.
Filled in yet, but it's out. That's the overall law. I'm sorry, I'm looking at the possibility.
State of Ohio versus Charles H. Dennison, case number CRB 23566, A, B, C, and D.
Good afternoon, Your Honor.
Yeah. Set for a pretrial today.
It is our first pretrial, Your Honor. I've entered a notice of appearance and requested discovery.
Okay, was that filed today?
I'm sorry?
Was that filed today?
It was,
Your notice of
yes.
appearance? Okay. So I'm assuming you want to come back for another pretrial?
Please.
You have a date? We're looking, obviously, mid to late October at least.
Okay.
And these are M3s, Your Honor, so I believe that Mr. Nash, we spoke about a time waiver.
That's correct. And so the state will need some time to get some discovery to me. I'll need to meet with the defendant, go through that, and then just sometime after that.
Okay. The 23rd, 27th, 30th are all good dates.
How about the 27th?
27th of October will be the next hearing will be a pretrial,
Thank you.
10 o'clock.
Thank you, Judge.
You're welcome.
Okay, you got it.
State of Ohio versus Keith W. Cooper. Case number TRC 21288, TRC 21121, A and B. Keith Cooper.
Keith Cooper
Keith Cooper.
is represented by Mr. Morford. It's set for pretrial today.
Your Honor, if I may, I have a note that Mr. Cooper was ordered to be on 825 to have some community service done before his next hearing. and he got it up.
Keith Cooper.
He's not showing up today. You haven't heard anything from him?
I have not, Judge.
He's got 7 days to report. He does have a bond up. Check. Looks like he posted a bond back in January. Well, so there's a judgment entry saying he bonded with ours in February 2023. Yeah. Okay, I'll issue a warrant and a bond forfeiture hearing for October 16.
October
16 for bond.
16th.
For bond forfeiture.
Thank you, Judge. Is that Mr. Soward, Your Honor?
It is. Yeah, okay. There was a more recent bond this year in January, so I did find that.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Ronald Ferguson. Case number TRC 23923, A, B, and C.
Mr. Morford's case, pretrial.
Your Honor, Mr. Hill and I had some extended conversations about this case earlier. It's not your typical OBI, shall we say. I'd like to set it out a minimum of 2 weeks, maybe 3, so I can pass the motions. And in the meantime, the defendant has agreed to go obtain a mental health assessment. And I think that that will play a role, if he's convicted or pleads guilty, I think it will play a role in the court's consideration and sentencing.
Okay, how about the 23rd of October?
But that's good, thank you, Judge.
All right, next hearing is defendant's request is October 23rd for pretrial, 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Bruce Maynard, case number TRC 23-1013, A and B.
Mr. Morford's case, pre-trial.
Judge, this is I'm going to have to ask you to continue for a short period of time, if you would. We just got results of your analysis this morning. Have you seen them?
I have not.
Would you like to see them?
Yes.
My approach?
Yes.
That probably, Steve, you'll have the injections if I ask for a referral to for a call another drug assessment judge.
I think that would definitely be in order.
And also, I would like for the court to know he's a veteran.
Well, there's a lot of resources available to veterans now, including very nice inpatient facility, not very far from here. You know, it's Spring Valley, so it's practically brand new. Have you been engaging in any services with the VA?
Yes, I went through the program once, Your Honor, and I was doing very well, and I completed everything, and I relapsed here recently, but I was out there in the 45-day program, and it did help me for a couple of years.
When was that, sir? You recall?
I've been out of that facility for over about 2 years, something like that.
What's your phone number, Mr. Maynard? I can give it to the VA liaison, and they can contact you.
Kim has my phone number. I spoke with Kim. It's 740-451-0128.
451 what?
0128.
0128. Well, the person that I deal with, his name is Amanda Rayburn, so.
Amanda? Yes, I
just sent her a copy of your charges and your contact. Okay, I'd like to see you avail yourself of their services. I think that would be a good plan.
I would like to go into the 45-day program.
Okay. I'll give you some time to get that done. When do you want to come back? 2 weeks?
Yeah, then we could see if he's been there and maybe have a preliminary report from Ms. Rayburn as to a plan of treatment.
October 13th?
That's good, Judge.
10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you, Judge. You're good to go. Good luck.
State of Ohio versus Stephen Stanley, case number CRD 23148, CRD 22184 A and B, CRD 193337 A and B, TRC 191194 ABC and D, CRD 19320.
Are you from a treatment facility?
Yes, Sunrise Treatment Center.
You're not involved with his care, are you?
What is it?
You're not involved with his care now?
No, he was in our care until
Have a
he
seat,
came forward.
please. Have a seat.
Okay.
right, this is Mr. Morford's case, and it's set for pretrial. And he's at Bethesda, obviously.
He is. He's getting acclimated to treatment. I think we were in here the last time on. He is inpatient. With Judge Hall, and there was concerns about his medical needs being neglected. He had a neurology appointment on 9/25, a PCP appointment on 9/26, a mental health appointment on 9/26, a follow-up with a regular doctor on 10/10. He also has a cardiologist appointment this Friday. I just want to make sure that that is known, that we've addressed all of that.
All right, Mr. Morford.
Judge, I think that it's pretty apparent that we're nowhere near finished yet with this treatment at Bethesda, and I'd like to see him continue that and attend to his physical health needs.
Well, it sounds like he's getting lots of care, and you're transporting him to those appointments?
We are, Your Honor.
He still has an ankle monitor, right?
He does.
And he still has a bond, though.
He does, Your Honor.
Mr. Hill.
Well, Your Honor, we want him to continue to work towards successful completion of the program, and I was just speaking with your Destiny, right? And she's concerned here about what we're trying to accomplish, and I just reassured her that our goal is, as we have said since the beginning of this, which has been a long time now, 6 months or more, that we want him to be successful in treatment. And that's what we're continuing to work for. We have the case that, that keeps it in this court, and the idea is that we could go ahead and prosecute it and try to convict him if that's, but we'd rather have him be successful in treatment so that he has some lasting benefit from this. We don't want to leave it where things happen again in the future.
Well, and we kind of had to hit the reset button because he failed to appear before. And now that's why he's got the ankle monitor also.
Yes, Your Honor.
Okay, I don't see any reason to change things up. I think he's starting the right program. He's where he needs to be, getting the care he needs. So let's come back in another month. November 3rd.
Thank you, Your Honor.
Thank you, sir.
I'm here then, Judge, thank you.
November 3rd will be the next hearing.
State of Ohio versus Christy L. Jordan, case number CRA 23549.
Christy Jordan is appearing by teleconference. She's at Brighton Recovery, Florence, Kentucky, or what she should be.
I think she may be at a different facility I'm certain she's in a different facility in Kentucky. But she is in a facility in Kentucky. What's the facility you're in now? Oxford Recovery. There was an issue with her medication. You may recall there are some mental health medications involved in this case as well. There was an issue that led to her being placed in a crisis unit briefly, and then when they transitioned her out, they put her in a different facility. I think we may have discussed that by text message at one point several weeks ago. Has the court received a report from Oxford?
I have not. And she has something in common pleas as well, does she not?
I'm not the attorney on that. I don't know offhand.
Ironton Municipal.
Oh, and it's G Meadows,
I think so.
Right, and actually, I think that may be either complete or was nollied or waived to the grand jury, though. And I don't know if it's gone to the grand jury or is going to the grand jury.
I thought it was a felony, so it is.
My understanding is it was a felony, but it had not been kept in Ironton Municipal, but had been either waived or nollied to the grand jury. But I don't know that it has gone to the grand jury. Let me pull up the common pleas docket real quick and find out. We did have to talk to Judge
And Mr. Morford, I got a text back from Amanda Rayburn. Bruce Maynard does not qualify as a veteran for treatment there. They did see him at one point while they were determining eligibility. They determined he was ineligible. They saw him as humanitarian care, but now that he's determined ineligible, you'll have to see another facility in the community, not the VA. So I don't know what that's about. I'm assuming there's some qualification. I don't know if you got a dishonorable discharge or what the deal was, but they're not willing to see him.
Puts me back at square one. I guess, Judge, I will try to assist him in finding a provider.
Yes.
To get that between now and when we come back.
Thank you.
Yes, sir. Thank you, Judge.
Your Honor, I'm not finding that anything is on the active docket in Common Pleas Court, so I would assume it's not been filed. We need to get a report from Oxford to the court. Christy?
Yes, I'm with the airport right now, and she said that she will have it typed up and she will email it to you today.
Well, that leads us to the question then, Your Honor, do you want to come back onto this one today, or do you want to set it for another hearing date?
Just set it for another hearing.
Okay. And I would ask that she again be allowed to attend by video.
Okay, that'll be permitted. Let's go to October 13th, 2 weeks from today.
October 13th. So you're back here on video October 13th. Same blue jeans code that I already provided.
Well, it may change.
Oh, I didn't think it was going to change. I thought we were good that long at least.
Well, we're going to change to Zoom. I'm not sure when.
Well,
if it changes, we'll give you the.
If I don't tell you otherwise, use the same system. If not, we'll get a new system. I'll get you new information
It's very
together.
similar.
So this is
State of Ohio versus Devin Stapleton. Case number CRB 23494A and B, CRA 23491.
This is Mr. Steyer's case, preliminary hearing and pretrial.
Your Honor, my understanding of where we are with this is that Court Clinic has indicated that they will not provide an evaluation if they're on a referral from this court with a felony. So what we had asked for was a referral dealing only on the misdemeanor charges, and apparently a referral, again referring to the felony, was sent to Court Clinic. I've spoken to Ms. Bledsoe, and what we're going to do is after the the court's done with the file today, I'm going to go back and we're going to work together to try to figure out how to craft a referral that we think will actually get action taken by court clinic. I'm going to tell you, I've never been involved in crafting the actual referral before, so I'm kind of feeling my way through this as well, but I think that between myself and Ms. Bledsoe, we should be able to get this figured out in a way that we can send them something that they'll actually act upon. So, I'm sorry, go ahead.
Well, this was at the suggestion of Dorothy O'Neill at Court Clinic, who, I don't know what her position there is, but she has a position of authority. I explained the situation, that we had a felony, but at this point in time, we were interested in leaving that here, and she said, just make a referral that doesn't have the felony case number on it. So that's what we want to do. Now, we've also been working with the state level DD authority, and they also can do an evaluation, but only if it's issued out of common police court. So we're I think making the best moves that we can at this point. We're not able to arrange for Mr. Stapleton to be transported to a DD facility, Gal Police Developmental Center, or another one at this time.
So then, I'm not hearing things are okay now, they're stable, or not. Is there problems?
Do you know if there's been any problems?
As far as I know, I don't think that, he says he hasn't contacted her at all.
We haven't heard that there's been any contact, and I haven't called the victim's parents this week. So I don't know, but I'm hoping that there haven't been, and they haven't called us. And I invited them to call the authorities and have new charges filed if there were more calls or more contact. We haven't had any of those.
Okay. So the state's willing to keep it here and try to get the assessment done on the misdemeanor level?
I think that the totality of the facts of this lean more towards a misdemeanor type behavior. Plus, we have the other issues of competency and things of that nature that kind of overshadow this too.
So what I would propose, Your Honor, would be to come back here, stick with that date 2 weeks out. That should give time to get a little bit of something going. I will tell you that if they are willing to act on this, it's not going to be done in 2 weeks, but we should at least know whether they're agreeing to move forward or not.
Right.
And you can, regroup at that point and decide on that basis what we want to do. So I'm asking to come back on the 13th.
All right. Next hearing, October 13th at 10 o'clock.
Thank you.
State of Ohio versus Jessica L. Johnson. Case numbers CRB 22157 and CRA 22156, CRB 22545.
Smith's case.
Yes. Judge, he's handed me an envelope from Valley Health. It's sealed. I'm going to unseal it. Let the court take a look at it. I will need to, you need a copy of the original?
Yes, please.
Okay. I have to make copies.
I just need to make sure I have copies of these.
Whoever that is, quit talking.
Thank you.
Daniel Collier. Okay, I'm concerned, it says she no-showed in two appointment dates.
I know she had been out of town. She appeared by Blue
Yes.
Jays last time. What?
Yes, I had called the office and talked with her and let her know that I was out of town. We went ahead and scheduled those in case I was in town, but it wasn't a for sure thing if I would be there or not.
Okay, continue on and get more reports.
I think that's a good course of action, Judge.
Okay, you need to make this a priority.
I apologize, Your Honor. I know you said you just wanted an evaluation, so I went there and she did an evaluation and she just asked me if I thought, if I wanted to continue going, and I told her I wasn't sure. So that's why she made those dates, if I would be in town to go to them. She has.
That's not the way I read the letter. The letter read like you missed 2 dates that were scheduled, so.
I just knew I had to have the evaluation, so I did that right after court, about 2 days
Let me
later.
have that letter back.
I think Josh is making copies of it.
I was kind of surprised because it first said something about medically assisted treatment, which surprised me, but then it said you were not going to do medically assisted treatment. I don't know if that was a typo, but I need to see that reported.
She also said that they had faxed in the actual evaluation to you all as well.
I don't have anything.
I completed the intake, yeah. Yeah, I was out of town.
Well, what it says August 2nd, you did an intake assessment for
Yes,
MAT program.
I just did, she didn't know how.
Hold on.
I'm sorry.
Patient was deemed appropriate for therapy services only with no medication. So they're not saying you didn't need it. She was scheduled for follow-up August 9th, August 16th, and no-showed these appointments. She did provide a urine screen that was appropriate on August 2nd. So they did not say you didn't need treatment. They said you were appropriate for therapy sessions only, which tells me no medically assisted treatment, just therapy. So that's what you need to do.
Okay.
You're not in charge of this.
Okay, yes, sir.
Yeah, I'm not happy with you anyway. You left the area, chose a place of your own without court approval, and went there for treatment for a long period of time. So you got a felony.
Yes, sir.
If you want to get that dismissed, you've got to be compliant with what the court wants.
Yes, sir.
If you don't want to do that, tell me now. Let's just send it to the grand jury and let them decide if they want to indict you or not.
Yes,
It'll
sir.
be out of my hands. I won't have to deal with you anymore.
No. I'll go to therapy.
Okay, well, give me some reports that you're
Yes, sir.
there and doing what you're supposed to. Right now, you're not compliant.
Yes, sir. I'm sorry, I misunderstood.
Yeah, that's a big misunderstanding.
You want to come back sooner rather than later, Judge?
I do.
Okay. I have some.
23rd,
Of October. Actually, I can do the 20th or 27th of October.
27th.
Okay.
Okay. Give me a good report that you're
Yes,
doing
Your
what
Honor.
you're supposed to, October 27th.
State of Ohio versus Jeffrey Holly, case number CRA 23558.
Mr. Holly. Good. I'll take one of them in the meetings. Good. Good? Good.
This is Mr. Stratton's case, set for coming
Yeah, Your Honor. And one to the prosecutor.
Mr. Hawley here has been compliant. He has a positive drug screen on there, but it's, that's for whenever he came in on 9/11. I did talk with the nurses, and he has been negative this past couple of weeks.
Okay. Well, we're just getting started.
Yes.
So. Looks like it's a decent start, I would say.
Thank you, Your Honor.
And keep working, and we'll come back and monitor you. At some point, when I feel like you're not going to run off, bolt, I'll take the ankle monitor off.
All right.
I don't guess that, I don't know yet. I don't know when that'll be.
I had a question about the monitor. Could I get the schedule open so I could?
No.
I can't.
You get the schedule that Linda Reed sets up for you.
Okay.
You're just getting started. You've got a felony.
Right.
You want me to go back over what felony means?
No, I understand.
You know that means you can go to prison?
Yes, sir.
You know that means you got a heroin, charged with possession of heroin?
Yes, sir.
So, what did I tell the other guy? You're not in charge?
Yes, sir.
You're not in charge of when you get to go and do things. They're in charge. You gotta do what they tell you to do, when they tell you to do it. Do all that and show me that you can be compliant, and then I'll probably take the ankle monitor off. When I'm convinced, here's what I'm looking for. This has to become Jeff Hawley's project to get clean.
Yes, sir.
Not Donald Capper's project to get clean. Because you know, if it remains my project for you to get clean, guess what? It's never gonna work. Because at some point, you gotta do it for yourself, not for me. I can only monitor you so long.
Right.
You gotta make this what you wanna do for yourself. How old are you?
38.
Okay. You still got, hopefully, if you get off drugs, a long time to live. If you don't get off drugs, you don't have that long to live. I mean, let's be honest. You could have a long life, but you gotta get this right. At 38, you got kids?
Yes, sir.
How many?
3.
How old are they?
18, 14, 11.
Okay. Well, we can't fix what's happened in the past, but we can fix what's going to happen in the future, and you can still be a very positive influence in their life, but you can't be a positive influence in their life if you're using heroin. Do you agree with that? Can we agree on that?
Yes, sir.
So you got to get clean.
Yes.
Not only for yourself, but for your kids. Are you married?
Yes, sir.
I bet your wife would like to see you clean.
Yes, sir.
You got other family?
Yes, sir.
Siblings?
Yeah.
They want you clean?
Yes, sir.
Parents still living?
Yes, sir.
Neighbors, friends? I mean, this stuff just ripples way out. You know, you got young kids. What happens to you could have an impact. We're talking 50, 60, 70 years from now. If you get clean, that's going to affect, you don't know what the impact is on your kids down the road, and even your grandkids. I mean, this is super important. Are you treating it like it's super important?
Yes, sir.
Well, don't be worried about whether I'm going to get a pass. Be worried about whether I'm going to get clean. What am I going to have to do to stay clean?
Yes, sir.
And make this a part of my life. Okay. You got to start. But that's all it is just a start. You got a lot of work to do. And I want to see you investing in yourself and all those other people that go out from you. They're all affected by this too. So if you can't find it in yourself to do it for Jeff, do it for them.
Your Honor, we were arraigned on 9/11 on this case, and we had spoke about, I know that the prosecutor had mentioned that there was possible additional charges coming, and I had just spoke with the prosecutor again on that, probably not.
Okay.
Okay, that was Mr. Field just mentioned.
And I'm assuming that's probably conditioned upon him continuing to do well.
Yes, yeah, I'm assuming it is, but I just want to put that on the record that we're not anticipating anything else at this time, as long as he probably completes his treatment.
Yeah, we don't have anything else at this time, Your Honor.
Okay.
Yeah.
Uh, 23rd, 27th, or 30th of October, pick that up by day.
23rd.
October 23rd will be the next hearing. Okay, Mr. Hawley, show me what you can do.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kayla Smith, case number CRB 23271.
Mr. Stratton's case, Kayla's at Bethesda, but she's not going to be there that much longer, or she's already left?
She is transitioning on Tuesday to Project Hope, where her, what is it, Monday? Oops, sorry, it's Monday, where her
Okay.
children will join her.
How do you feel about that?
Excited. I miss him. I haven't seen him since I was in your courtroom August 7th. So,
Okay, well, I've got a little familiarity with that program. I think it's really good. We've had some other people successfully complete it. And it's, you know, such a great chance for you to be with your kids, so.
yes, I'm excited to be able to grow while growing with them as well.
Mr. Stratton.
Your Honor, she's done well. I think we've already took a plea to this case, and I believe it's already been a sentence. She's already been sentenced on it. I believe.
As far as I know, yeah.
She has.
Yes, yeah, so I think.
6 months suspended on the condition she finishes treatment.
Yeah, yeah, so.
With an
So
ankle
now,
monitor.
you were ordered to Bethesda, but this is one case where, because of your kids, and they're going to be able to come stay with you, I'm totally on board with you going to Project Hope.
We think it's in her best interest as well. She does have an ankle monitor as well.
So Your Honor, I don't know if you just want to put it back on the sentencing docket or put it on the review docket, whichever.
Okay, so it's already on the review docket for October 23rd. Let's just keep that at 9 o'clock.
Okay. Oh, 9 o'clock, not 10. All right. There you go.
Thank you.
Okay, I had it down for, I guess the motion was to let her go
Yes.
to Project Hope, and that is granted. If there's a motion, she is, I guess we need to do an order. She is allowed to transition over to Project Hope.
Thank you, Your Honor.
Good luck.
Thank you.
Thank you, Your Honor.
You got a guy in the back who wants some attention. No, I think it's him.
State of Ohio recalls Jesse T. Conley, number CRA 23410, CRA 23411, CRC 2399. Jesse Conley. Jesse Conley.
He was still out there last I looked.
Mr. Conley? No answer.
Your Honor was here a few moments ago.
It's Mr. Steyer's case, except for when we're here. Pre-trial, actually.
Oh, here he is. We had him. I apologize. Mr. Major has a report.
Your Honor, he did give a sample, but upon looking at the sample, it did not read a temperature. It was not warm to the touch. I asked him to give me another sample. He's not done it yet.
Okay, we can wait.
Thank you.
State of Ohio recalls Jason Watts, case number CRB 23532, A and B.
Mr. Morford's case, set for, well, it was set a week ago for pre-trial, so he came in today.
Judge, we'll have to change the pleas.
Okay?
Guilty.
So that's to theft and criminal trespass.
Yes, Your Honor.
I want you to go do your screen. Go to probation, do a urine screen, then I'll send you after you get your urine screen.
State of Ohio versus Daniel Craig Collier, case number TRC 23448, A, B, and C.
Well, that's his video feed, I believe. He's been texting me, pretty recently, but doesn't appear to be on there.
All right, Daniel Collier, wake up. I don't know where you are, it looks like a big city. I'm assuming that's the fake background. Yeah, we'll go on to some others so we can work on it.
Thank you.
State of Ohio versus Laban K. Murray, case number CRB 23412, A, B, and C.
He just left to go to the bathroom.
Just left what?
He just left to go up to the restroom.
Okay.
State of Ohio versus Robert C. Lovell, case number CRB 22672.
All right, this is Mr. Stratton's case.
Yes, Your Honor.
Set for sentencing.
Yes.
What's your thoughts on this one? This is crazy.
This is sentencing.
That Mr. Collier will be with you in a few minutes.
Yeah, there was apparently some sort of a technical issue, said it was resolving an issue and stopped the feed.
Okay. We'll be right, don't leave, we'll be right back to you.
Your Honor, I believe the state's going to just recommend suspended time on this case.
Okay, I'm assuming we continue this so you can get in touch with the complaining parties.
That's correct, Your Honor, and because this is a 2022 case, I believe, we were unsuccessful in the telephone number that we had from before was no longer a good number. So what we were going to recommend was a 10-day suspended jail sentence and a no contact order.
Yes, Your Honor.
No problem with that?
No.
No, sir. No, sir.
Not together any longer?
No, sir, I want to get this over with and go on. Yes, sir.
Anything you want to tell me, Mr. Lovell, before I finalize it? You have a right to make a statement, you don't have to.
No, sir. No, sir. I got a job interview, actually. 2 o'clock, I'm going to be late for.
No, you're going to be done.
All right, sir.
$100 fine, court costs, 10 days in jail suspended, order to stay away from Lisa Drennan, no contact order be issued. Your review hearing will be March 29th or 24th at 9 a.m. If you pay your fines and court costs off before then, you don't have to show up.
That sounds good.
You got to go see Mr. Major, who will be your probation officer, though.
Okay.
And Your Honor, it's going to take us a minute to get the no contact order.
You'll need to sign that before you call.
Yeah.
All right,
We leave, you gotta sign
go to
it.
probation. By the time you're done with probation, they'll probably have it ready.
Let me look through that one folder there, Mike.
You do yours well.
You go, where you going?
Oh, is this it?
State of Ohio recalls Laban K. Murray, case number CRB 23412, A, B, and C.
Mr. Stratton's case, set for sentencing. He's at Bethesda.
Your Honor, he's done well. Only thing is that I think he has a positive test for
Cannabis.
cannabis.
And he's still in the early stages, so we've just gotten started.
Okay. Come back in a month,
Yes,
or maybe a little bit longer.
yes. A little bit longer, good. Maybe end of October or beginning of
Looking
November.
1st of November, 6th, 13th.
6th is fine.
November 6th will be the next hearing.
Thank you, Your Honor.
10 o'clock.
November 6th at 10.
State of Ohio versus Carl E. Fluid II. Case number CRB 23325. Carl Tulig II.
I have this in this first case, Carl Tool, hometown recovery. He left Burnham against staff advice. Okay, and this is a CRB case, so there'll be a warrant issued from here.
Thank you, Judge.
No bond. Bench warrant without bond.
State of Ohio versus Daniel L. Cox. Case number CRA 23495, CRC 231103.
Mr. Smith's case, preliminary hearing, pretrial, supposed to be a pro act.
Yes, he called the clerk's office here probably closer to noon, said he was half an hour away. It's now 10 minutes after 1, close to, looks like 10, I don't know where he is. He said he was half an hour out about noon. I've called for him outside and in the lobby just for the last 5 minutes.
And this is OVI and a felony possession.
Yes.
He, I believe, pled to the OVI on September 1st. We're leaving the felony possession charge pending to allow him to go to treatment.
How do you want to proceed?
We would ask for a warrant from this court, Your Honor.
The bench warrant for failure to appear.
I'll see if I can find him, Judge. You just walk in. This might be
Daniel
on
Cox.
time. Is Daniel Cox? Apparently he's walking in now. Hey. Like, seriously, 10 seconds. So is that for pro?
This is from the reason why I was at the hospital until 6 a.m. I've been there 3 weeks. The kid's diagnosed wrong time and treated the wrong way.
Do you have anything for pro action for your assessment?
I signed paperwork for them to send it, yes.
So you were there this morning, say 6 a.m.?
We should be able to sign it maybe 5 seconds.
Okay. Yeah, well, I can explain why he wasn't here on time. He's been at Cabot Huntington Hospital since 5 or 6 a.m. this morning, but he did sign a release of PROACT, he said, to release the medical records here. I don't know if you received.
No, I don't have any.
Seems like PROACT, we kind of run into this. You want to recall it, maybe check if they're here? I don't know.
I don't think we can probably get them that quick.
I'm here Monday, if you want to do it Monday, if that's...
Sir, I also have changed jobs since, and I work in Lexington, and my weekends actually is Thursday, Friday now. If you can just give me till next Friday, I'll have all that paperwork and I'll bring it.
We got 34 pre-trials next Friday.
Are you busy?
Yeah, well, I'm busy, not quite as busy as the judge. but I'm-
October 13th. That's 2 weeks.
Let's see. Yes, I can do that, Judge. October 13th. You go to proactive, plus it, tell me.
Everything is continued to October 13th.
And you might also want to get a copy while you're there, but fuss at him, tell me. You're supposed to send this stuff to the court.
Yeah, I was in there.
State of Ohio versus Naaman C. Cox. Case number CRD 23569.
I got you.
This is
Just did a copy. We'll see you that day.
recall.
I think he had
Okay.
a sentencing there.
Yes. Oh, okay, he has review, and then this is on sentencing.
At your next hearing, I'll see you then. Oh, here, get this. Make sure you get that for proactive. Yeah.
They're waiting on him to be assessed as soon as he gets down here.
Okay, so he's gonna go, so.
Yes.
All right, well, I'll just continue this then to sentencing until we get the assessment back, October 13th. And I'll set it at 10 o'clock. October 13th.
Your Honor, I left my paper in the vehicle for what you got my other date scheduled at. Was it the same day by chance?
I don't think so. What was the other date? It's further out.
Hey, Josh. I have a disorderly conduct charge.
That's what this is.
Okay.
2 A's.
If you could maybe move this to that or that to this, vice versa, whatever, if I could request it, that'd be possible. So I don't have to take off one day of work.
Okay, hold on a second. Okay, move them all to October 13th.
Moving both to October 13th.
All your cases are October 13th.
Thank you, sir. Both of them to 13th. Thank you.
State of Ohio recalls Daniel Craig Collier, case number TRC 23448, A, B, and C.
Is he no longer on the call? Oh,
Been there all morning.
Okay, go to something else.
thank you. I'm gonna try to contact him.
State of Ohio recalls Jamison Watts, case number CRB 23532, A and B. Jamison Watts.
He was doing the screen, right? Okay, pass. We don't have a result.
State of Ohio versus Matthew White, case number CRB 23576, A and B.
I said Michael, it's Matthew, you're correct.
Your Honor, I reached out to Mr. Major. Mr. White is having a little bit of trouble understanding that he is where he has to be and he's court ordered. Every day it's, I want to run. The girlfriend's left OBP. Now he wants to go to some Kathy Ireland facility in
Williamson, correct.
And I told her the 1900 times she's called that it's not court approved, that he needs to continue in treatment.
That's correct. We did discuss briefly, I believe it was Monday, we were here on this case, that the Kathy Ireland place in Williamson was going to accept him, but that's before I knew that Bethesda would take him. So he was ordered to go to Bethesda, and I didn't know he was on the docket until I just found out from Mr. Major.
Well, I hear you're causing lots of problems at Bethesda. You're wanting to leave, threatening to leave, threatening to run.
I've been polite as I can. My wife is what I'm trying to get to. She found a place for us to go to co-ed, and
No.
my wife's the only social support I got.
We had to send you to Bethesda because she was at OVP, and I understand she left there.
Yes, she did.
She left because I wasn't there. That's what I'm saying, I'm worried about my wife running the streets.
I'm more than happy to offer her a bed, but I just need you to understand that your court order to stay there, and that's where you're going. We're not gonna have a conversation every single day that you wanna go somewhere else. It just is what it is.
And Your Honor, his wife has called us a lot last week over this situation also.
Okay, the calls have to stop. Is she here anywhere? Or we can just set it for trial and have a trial.
I prefer he stay in treatment, but it's up to him. He's got to do this. I can't do it for him. You want to stay in treatment?
I want to help her, and I'll be more than happy to reach out to her, but I can't force her into treatment.
We got married in December, and I've never been away from her. She's never been away from me.
And I understand that, but if you're both using it, it's
How old
not
are you?
healthy.
Okay, well, you got 33 years without her, so, I mean, I don't think that's a very good argument. The main thing for you is to get clean at this point.
I did talk to the assessment team who did his assessment, and she said that of all the people that she's assessed, he needs it probably more than anyone she's ever talked to. So if you'll give me her number, I'll reach out to her, and I'll be more than happy to go pick her up.
Can't do better than that.
Sure can.
Okay, so we're square then, you're gonna stay? Okay, he can be released back to Bethesda, and we need to set another date. October 13th?
I'm here that day, yes.
See you in 2 weeks. With a good report.
Thank you, Judge.
Thank you, Your Honor.
Roger.
State of Ohio versus Jacob A. Williams, case number CRA 22-806 and CRB 22-807.
See you in the back?
Yes.
Okay, we can do Daniel Collier while, who's the attorney on that?
Luke.
Sorry.
State of Ohio versus Daniel Craig Collier, number TRC 23448, A, B, and C.
All right, Mr. Collier is on screen. This is set for sentencing. He's in treatment at Rocking Horse.
Yes. Rocking Horse has previously provided a report. I don't know if they've provided one today or not.
September 1st is the last one I've had.
Well,
I go every Monday.
well, we were last here on September 1st, and if I remember correctly, on that day,
They faxed it.
they faxed one in. But you have not received one today?
I have not.
I have not, Your Honor.
Your Honor, I'd ask to reschedule this for the 6th or the 13th, whichever date's better for the court, and ask Mr. Collier to,
Let's just keep, can I talk now?
I'm going to advise you that to remember, anything you say can be used against you, and then you're free to talk, say whatever you want to say.
Yeah, so let's just get this over with. If you want to jail, send me to fucking jail. I don't give a goddamn. This was.
Okay, I will send you to jail. I find you in contempt. I sentence you to 6 months in jail, and I'll put a warrant out for you. So as soon as you're found, I'll have you back before the court, and we'll deal with it then. But right now, I'm issuing a warrant for your arrest.
Why?
I think that's self-evident.
Thank you, Your Honor.
You're welcome. All right, Jacob Williams, I put in the holding cell because he did not do community service like he was ordered to do.
Your Honor, I apologize for that, that was my mistake.
And you'll be here tomorrow morning at 7:30? No, tomorrow morning. Well, that was gonna be your two choices, go to jail or be here in the morning for community service. 7:30 a.m. You'll have to set the alarm. What time you gonna set your alarm for? On your phone. I assume you got an alarm on your phone.
Yeah, I do.
Where do you live?
I've been staying in Huntington recently.
Where in Huntington?
My girlfriend's house.
Where's that?
355 Slater Court.
I don't know where that is. Where's Slater Court?
It's by Cookout.
Okay.
Cookout.
You're maybe 4 miles away. Do you have, is somebody gonna bring you, or how do you gonna get here?
Yeah. I'll have it.
Okay, you need to set your alarm for 6:15. You get up and take a shower, brush your teeth, comb your hair, wash your face, put decent clothes on, and get here at 7:15.
Yes, sir.
And start your community service. Then I'll see you back for another review hearing. Let's see.
Just say what happened, it's okay. Yeah, that's fine.
The day where the community service is done, that's October 7th, right?
Correct.
Yes.
You come in too.
Yeah, I will.
I'll set your next review hearing for October 16th.
Appreciate it.
Okay.
Thank you.
So you'll be out tonight, but you're coming in the morning, all right?
Yes, sir.
Okay.
State of Ohio versus Brittany D. Lively, case number TRC 23799, A and B. This is Mr. McCallum's case.
Okay, this is set for a motion hearing today.
That's correct, Your Honor.
State ready to proceed?
We are, except we need for Mr. Major to plug in our junk drive.
Here he is.
Okay.
Okay, what's the real issues here?
Your Honor, I believe that the SFSTs were done incorrectly, that he didn't have reasonable suspicion to actually get into the SFSTs, and that for the scores that he did, that they were incorrectly observed.
Okay, so do we have to get into the stop at all, or?
He alleged that he pulled her over for speed. There's no mechanism to state that, so.
Okay. All right, state ready to proceed?
Yes, Your Honor. Call Trooper Bean.
If you'll come up, I'll swear you in. You swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Trooper, can you state your name and where you were deployed?
Trooper Bean with the Ohio State Highway Patrol, the Atlantic.
And were you on duty on June the 24th, 2023 at 12:46 a.m.? And at that time, did you come into contact with Brittany Lively?
Yes, sir.
Where were you when that happened?
I was stationed at Office 14 in the Township of Perry on US Highway 15.
What township was that? I didn't hear that.
Perry Township.
Harris. Thank you.
Here in Lawrence County, correct?
Yes, sir.
And at that time, when you learned that it was Brittany Lively, was she operating a vehicle?
Yes, she was.
Would you recognize her in the courtroom when you pulled her out?
Yes, sir. She's right there.
Okay, record will show you pointed to the thing.
What was the first thing that you noticed that caused you to, drew your attention to this life?
As I said, I was stationary on US 52 near Office 14. I was observing the speeds of eastbound traffic, and I observed two vehicles traveling toward me. The one in the rear estimated to be moving faster, and I estimated that speed to be 65 miles an hour. The speed limit through that area is 55 miles an hour. So the stationary mode, I was using my LiDAR device, and I checked that vehicle is further back to 68, 69 miles an hour. I had 3 successful checks. No issues with those checks. I conducted my conference check at the beginning of my shift, as well as each time the device is powered up, it does a human self-check, telling me whether it passed or failed. No issues with my device. Pulled out behind the vehicle after it passed me, and I initiated a traffic stop by activating my overhead lights.
That was a 55 mile an hour zone?
Yes, sir.
Did you end up citing Ms. Lyman with speeding 69 in a 55 zone?
Yes, I did.
Now, when she passed you, you were stationary and she drove by you, is that right?
Yes, I allowed the vehicle to pass.
Were you able to determine the color and make of the car?
Yes.
What was it?
Off the top of my head, it was a gray Honda. I don't remember the model.
So after you registered that speed, what did you do?
As I said, I pulled out from my stationary location, pulled out behind the vehicle, and activated my overhead lights, initiated a traffic stop, and Ms. Lively, who was identified as the driver and only occupant of the vehicle, pulled over to the right shoulder of the roadway before that stop.
Was it raining at that time?
No, it wasn't.
I'm going to show you the video here. I'm going to ask you if this is, well, let me do this first. Was your vehicle equipped with video equipment on this night?
Both the vehicle and my personal body camera on my person.
So you had a forward-facing camera in the cruiser and a camera that point towards the back seat?
Yes, sir.
And then a body cam?
Yes, sir.
All of those were working?
Yes, sir.
Did you, after this was over, did you upload all of that video to the system for its use here in the case today?
Yes.
You've reviewed all the video since the time of this stop?
Not the rear-facing one, but the other two, yes, sir.
So you would recognize it as an accurate copy of what you saw and what came off your video in that cruiser?
Yes, sir.
So I'm going to show you. See that? The accurate time that this occurred is up there in the right-hand corner.
Yes, sir.
And what does that show?
0046 hours. So
Very good.
just a little after, just a little before 1 a.m.
All right, so from here, did you approach the vehicle?
I did.
And did you notice anything as you were approaching the vehicle?
Just prior to depositing the video, the rear windshield wiper activator, it was active at the time. It was not ready, so that was at least an interesting thought.
And are we going to see here that you made contact with this live vehicle?
Yes, I'm making a driver's side approach to the vehicle.
Was there anyone else in the car?
No, sir.
Did you ask her where she had been?
Yes, I believe she said she just finished eating at Texas Roadhouse. I assumed the one in Ashland, but I don't know if that was ever said.
But it was 12:47, almost a.m.
Yes, sir.
And did you notice anything about Brittany Lively or appearance?
Sure, so when I approached the vehicle, I saw that Ms. Lively's eyes were watering and bloodshot. That's an indicator of impairment. I detected a moderate odor of alcohol, an alcoholic beverage emitting from the vehicle. As I talked to her, her speech was slow. Depressants, alcohol being a depressant, behavior can be slow, lethargic, sloppy at times. So her speech was slow. I talked to her, asked her for several things, including vehicle documentation. While I'm asking those questions, it's an attempt to divide attention. While she's retrieving something, I want her to think about questions that I'm asking. And if she's not able to do both simultaneously, it could be a sign of impaired divided attention skills.
Did you observe that kind of thing?
I did. At one point, I had already asked for various relevant documentation. And at one point, Ms. Lively either handed me her registration or insurance. And she paused for a moment and then said, and I'll hand you mine. And she said, sorry, specifically to me, that she realized that she had lapsed thought. And I also had to give it my ID as well. So that was another thing that I observed.
Did you ask her how much alcohol she consumed?
Yeah, she said that she had one glass of wine.
Did you notice anything about her speech?
Like I said, while she's still in the vehicle, I wouldn't say that it was anything other than slow. As she exits, she tells me that she just had one glass of white. I say it specifically like that because it was slurred at that point. That was the first time, and I believe the only time that I observed her speech to be slurred during a traffic stop. Specifically when she said the word "just," and there wasn't a defined T on the end. It was more of it was slurred, as well as when she said "wide." No, the word "wide" was wide, not white. So those other things that I observed, she exited the vehicle.
So you asked her to exit the vehicle at that point?
I did, yeah. I asked her, I said, hey, when I ask you stuff about the vehicle, do a call for me so I can ensure that you're safe.
At that point, did you feel that you had reasonable suspicion that she may be prepared for purposes of the OPI statute?
Sure, just for phase 1 and 2, vehicle in motion and personal contact, with all those things together, with the rear wiper blade being activated, no, it wasn't raining, watery bloodshot eyes, odor of alcoholic beverage, admission to consumption, as well as slow speech. I asked her, said, if it's helpful, probably 90-second marks on that, 30.
Yeah, 30. By the way, that last video clip that we played, was that an accurate representation of what happened that evening?
Yes,
as far
sir.
as your view from the cruiser?
Yes, sir.
You had the body cam on, correct?
Yes, sir.
So that's my union turn. Okay. And I'll give you my leave. That's good. Take your time. It's not about that. They were $50. Was that all the insurance? Yeah, absolutely. Yeah, you know, they're cheap. Yeah. Do you have your registration for us? Yeah. Like there. That's all right. Nothing wrong with
Where'd you guys gear up at tonight? Oh, nice, okay. Got it. Okay.
Yeah. 1143. There you go.
Thank you.
Is this mine?
Yeah, so let's put it back there for you.
So I just switched for that.
Okay, good job before.
State Farm.
State Farm.
Yeah, and, 7 o'clock.
Did you get lost just so I can clarify maybe what I mean by slow speech when there's a delayed response to my question, right? So she's looking at something, there's silence and then and then she gives the answer. That's what I'm referring to, if it's helpful to articulate what slow speech sounds like, that's what I'm keeping in mind.
Oh, no, I just have one glass of wine. Okay. Yeah.
All right, let's know.
Sorry, yeah, it is kind of. That's okay. And my mom said ICU, and I've been spending time there. Lots of wine. But
Not a big deal. Okay, I just said that. You said you drive the other way. Was it food release?
yeah.
So she continued to get out of the car, I guess.
Yes, it is what she asks.
After she was out of the car, did you conduct standardized field sobriety tests?
Yes, sir.
Before you did that, did you turn off your overhead lights on your cruiser?
The forward-facing ones, I did, and also noted at that time, one of the things I do, I'm in a vulnerable position on deactivating my lights, so I like to look up and see, I didn't suspect Miss Lively of hurting me in any way, but as officer safety, I look at the person as I'm doing that, because you never know what someone's going to do. So I noticed that she made it to the front of my car, she staggers at one point. I believe she leaned on my cruiser for support.
So as part of your job as a state highway patrolman, you are trained and certified in conducting standardized field sobriety tests.
Yes, sir.
And there have been several editions of the NHTSA manual that the last one was in 2018. You're familiar with that one?
There's a more current one now, 2023.
Yes. Have you looked at it? That's going to be my next question.
Yes, sir.
So you also are familiar with the standards that apply, and you are competent to perform the test according to those standards.
Yes, sir. Not only do I read it personally, study on my own, but the state highway patrol itself gives us updates on what those changes in. So I've received that as well as my own personal reading.
So did you perform did you conduct those tests, starting with the horizontal gaze status?
Yes, sir.
Now, I would like for you to explain what horizontal gaze status is.
It is nystagmus in general is the involuntary jerking of the eyes. The cliche that's always used is imagine dry wiper blades going across a dry windshield on a vehicle. And that's what we're looking for specifically in horizontal gaze. Nystagmus is I move the stimulus, or as the person who is performing the test is focused on it. There will be an involuntary jerking of the eyes present if HGN is present.
And if HGN is present, what does that indicate to you?
Well, so there's 6 total clues that we're looking for. Before we do any of that, just so we have a greater understanding of the person that we're dealing with, I always ask a question. That's really the first thing I do. I ask, do you wear contacts or glasses? And I believe Ms. Lively's response was no. I asked her if she's taking any medications. And she told me that she was taking I want to say antidepressant as well as blood pressure medication. I might be wrong on second. She also asked, would you consider yourself in good physical health overall? Do you have any history of head injuries that cause you present day issues? Ms. Lively told me neither of those applied. And then she did consider herself in good physical health, I guess more specifically. From there, I'll do a pre-check where I'm looking for, when we look at the administrative clues of HGN, the very first thing we do is we check the contacts. The second step is provide the verbal instructions. The third step is present the stimulus, 12 to 15 inches from the individual's face. Fourth step, I'm looking for equal pupil size as well as rest and nystagmus. Neither of those were present when we're concerned. The next thing I'm looking for is equal tracking. So I'm moving the stimulus, are both eyes following that stimulus equally. From there, once I've done that, then I move into checking for lack of smooth pursuit. That is the first two validated clues that you could potentially observe. So as I'm moving my stimulus, is the person following, their eyes following it smoothly? If it's not, in a jerky motion like those dry windshield wiper blades on a dry windshield, it's going to be, rather than being smooth as they follow it, like my hand is moving, it'll be jerky. As they follow it, it's not smoothly following the stimulus. I did observe that, and therefore observed the first two validated clues, horizontal gaze and stagnant.
And that's lack of smooth pursuit.
That is lack of smooth pursuit.
But just in case it's not evident already, the purpose of this test is to gain evidence of something?
So HGN will be present for three types of drug categories: depressants, inhalants, and dissociative anesthetics. Alcohol being a depressant, if that is very much in play when we're looking for impairment here in HGN. If I believe the person being impaired by cannabis, I would not expect to see HGN. However, with alcohol, with it being a depressant, I would expect to see that if they are indeed impaired. So yes, that is something that I would expect to see.
In this case, did you suspect impairment by alcohol?
Well, I'm developing that as I go, right? So now that I see two clues of horizontal gaze and nystagmus, I'm looking for the next set of clues. The next set of clues that follow, and they're the follow.
I want
Yes, go
to
ahead.
play some video first.
Sure.
Stand literally right there. Yeah, normally, yeah, come on over, yeah, you're fine. No, you're good right there, you just stand normally for that. Where do you live at? South. Okay, gotcha. That's the current address in ID, right? What do you go by? Brittany. Brittany, you can just take like a half step back, like right on the line. You're supposed to be right there on the line. And actually stand. Turn face. You're under there, like line over. And then you just stay like that. So, you don't touch your glasses? No. And then any medications? You take one of those?
Yeah, I take, let's see, metoprolol, amlodipine, Basbar, Vibrid, I'm on a lot of tablets.
Okay, and then the worst that you mentioned,
I take Vibrid for antidepressant, Basbar for antidepressant, amlodipine for high blood pressure, metoprolol for high blood pressure.
have you taken all those that day?
Yes. When? Oh, morning and night. So like, yeah, so like, 9 o'clock and then like,
Only reason I ask is, when I'm asking for these things, it's so I can understand.
oh, yeah. So I face high blood pressure, I'm hypertension, and then I have, depression and anxiety issues. Yeah.
able to make a mental note of all the medications she named?
The categories, yes, so antidepressants or anti-anxiety, either or, and then blood pressure medication.
Are any of those ones that you would recognize in your line of work that could be impairing someone?
Your Honor, I'm going to object. I think it's improper. There's no lack of, there is no foundation for this line of questioning as to what his training and education is on this or experience as to the various effects of various medications.
The same.
Trooper, as part of your training, have you undergone any kind of instruction about the various kinds of intoxicating narcotics and other drugs that could impair a person from driving a vehicle pursuant to the OVI law?
She did mention an anti...
Objection. It's non-responsive to the question.
Have you had training to that effect?
Yes, both training, experience, and then, yes, in the training they talk about drug categories and classification calls that.
Was there anything about what she, and that's an A-RIDE training, is that what that's called?
I don't remember if it was taught in the SST course or the A-RIDE course, but it was one of the two.
But you've had the training?
Yes, both of those.
Is there anything about any of those drugs that she mentioned that would be in the category that might cause impairment?
Your Honor,
for purposes of the OVI?
Again, I'm going to object. There's been absolutely no background as to what that training consisted of, what the educational aspects were. There's been no manuals put in, nothing that would indicate his education on this matter and the classifications and how they have those classified.
I'm going to let him testify, then they'll go to weight. I mean, he just said they covered it. He doesn't, I don't know what the depth of his knowledge is or anything like that, so I'll let him answer.
Was there anything among that list of medication that Ms. Lively recited that would be of a category that you understand through your training and your profession to be something that could impair someone for purposes of the OVI statute?
Antidepressant, anti-anxiety have the ability to cause HGN, and taken in the right doses or quantities should be considered.
So I believe you testified already that you went to lack of smooth pursuit. That was the first part of the HGN.
Yes, sir.
Sorry, I thought.
Actually, before I go any further on that, you did perform that lack of smooth pursuit portion of the HGN test. Did you perform that?
Yes, yes.
And as part of the investigation that you do involving standardized field sobriety tests, do you do an impaired driving report to record what observations you have of each of the field sobriety tests?
Yes, sir.
And in this case, did you do that?
I did.
And I'm going to show you what I've had marked states of it.
Your Honor, if I could see the exhibit that's being brought up as well.
You haven't. Tell me what this is.
That is the first page of at least two, I would say three, of the HP 70B impaired driver's report.
Is that an accurate copy of the report you submitted as part of the investigation of breaking law?
Yes, this is the one that I submitted.
So, does this show the HGN observation that you had?
It does, yes.
And under lack of smooth pursuit there, what did you record?
then I observed lack of smooth pursuit in both the left and right eye, so 2 clues total.
And I'm going to show you a video here, which I believe is that portion. You can tell me what it is.
Or you're about to tell me what's going on. What's going on.
Now, was that what you were doing there, the lack of smooth pursuit?
Yes, you just ended it where I just said completed lack of smooth pursuit.
And you said you saw 2 clues there, 1 in each eye?
Yes, and that's the max that I could observe.
Now, did you move on to another part of the horizontal grading nystagmus?
Yes, the next part of the administrative procedure is checking for distinct and sustained nystagmus at maximum deviation. So what I'm doing there is I'm holding the stimulus as far out as I can to where I'm basically putting that just within their view. They still have to be able to see it. If they can't see it, you're not really finding out anything. While it's at the max point of their view, where they can see it, if it is observed, or if nystagmus is present at maximum deviation and sustained, what you'll see is the involuntary jerking of the eyes. You'll still see that nystagmus.
In this case, did you see involuntary jerking of the eyes?
Yes, I did.
In each eye?
Yes.
Did you record that here on the prepared running report?
Yes, I did. So I've got 4 of 4 that I've checked.
Now, that video that we just watched, was that the portion that you checked for distinct nystagmus at maximum deviation?
Yes, sir.
And what was the next part of the HGN test that you conducted?
Onset of nystagmus prior to 45 degrees.
So explain that difference.
What I'm doing is I'm, for one, to get 45 degrees and knowing a right isosceles, a triangle based on common geometry lets you know that if I'm holding that stimulus 15 inches out from the person's face, by going 15 inches out to the side, I've got a 45 degree angle on one side of the check, of course. So at any point, if prior to that 45 degrees, I observe an involuntary jerk into the eyes, onset of nystagmus, prior to that 45 degrees is present.
Did you observe nystagmus prior to the 45 degree angle?
No, I did not.
And so you didn't record that as a clue, did you?
Correct.
Now, so how many clues total did you get?
I have 4 of 6, so as per the manual in the most recent validation study completed to date, what that would mean, based on that study, is that 4 out of 6 clues indicates that it is an 88% chance likely that this person is impaired. They base that on the blood alcohol concentration of 0.080 grams per 210 liters. So having 4 out of 6, that is an 88% chance likelihood that Ms. Lively was impaired at the time. when the truck happens.
So you've already, I think, testified that you're familiar with the 2023 NHTSA manual.
Correct.
And is that testimony that you just gave about the 88%, is that in that manual?
Yes, that number comes from the 1998 San Diego validation study.
So that information has been contained in the 2018 manual and the 2015 manual as well?
I don't know about 2015. I was not trained. The very first one I was trained on was the 2018 study. I can only speak to that one or later. But for both manuals I've been trained on, it's the same, based on the same study.
So I'm going to show you what was marked as States Exhibit 2. I'm going to ask you if having reviewed the 2023 manual, if these pages are accurate copies of the 2023 manual, and what information is on there that you just testified about.
Yes, this appears to be session 7, pages 5 through 7, and discusses horizontal gaze nystagmus in general, as well as vertical gaze nystagmus.
And does that say anything about what you just spoke about, the 88% accuracy?
Yes, it says, it discusses the 80% accurate detecting subjects with a blood alcohol concentration of 0.08 or greater.
That's it. Accurate copy of the manual, is that right?
Yes, sir.
Well, I'm going to ask that Exhibit 1, which is the impaired driving report, and Exhibit 2, which are pages from 23, NHTSA manual, please, Ben.
Your Honor, argument 2, I'd like to cross-examine first on those if it's okay.
All right, I'll take the subject to cross-examination.
Now, in the motion that Mr. McCown filed on behalf of his client, he said that you had the stimulus too far away from Ms. Lively's eyes, and that you also didn't move them in a correct manner. Do you agree or disagree with that?
Disagree.
How many inches do you feel that you had away from her eyes?
Anywhere from 13 to 15.
And what is the distance that it's supposed to be according to the NHTSA standards?
Within 12 to 15.
As far as improper directions, what directions did you go?
I positioned the stimulus and I asked her to follow the very tip of my pen with her eyes and eyes only. You'll notice in that video, if you can recall, I corrected her several times. She moved her head several times. Even at one point, I said, I need you to hold your neck still, your head neck still. And she, even after the instructions, began moving her head again. So still of interest, even though it's not a validated clue, I'm interested in that when it comes to impairment. Why am I giving these simple instructions that they're not going to follow? And I can tell my 5-year-old woman, your head, and he's not going to move his head.
Objection.
Did you eliminate environmental factors such as reflection of strobes from the rear of the cruiser? That's what's alleged, that there were strobes at the rear of your cruiser that could have influenced the accuracy of the horizontal gaze nystagmus test. Do you agree with that?
Yes, I deactivated all strobe lights that would have impacted this light.
Were there strobe lights on your cruiser that were still activated?
Yes, the rear-facing ones that were not exposed to, the Ms. Lively's eyes were not exposed to. Yes, just for brush safety. Obviously, in an ideal world, I wouldn't have any strobe lights on, but considering that there's no concern with that light being introduced in Ms. Lively's eyes, I want to keep traffic away from us anyway.
Were those lights facing the direction of traffic was coming towards you?
Correct, and away from us.
It's also alleged in the motion that you did not instruct Ms. Lively to maintain focus on the stimulant for the duration of the test. My question is, did she maintain focus so that you were able to conduct the test with an accurate result.
Yes. Yes. I mean, you can see me redirect her even multiple times to make sure that she's doing exactly what I need her to do.
It's also alleged that you did not retest the defendant's eye after she nodded her head in acknowledgement to a question you asked, leading to the potential of rotational, post-rotational, or positional alcohol nystagmus. First thing is, do you know what rotational, post-rotational, and positional alcohol nystagmus are?
Yes, I do.
Are you able to explain those three things?
Yes, so if you look at the manual, in session 8 specifically, I believe, what it says is that it talks about different types of things that could cause issues with HGN, and it mentions even I'll explain in a second, but rotational nystagmus, we'll start with that one. The manual says that rotational nystagmus is caused by the person being rapidly spun around, and that because of that rapid spinning, it will disturb the inner ear fluid. And post-rotational nystagmus is directly related to rotational in that when the rapid spinning stops, that disturbs the inner ear fluid. You'll also note in the manual what it says immediately after discussing both of those is that those are not a concern for fingerprint sobriety testing because of the conditions under which they would happen. Miss Riley was not rapidly spun around at any point in the traffic stop or anything like that. And then as far as positional alcohol nystagmus, what the manual says is that so long as the head is aligned with the spine, this is of no concern. Miss Lively's head was kept in line with the spine, and anytime she would move her head, she was redirected to move it back to the position in which I needed it to be.
I believe you mentioned session 8 of the 2023 manual, and I would ask you to look at these 2 pages and tell me where you've seen them.
This is pages 14 and 15 of the session, from session 8 of the 2023, and it's a SFST manual.
According to those definitions, do those pages contain those definitions of the different kinds of nystagmus that we just discussed?
It does.
And do those pages look familiar to you?
Yes, sir.
Is there anything in there contrary to what you just testified to?
No.
I'm going to ask that this be admitted as State's Exhibit 3.
Any objection?
Your Honor, again, I'd like to be able to cross-examine any exhibits proffered.
Subject to cross-examination.
Did you move on to other field sobriety tests after this?
Yes, sir.
What was the next one?
The walk and turn test.
Can you explain what the walk and turn test is, how it's performed, what indicators you're looking for?
Yes, in short, I'm asking somebody to take a series of 9 toe steps along the line, or one that's being imagined if there's not an appropriate or safe line to use nearby. And from there, they're instructed on how to take the steps and what to do, and then how to make an appropriate turn, and then take another 9 toe steps back, and then they're instructed to stop and say complete instruction.
Did you record your observations on the comparative driver report that was looked at previously?
Yes, sir.
And I'm going to show you that again. It's Exhibit 1, and ask you about what you observed.
Okay. You saying after the video or
Go ahead and talk about what you observed.
So, on the paper I submitted, I have all 8 clues that are possible to observe during the walk and turn as being observed. The one that I would actually say that I would differ on now than when I was on the roadside is the number of steps that were being taken. As I studied for this hearing a couple of nights ago, I was watching the video, and while I was on the roadside, we'll play the video in a second, maybe it'll help give greater clarity to it. I had believed that Ms. Lively took 10 steps down the line, then made her turn 9 back. While reviewing the video, I think that what I can now see was that Ms. Lively did take 9 steps. So I would say that after 7 inclusive impairment, not 8.
It's a divided attention test.
Yes.
Explain what you're looking for as far as divided attention.
So for starters, what we do is we get them in what we call the starting position. I ask them to imagine a straight line. They can do that, and I'll ask them to stand with the right foot in front of their left, touching toe to toe, and their arms down to their side. They are asked to do this while I'm explaining and demonstrating instructions to them. To stand like that and then still listen to my instructions, that's divided attention. Can you stand in this position and also listen to the instructions that I'm showing you and explaining to you. In that starting position, prior to them beginning the test, you can observe 2 total clues, 2 out of 8 total clues of impairment. I did observe both in this case. It's likely, those 2 that I'm looking for, did they start the test too soon? And did they move the feet for balance from the starting position? Ms. Lively started the test too soon on multiple occasions, as well as moved her feet for balance from the starting position.
Did you tell her not to move until you told her to move?
One of the things I say is I don't want you to stay like that until I said it again. You understand?
You want right over here? The next thing I'm going to ask you to do is you just face my way. And then I'm asking you to imagine a straight line. Going from you. Let's say 1 steps to the right here. Just give you a little space. Just, you don't have to be up right. So imagine a straight line going from you.
Here, that headline?
Yes. Yeah. Perfect. Can you imagine that line? I don't want you to go anywhere. You
Oh, I'm sorry.
That's okay. So that can you imagine? I'm asking you to go this way.
Oh, okay.
Then take your right foot, put it in front of your left foot, touch your toe, just like that. Actually, go to the opposite. Yeah. That's all right. want to just try a different one?
No, I'm just a sports player, and you don't see that, like.
That's okay.
I don't know that I can do that in general.
That's all right.
You go on then to another standardized field sobriety test?
Yes, sir.
And what test is that?
The one leg stand.
Can you explain, Stephen, what that test is, how it's performed, and what you look for?
Yes, the instructions that they're given, obviously, I'm asking you to take a foot of your choice, left or right one. Doesn't matter to me. Take the foot of your choice, don't hold it approximately 6 inches above the ground, and parallel with the ground. Your hands down your side, look down your toe, count a series of 1,000, like so, 1,001, 1,002, 1,003, 1,004, and so on, until I told you to stop. I'll have my watch ready to go, and I'll time them for 30 seconds to how long the test lasts. 4 clues I'm looking for. They put their foot down, do they use their arms to balance? Do they sway? Do they hop? Per the NHTSA manual and that validation study that I referenced earlier, 2 out of 4 clues indicates that there's an 83% likelihood that that person compared by one of the 3 drug categories I mentioned earlier.
And in this case, did she actually follow through for the one-night stand?
Yes, she did.
And did you record your observations on the impaired driver report?
I did. She put her foot down multiple times and swayed during the test.
Someone asked you to do some walking or anything if you want to try it. I'm asking you to stand right there for me. Alright. Then feet together like you're moving forward. Okay. Hands down your side. That's what I'm saying. You can't understand.
No, yeah.
Alright, what I'm asking you to do with this one is take a foot of your choice. Left or right one. Doesn't matter to me. Take that foot of your choice. One of the cars. 6 inches above the ground. Parallel with the ground. My hands. Both legs nice and straight. I'm ready to be. Not just yet. I'll tell you again. Keep your hands down your side.
Oh, I have to keep it up in the air.
30 seconds. Keep your hands down your side, and down your toe. Count series 1,000, 1,001, 1,002, 1,003, 1,004, so on until it says stop.
Oh, shoot.
You ever seen the instruction?
I do, sir.
All right. All right. If you ever seen the instruction, maybe you can.
Okay. 1, 2, 3, 4.
So you can get it resumed where you left off if you want to.
1, 2, 3, 4. Ah! And do this for everyone.
All right, you can stop. Last thing I'll ask you, you can come right up.
Now, after the completion of the one-leg stand test, did you have any more conversation with her about how much she had to drink?
I think the entirety of the time was likely. She said she only consumed 1 glass of wine. I think she even put 9 ounces on the volume of that at one point.
And at this time, it's almost 1 o'clock in the morning.
Yes, according to video.
Now, without telling me if there was a score that was recorded, did you request her to do a preliminary breath test at that time?
Yes, she said she was willing, with our preliminary breath test devices, PBTs for short, just like the Intoxilizer 8000 that we have at the Ironton Post, if you're blowing into that device, the tone will sound for as long as they're providing sufficient enough breath sample.
Your Honor, I'm going to object as to the mechanics of it. I think we requested the information about the PBT calibrations, et cetera, in our discovery, and I don't believe that has ever been provided, including even the model number of it.
Well, we're not going to seek to introduce a score, only what she did while she was.
Your Honor, he's testifying as to how this machine functions, and we don't even know how it functions because they haven't told us what the machine is, given us a model, anything.
Well, we don't need to get into that if we're only going to talk about, I assume you're talking about observations that.
Yes. Well, yes, exactly. So we'd like to know what this profit is.
Yes, go ahead.
So what happened?
So I know, I've offered many PBTs over the course of how long I've been doing this. When they're blowing into a tonal sound,
Objection to the record.
From there, I'm giving Ms. Live instructions to take a nice deep breath and blow into the machine. I'm asking her, like I said, I'm asking her to take a nice deep breath and blow. She's making a sound, but it's not making a tone. She's sucking in.
Again, objection for the record because we don't know what the machine will do in that situation.
Sustain. Go ahead.
I gave her multiple instructions on how to blow into the device, and at no point did a valid test.
Your Honor, again, I'm going to object. I'm going to ask that his comments be stricken. You sustained, I think, my prior objection. So he's testifying, I think, as to the same thing, the operation of it and what his observations of that machine are.
Yeah, I would allow some testimony, since you're not going to offer the PBT, if it's observations that tend to show intoxication, just the way she conducted herself, but not as it relates to the machine itself.
Did she suck instead of blow?
She was given instructions on how to provide a test, and she did not. Simple instructions.
Objection. Your Honor, I'm going to object as to the audio when he's stating what he believes she's doing. Again, we have no idea on the model or how he knows what it is that she's doing.
I'm sorry, was there some testimony about, or something on the video about that?
I believe that, well, without telling you what I'm asking to have redacted, I believe he indicates in there, I think you're sucking, or something to that effect.
Well, I didn't hear it until you just said that, Mr. McCown.
Well, that's why I didn't want to state it, but you asked me, Your Honor.
Here, so please proceed.
Objection as to the function of the machine and what happens in that situation.
Overruled.
Objection.
You're not gonna be able to get me for a DUI. I mean, I'm only have one glass of wine.
You want to do this or not?
Oh, yeah, it's fine.
Okay. I'm asking you to take a nice deep breath. When you get this to your mouth, roll it out, okay? Okay, you're not going around. I'm not going to that.
Okay.
You're going to that.
You placed her under arrest for OVI at that time.
Yes, sir.
And also speeding 69 and 55 mile hours an hour.
Yes, sir. You're at 55, like I said.
55.
Yes, sir.
All the video that we showed, is that an accurate copy of the video that came from your devices on this night when you were arrested, Brittany Whiteley?
Yes, sir.
I'm going to ask that that be admitted as State's Exhibit 4.
Your Honor, I would object to the audio as well that came out during this last portion of the PBT.
Overruled.
And, let's see. That's all I have for this witness, Your Honor.
May cross-examine.
Your Honor, can I see that again? I'm sorry, those exhibits. Trooper Dave, I'm going to walk you through kind of the mechanics of an OVI investigation. There are 3 phases prior to an arrest, is that correct?
Yes, sir.
First phase is vehicle in motion.
Yes, sir.
Is that an important event in the course of an OVI investigation?
It's part of the investigation.
Okay. And during the vehicle in motion, you are to determine whether or not there are any indicators or cues that an individual could exhibit impairment. Is that correct?
Yes, sir.
Now, you pulled her over for speed.
Yes, sir.
Speed is not a cue for impairment. Is that correct? Excessive speed. Certainly slow speed, 10 miles an hour under, according to NHTSA is, but excessive speed, according to NHTSA, is not a cue.
Yes, sir.
Yes, that's correct?
You're correct.
Okay. So, when you pulled her over, she had to do a number of things once your lights came on, right?
Yes, sir.
She had to signal, is that correct?
Yes, sir.
She had to recognize that you're behind her, obviously.
Yes, sir.
Begin to brake and decelerate.
Yes, sir.
She had to get over off the side of the highway. Is that correct?
Yes, sir.
Did she turn with a wide radius at any point once you were behind her?
No, sir.
That is a cue. Is that correct?
You can be. Yes, sir.
And for vehicles in motion, you're trained on all these. There are 30 total cues that you look for during the Phase 1 vehicle in motion test to indicate impairment. Is that correct?
I don't recall the total number off the top of my head.
Okay.
I'll take your word for it.
Okay. Turning with a wide radius. She didn't do that.
Correct.
Almost striking an object or a vehicle. She didn't do that.
Correct.
Weaving. She didn't do that.
Correct.
Weaving across lane lines. She did not do that.
Correct.
Straddling center or lane marker. She didn't do that.
Correct.
Swerving. She did not do that.
Correct.
Drifting. She did not do.
Correct.
Those are the 7 cues for problems maintaining a proper lane position, and she exhibited 0 cues. Is that correct?
Yes, sir.
Okay. Speed and braking problems. Stopping problems. She didn't indicate any, there were no indications of that, is that correct?
Correct.
There were no accelerating or decelerating rapidly in this, is that correct?
Correct.
There was no varying of her speeds during this encounter, is that correct?
Correct.
I think there was 1 mile per hour, I think, 68 to 69 you indicated, but there's no significant varying of speed. Is that correct?
Yes, sir.
And speed slower than 10 miles per hour below speed limit. She did not do that. Is that correct?
Correct.
So the 4 speed and braking problems out of the vehicle in motion, she exhibited 0. Is that correct? In vigilance problems, she didn't drive an opposing lane or the wrong way, down a one-way street or anything. Is that correct?
Correct.
She was not slow to respond to traffic signals. There were no traffic signals here. Is that correct?
Correct.
She was not slow, nor did she fail to respond to your officer signal when you turned on your lights. Is that correct?
Correct.
The timing of her, how she treated it, and her response was appropriate for a sober individual. Is that correct?
What I would expect, yes, from somebody who's not, yes, correct.
Okay. You would expect all that from somebody who's sober. Is that correct?
Correct.
She did not behave any differently than somebody who was sober in that situation.
Correct.
Okay? She had her headlights on. Is that correct?
Yes, sir.
She didn't stop without pause in the traffic lane. She actually got over. Is that correct?
Yes, sir.
And she didn't fail to signal or signal inconsistently with driving. Is that correct?
Yes, sir.
In other words, she's trying to think of all these things while your lights are on. These are actually divided attention skills to a degree. Isn't that correct?
I can see that argument.
So Well, she had to choose to turn her turn signal on when she saw you and realized that you were behind her. Is that right?
I would assume so.
While she's hitting her brake, and she has to turn the correct turn signal on. Is that correct?
Yes, sir.
So she's using her foot, her hand, steering, and making mental decisions at this time. Is that correct?
I would assume so.
And so when you have that issue where you have motor skills as well as mental choices and decisions, that's a divided attention test. Isn't that right?
Again, I can see your argument, yes, sir.
So she didn't have any of those vigilance problems that we just talked about, those driving in opposing lanes, etc., correct?
At least not for the short amount of time that I saw.
Okay. Judgment problems while the vehicle is in motion. She didn't drive in a manner that you thought she was impaired by her driving, correct?
I didn't observe anything that would lead me to that other than the windshield wiper in phase one.
We'll talk about that. Driving on other than designated roadway. She didn't do that. She didn't make an illegal or improper turn. She didn't stop inappropriately to your signals. Is that correct?
Agreed, yes.
She didn't make an improper or unsafe lane change. Is that correct?
Yes, sir.
She didn't exhibit any unusual behavior. You said possibly this windshield wiper that we'll talk about here in a moment.
Yes, sir.
She didn't follow anybody too closely. You said there was another car in front of her, but you didn't indicate she was following too closely. Is that correct?
Correct, she was not.
In all of these manners, she acted as a normal, sober driver would act. Isn't that correct?
Yes, sir.
After you stopped her, she didn't attempt to flee. Is that correct?
Correct.
She didn't fail to respond to your emergency equipment, your lights, etc. She didn't do that slowly. Is that correct?
Yes, sir.
There were no abrupt swerves by her?
Correct.
No sudden stops?
Correct.
No striking an object?
Correct.
No other violations other than that original speed?
Correct.
So those 30 cues that we just went through, I'm going to reserve the one so we can talk about this windshield wiper.
Yes, sir.
At least 29 of them you would agree Ms. Lively behaved as a normal, sober driver would. Is that correct?
There were no other things that I observed during phase one.
That would indicate that she's impaired.
Yes, sir.
You had no indications that she was impaired.
I had speed and the interest of the windshield wiper.
Well, again, we just discussed this. Speeding is not an indicator of impairment.
Correct. I'm saying the reason for the stop.
Okay.
On top of.
So at this point, your position is the only potential indicator of impairment is a back windshield wiper.
It's of interest. Yes, sir.
Okay. That's not a listed clue, but that's, as you said, that causes an interest. That's something that's different, you believe. Is that correct?
It's of interest. Yes, sir.
Okay. Now, when you go through and do an investigation, you're taught that you're to take complete, accurate reports, thorough reports.
Yes, sir.
Is that correct?
Yes, sir.
You're to write all of those things down. Now, you've got, I think the narrative that you tendered in this was 2 pages long. Clearly, you didn't do that while you're sitting there. You're not typing that out while you're going through this. Is that correct?
Yes, correct.
We've had officers in the past testify that it may be weeks before they get to those narratives. Some don't do it unless it's requested in discovery. Are you aware of that, first of all?
I think I've heard of that happening one time with a different agency.
Okay. How long after this incident was it before you typed your notes, your narrative?
The date, I can't tell you for sure. I don't know. I can tell you this, though. I don't know what day of the week this was, but what I'll generally do is, for one, I'm not going on time off for my statement. It's generally done, with the exception of there's one bid where I did have that luxury, just because of the way my days fell off. But more than a week, absolutely not. Absolutely not. Generally, it's within 2 days.
Okay.
2 days.
So this narrative where you're documenting all these things that you just testified to, that's done up to 2 days later.
Yes.
Okay. Do you come in and do all that from memory?
With the statement?
Yeah.
Well, I mean, we have the video as well.
Okay, so the narrative of what happened, that you do 2 days later, you go back, you review the video, and you type in, hey, here's what happened that I see from the video.
So to give you a full answer, what I'm doing is, in terms of like more totaling clues and things like that, that's something that I do once I've cleared the stop and I've released my person that I've arrested. I jot those down. So, example, I'm sure I'm getting ahead to something you want to get to, but I talked about a difference in clues from what I observed on the roadside to what I saw on video, right? So, in that instance, that's happening because I've total clues in the roadside on my head, but then, reviewing the video, even recently, a couple of days ago, that's why you have a difference there. So it's a combination. My report's a combination of what I observed on the roadside as well as the video. It's not just exclusively video. Does that answer your question?
So let me clarify. Your narrative is based upon what you remember, I guess, is what you're saying, and viewing the video.
It's based on my observations along with the video.
Okay. The impaired driver report, state one, where you do all that. When is that completed?
At the same time as the narrative.
Okay. So where you say she had 4 clues, that was actually first written down up to 2 days later after the arrest. Is that correct?
No, that's what I'm saying, is I totaled that after I cleared the arrest.
Okay, so you total that after you cleared the arrest. Where do you put that total?
Just on a jotted script down. I don't keep it or anything like that.
So you took notes?
My observations?
Yes.
I just literally write 4 clues HGN on a scrap piece of paper.
Okay, so we'll talk about that here in a second. On a scrap piece of paper, you write down 4 clues.
Yes, sir.
HGN.
I've done that.
On walk and turn, you write down however many clues.
Yes, sir.
You don't write down on that scrap paper what clues those are.
No, so I'm done. Okay, let me clarify. You're saying, what am I actually writing down on the paper?
I'm saying the first time you sit down, you said you do some type of notes, apparently, which haven't been turned over to us, but you do some type of notes immediately at the conclusion of your investigation.
Yes, sir.
Okay. Have you tendered those notes to the state?
No, sir.
Do you have those notes?
No, sir, I don't keep them.
Okay. So do you actually keep it in a notebook, or you said it's a scrap piece of paper? How's this done?
It's just I have a little like flip notebook. All
Okay.
right, jot it down there.
And do you have that flip notebook with you today?
No, sir. I don't keep it. What I do is I tear it out. I take it in with me when I'm completing my 70B, the impaired driver report, and then that's it.
Okay.
It's not an official document, so.
So this unofficial document that's your notes, you write down, you said HGN 4 to 6 clues.
Yes, sir.
And we'll come back to it, but do you write down which 4 of those 6?
Not for HGN. No, we don't need to.
Okay. And what about the walk and turn? Do you write down the number of clues?
Yes, sir.
And do you write down each and every single one of them? Or do you just say, 6 of 8?
No, so I'm writing down, like, I'll put HTT for heel to toe. I'll put OL for offline, so on and so forth, just a hand script.
Okay. And you take notes of how many times that occurs?
No.
So if it happens once, it's over, you're done. Is that correct? In other words, off the line. If she walked off the line 8 times all the way, if she staggered, walked all the way over here and back, you're not going to write down she took 7 steps or 8 steps off the line. Whether she does it once or falls down in the meeting, you're going to say off the line.
Yes.
Okay. One last thing.
Was I talking about the little script that I do?
Yeah, I'm talking about your notes.
I didn't ever talk about the 70B impaired driver.
No, I'm not talking about the 7B. I'm talking about the ones you do right now, right when you're observing all these things at the conclusion of this.
Yes, sir.
Do you write down all these things, or you just write down how many?
It's literally, like, if I could, give you a picture of one, it's literally 4 of 6 on HGN, or 6 of 6 on HGN. It's the hand, like the little hand jotted for the walk turn, HET, OL. Starts too soon, I literally just write starts. That's all I write. And then for one leg stand, push. the acronym for, let's put down, use arms of balance, sways, hops. That's it. That's the only thing on there is a total of clues. That's all it is. There's no narrative, there's no writing of any kind other than the clues observed in short.
And have you been instructed that it's okay to destroy these notes that you take immediately after the arrest?
No, it's not official document.
Nevertheless, that's, other than those quick jots, there are no other notes taken by you until you do the narrative up to a couple days later after you've reviewed the video. Is that correct?
Could you repeat the question?
Sure. There are no other notes that you do. There's nothing else you do other than until you prepare the narrative up to 2 days later after you've reviewed the video.
Correct. The only thing I've written down for the 70B is just a little shortening of the clues that I observed.
Again, when we first started this conversation, you were instructed to take complete, accurate, thorough notes of your investigation. Is that correct?
Yes, sir.
As a matter of fact, in the midst of it, they give you a nice little handy-dandy chart that you can fill out as you do these. Is that correct?
I believe so, yes, sir.
You don't do it, do you?
No, sir.
You just jot down some shorthand that you destroy and watch a video and then redo your narrative later.
So I don't know what you mean by redo, but I complete one.
Well, would you agree that your narrative is very specific on these issues, including, I think you state, hey, she lifted her foot as she turned around. She lifted her lead foot as she turned around. I believe you indicated in your narrative. Is that correct?
Yes, sir. Yes, sir, I did.
Well, you didn't jot that down in your notes.
Correct.
You didn't recall that as you were doing it later. It's because you saw it on video.
I mean, the video is also, video, me, it's, like I said, it's a combined thing.
Okay, so you would agree then that this narrative is not just your memory and recollection of what happened. You also add things into that narrative after the fact. In other words, you go back, review the video, and say, oh, yep, that, and you put that in there too, so that there'll be a complete and accurate report. Is that correct?
No.
Okay, what part of that is incorrect?
Well, the reason I say no is the way, correct me if I've misinterpreted your question, but the way I take your question is that you make it sound as if I am adding things that I might not have observed on the roadside later just because I saw it on video. That is not correct. If anything, I would say that I try to be, I go right down the line to the best of my ability. I've already referenced the walk and turn, where me personally, I observed on the roadside 8 clues, and then I review my video later, and I don't feel that I was right in that moment with Miss Lively. Further look on the video, I would actually say it's 7 of 8. If anything, it's been in the favor of your defendant. I'm not.
Well, but you reviewed that same video while you're typing the report, and immediately before typing the report. Is that correct?
I'm not just adding things in there. I'm going off of what I observed on the roadside.
So your testimony, though, is you watched the video before you did the narrative, correct?
Yes, along with it, yes.
Okay. You should have seen on the video. You should have known right then, not right telling us today at the hearing, oops, by the way, there's a change. Is that fair to say?
My job is to be honest and fair, so that's why I'm telling you today. I don't think that, from the video, I can see why I misinterpreted that. We can get into why if you want I misinterpreted that, but from the video, I don't think it would be fair or honest for me to say that I observed 8 of 8 clues, or fair and honest to say that Ms. Lively committed 8 of 8 clues. I did observe 8 of 8, but what actually transpired was 7.
But you watched that same video before you did this narrative. Is that fair to say?
Yes, sir.
Okay. Now, when you go through after the phase 1, the vehicle in motion, you move on to phase 2, that's personal contact. Is that correct?
Yes, sir.
And that's where you're making personal observations to determine whether there is reasonable suspicion to investigate further. Is that correct?
Yes, sir.
And is it fair to say that throughout this investigation, what you view back here serves as foundations for what you view in the future. In other words, hey, it only gets worse as you go on for an intoxicated individual. They're going to exhibit more signs here, and then they're going to exhibit HGN, and then they're going to, et cetera. Is that fair to say?
No.
I'm sorry?
No.
No, that's not fair to say.
That's right.
How is that not fair to say?
I would say it's consistent as you go along. There's been times where, I've observed things at the vehicle that I think is worth investigating, and get them out and conduct standard field sobriety testing if they're willing to perform. And there's not more there. It's not consistent, if that makes sense.
Okay, so you're looking for consistency as well.
I'm looking for consistency in actions that indicate impairment.
Okay. So you obviously don't grab every driver out of a vehicle.
Correct.
If you write somebody, pull them over for speeding.
Correct.
You're not just going to, hey, get out of the car, come back and talk to me. Right? You're going to do it for officer safety, always. If you believe there's an unsafe basis for keeping them in the vehicle, you're going to pull them out, stick them in the cruiser, handcuff them, do whatever while they're detained to preserve officer safety. Is that correct?
Yes, sir.
If you have developed a reasonable suspicion that they're impaired, you're going to pull them out to do the SFSTs, the pre-arrest screening. Is that correct?
Yes, sir.
And that's the third stage, by the way, pre-arrest screening. Is that right?
Yes, sir.
Okay. So if there is some other indication of reasonable suspicion that they're engaged in criminal activity, you're going to remove them from the vehicle. Is that correct?
Yes, sir.
And even if there is, say, only the odor of alcohol is the only indicia of impairment, if they are in a crowd of people in the vehicle, they got a whole bunch of them, and an odor of alcohol is coming from the vehicle, you're going to remove that individual. Is that correct?
Just based on the odor of alcohol?
Yeah, to determine if they're the ones, if they're saying, nope, I don't know what you're talking about, nope, I've been drinking, none of us have been drinking, you're going to remove them to see if the odor of alcohol is coming from them versus passengers.
It depends. Usually how I resolve the example that you're talking about, I ask questions. If I'm smelling alcohol, but the driver doesn't have watery, bloodshot eyes, if there's, no concerns with speech, and I have somebody else in the vehicle who does have all that as a passenger, that's not something that, why would I believe it was the driver when I have a person that acceptable answer right next to him? Okay, so in that situation, you would allow them to go on down the road after you write your citation or warning or whatever. Just odor of alcohol.
Yep. Okay. So, as you acknowledge that, you got to have this reasonable suspicion to pull them out of the car.
Yes, sir.
Okay. As we go through and let me rephrase that. So once you pull them out of the car, you've got reasonable suspicion in your mind to move on to the pre-arrest screening. It's not necessarily to arrest them, but it's to go on to the SFSTs in the pre-arrest screening. Is that correct?
Yes, sir.
And you would agree that you can't give a chemical test until you've decided, hey, there's going to be, they're getting arrested.
What do you mean by that?
You're not, can you just walk up, do you believe you can just walk up to a driver and go, hey, keep blowing this?
That's not how I'm about to do it.
No, you go through the SFSTs first, and then you offer them a portable breath test in this case, and throughout the state of Ohio. And the purpose of that PDT is to validate the conclusions to which you've already come based upon your observance of a standardized sobriety test. Is that correct?
I would say no.
How is that not correct?
Well, so for example, I've already alluded to it, or specifically said it, there's 3 different types of drug, for example, HGN, there's 3 different types of drug categories that can cause that. If I have somebody who has 6 of 6 clues, and I'm expecting to be highly impaired by alcohol, but they PBT, and 04, that's an indicative of possibly other substances involved, and has been the case in my experience.
Okay. Nevertheless, though, you've already come to the conclusion that, hey, this person's going to get arrested for impairment, and this is a validator.
Not a validator, I mean, it's part of the manual. It's the second part of phase 3. You have the pre-arrest screening, so you have SFSTs, and the second part that's outlined in phase 3 is the PBT.
And that PBT must come after the others, is that correct?
Yes, sir.
And why must it come after the others?
Well, there's an example here where I didn't get the PBT sample. That's not what determines impairment. Impairment is determined by following the SFST manual. For whatever, the PBT follows all of that. The arrest decision is made at the point prior to the PBT.
But the purpose is, according to the manual, it corroborates other evidence, it confirms your observations, it confirms alcohol as an impairment. Is that correct?
That, yes, that's different from what, at least I understood your question. It confirms alcohol to be part of impairment. That's, I've already spoken about, well, if I've got someone who I expect to be highly intoxicated, but I've only got half the limit of alcohol, there's other drugs involved. That, I agree with.
And you don't always give a PBT. I mean, if somebody is fine, you pull them out, you may have a reasonable suspicion, or maybe you pull them out, there's a strong odor of alcohol, and they say, I had one drink. We'll come back to that too. You pull them out and talk to them. If they are completely fine, okay, you may get 0 or maybe even 2 clues on the HGN, no other clues on walk and turn, on the one-leg stand. Are you going to give them a PBT?
If I only have 2 clues, I'm not even moving on to anything else.
Okay. If you have 2 HGN clues, you're not even going. I'm talking about that in the pre-arrest screening. On 2, because HGN is the most reliable, first of all. Isn't that correct?
Well, so the most reliable in terms of percentages, yes. I want to clarify that if I'm only suspecting alcohol, I'm not.
Sure, I understand that. And please, I'm not trying to trip you up.
Yes.
We're not going to talk about, I promise you, we're not going to talk about any intoxicants here.
Just want to be thorough.
If I do, I will specify, okay?
Yes,
Fair
sir.
enough?
Yes, sir.
So assume, unless I specifically direct you, we're talking about alcohol here. You're not being to do a PBT in those situations. Is that correct?
Correct.
Okay. You agree that if he started with a PBT, it could lead to confirmation bias.
Absolutely.
In other words, hey, I don't know, it's a close call on the HGN, but I know what they blew over here, so yep, it's a ding.
Correct.
And that's the purpose of doing a PBT last, if you actually have to do it.
Yes, sir.
Okay. Let's talk about your phase 2 personal contact and the reasonable suspicion to pull Ms. Lively out of the vehicle. You said that she had slow speech. Is that correct?
Yes, sir.
Okay. But you redefined slow speech during this hearing, or clarified it, I believe you said.
Yes.
It's not that her speech was slow. It's not that how she was projecting herself was at a slow rate. Your issue is that she paused before answering. Is that correct?
I mean, we're getting into semantics, but I articulated what I'm honing in on at that point.
Okay, and you said it was because she paused before she answered.
Well, I mean, again, this is my attention skill. She's examining the document. I'm not getting a response at all, and even when I do get the response.
Hold on, we're starting there, okay? It's not about anything else. I'm focusing on this, what you mean by slow speech. Okay?
Okay.
You said, and you stopped and said, let me clarify. By slow speech, I mean there was a pause before she answered.
Slow to answer. Slow.
She was slow to answer. It's not that her speech was slow, that her patterns were off. It's that she paused before answering. Is that correct?
If that's the way you want to word it, yes. I worded it, I guess, differently, but I feel like that my point's been made into what I was honing in on.
Okay. So, do you always view it that if somebody pauses and thinks about what you're asking them before they respond, that that's an indicia of impairment?
The fact that she was examining a document is not irrelevant here. It is the combined part of divided attention skills that
Okay? And what we're talking about there first, you had indicated, I think you indicated, well, here, if we can pull up, this is going to be defendant. Let's go with C. Mr. Major, who knows that?
Use the mouse, Mark. The mouse is up there.
No, it's going to be the.
Close it out and, oh, you got your own.
Here comes your own.
I heard you mention something.
It's like Disney World. Is this going to be C?
No, this is the wrong one.
Oh, he's yeah, down, come on, down. There you go.
Right here? Or
Right there.
I can't see all that. That's the. Yeah. There you go. It's right there.
Very quickly, I'm going to take it back to the action. That's wet pavement right down there in the center, isn't that correct?
I wouldn't say that.
Okay. So, let's take a look at that pavement.
Yes, I would say that's about it.
You agree there's wet pavement up there? It had been raining.
Sure.
Okay. It's not like she had her back windshield wiper on and it had been sunny all day and hot and no rain.
So,
Is that correct?
it's at night, there's no sun to cook the rain off the roadway. I do remember that if it had just stopped raining, it's not of any interest.
What would be, so indicative of just stopped raining would be, say, a wet car. Is that correct?
It could be, possibly.
Okay. You would agree the pavement is wet throughout that?
Yes.
Okay. You would agree that if there is wet pavement and somebody is driving in front of you, that they're going to throw some spray up, road spray on your vehicle, is that correct?
You asked, so we're getting into relevance here. I mean, the road's obviously not that wet. Look how long it stopped raining. You got a nice strip of dry right there. I mean,
Okay.
you're probably not kicking anything up with that.
Okay. You would agree that if she'd been traveling over a wet road, spray would have been sprayed up. Is that
If
correct?
there's still rain sitting, I can see that, yes, sir.
Okay. This is you?
Yes, sir.
Poetry? Why didn't you see that? Now, let me ask you, what's the condition of the roof of her car?
Wet.
It's wet. There are drops on there. There are raindrops on there. Is that correct?
Yes, sir.
That's after she's been flying up the highway at the massive speed of 68 and 69 miles per hour.
Yes, sir.
Okay. Did you observe the fact that her car was wet when you pulled her over and approached?
I don't recall.
Well, you obviously observed, you stated that, hey, her back windshield wipers on, and that's odd.
Yes, well, it's because the time between rain. I don't even, this is at midnight, I don't even remember it raining for that shift. That's why it was of interest to me.
Okay, but you didn't take that investigation further and look to see if she had a dry roof, a dry car?
I don't recall.
So, beyond that, you indicated that she had watery eyes.
Yes, sir.
Watery eyes is not a cue for impairment under this manual, is it?
Watery bloodshot.
Bloodshot eyes are. Watery's not, are they?
Watery bloodshot.
You believe that's watery bloodshot? We'll come back to that. Additionally, you indicated, by the way, is slow speech a cue of impairment?
No, it's not listed.
So the slow speech that you keep stressing that she had, and that was a cue for out, that's not even a cue of impairment. Is that correct?
That specifically, no, divided attention skills, yes.
Divided attention skills are, and we can talk about that, but slow speech irrespective of the stress that's been placed upon it here by everybody, it's not even a cue. Is that correct?
Not listed in the correct.
Does it say pausing and thoughtful consideration of a question is a cue?
Yes, sir.
Now, you said that you're familiar with the manual, 2023 manual. I'm going to hand you page 5, section 6, and ask you to take a look at that.
Okay.
Bottom slide. Does it talk about the eyes?
Yes.
And what does it state about the eyes?
What do you see? It has listed bloodshot eyes.
Where does it say watery eyes in there?
It does not.
It does not, because watery eyes is not a cue according to NHTSA. Is that correct?
Based on that page, correct.
So let's talk about those cues for the phase 2. You do have multiple things here. You have your sight cues, is that correct? Bloodshot eyes you indicate she had. Okay?
Sandy, yes.
Yes, sir. Yes, sir.
Did she have soiled clothing?
No, sir.
Did she have alcohol containers?
No, sir.
Did she have fumbling fingers?
No, sir.
Did she have drug and drug paraphernalia?
No, sir.
Bruises, bumps, scratches?
No, sir.
Unusual actions?
Yes.
Okay, what were those unusual actions?
So, if you're talking about other than speech,
These are the NHTSA approved cues. You say you're familiar with it and have been trained on it. What are the unusual actions under NHTSA standards that you observed?
I mean, if you're talking about something other than what I've already testified to, I feel like everything I've already testified.
Okay, so we'll come back to that. So you're saying those items that you've previously stated?
Yes, sir.
Okay. We'll talk about forget to produce documents or produce wrong documents. Did she do that?
She did. Yes.
And that was when?
Phase 1 or phase 2.
Phase 2, and you said that it was because she gave you her insurance policy. You weren't sure. You said maybe it was insurance, maybe it was registration. She gave you that instead of her driver's license. Is that right?
It wasn't that she gave me that instead, it was that she indicated she forgot to give me her driver's license.
She forgot to give you her driver's license.
Yes.
And you had to remind her then to do it, correct?
I did not.
Wait a minute, she forgot it, but then she didn't have to get reminded to give it to you.
She even apologized. She said, sorry, understanding that she had missed that or that lapsed from there.
Okay. By the way, part of personal communication, if somebody's speaking to you, do you typically look them in the eye?
I guess it depends on the circumstance. So,
We have been for the majority of it here today.
yes, sir.
Yeah? It's polite. Is that correct?
Yes, sir.
Is it polite to stop what you're doing and look at them? Would you take that as a cue of impairment if somebody, if you said, hey, about this, if they stopped what they were doing and looked up at you and spoke to you, would you take that as a cue of impairment?
I don't believe she actually looked up at me.
Okay? I've noticed several times when I've asked you questions, you've looked away from me, and looked down, and then answered.
Okay.
Okay? It's not unusual, is it?
In and of itself.
You just did it, by the way. It's not.
In and of itself, no.
Okay. We're searching our memory, trying to remember something. If you ask us a question, if somebody asks you a question, is that correct?
I mean, it just, again, I just did it, so, I mean, that.
Sure. I presume you're not impaired.
I'm not. No,
Okay.
sir.
Did she fail to see documents?
I missed your question.
Failed to see documents, like as she was going through them. You know, sometimes you'll have an intoxicated driver and they'll go pass their driver's license 5 times and hand you their credit card.
No, she did not.
Okay. Did she fumble or drop her wallet, purse, or documents?
No, sir.
Was she unable to retrieve them using her fingertips?
No, sir.
So out of those 12 cues, you've indicated unusual actions that we've already talked about, and that you said she produced the wrong document when she gave her insurance, and she forgot to give you the ID. Is that correct?
I didn't say she gave me the wrong document, but again, other than that, yes, I did.
Okay. Now, slurred speech, those are all the sight cues, 12 sight cues, is that correct?
I'm sorry?
Those are the 12 sight cues that it gives us.
I don't know the 12, if I could just rattle them off.
Okay, so let's talk about 5 hearing cues. Slurred speech. As I understand it, you said the first and only time that she slurred was when she said she just had one white Zinfandel, and you believe she slurred by not enunciating the T at the end of just, and that she said white instead of white. Is that correct?
Not just, it's not that she just didn't enunciate the T, it was an S. You know, you can hear the slurring of the S.
Well, there's an S before the T, right?
Well, right, but it was not just, it was just.
So it's kind of just
slur.
Just one word. We'll talk about that. But you said that's the one and only time she slurred her speech.
Did I observe? Yes, sir.
Okay, so she had no slurred speech prior to that when she's dealing with you.
Did I observe? No, it was the only time I observed.
Okay. Did she give you any inconsistent responses to any of your questions?
No, sir.
Did she make any unusual statements to?
I found that I've never had before since somebody told me about the pricing of their insurance. I found that to be unusual.
Okay.
And it wasn't just once. It came back to how much it was, how much cheaper it was.
So it wasn't just making conversation, here's why I went with this one.
It was unusual.
You actually asked her again about the insurance and delved further into it, didn't you?
What?
You asked her, well, what insurance did you have before? Is that
Yes.
correct?
Yes.
And then went into this whole, that's when she went into pricing, well, it's 70 or 50 or something, right?
Right. I didn't ask anything about pricing, but yes.
Okay. She didn't engage in any abusive language.
No, sir.
There were no, you said that you smelled the moderate odor of alcohol, is that correct?
Yes, sir.
Now, moderate, this odor of alcohol, the strength of an odor of alcohol deals with the recentness of when it was consumed, is that correct?
No, sir.
You don't believe that?
No, sir.
Okay, what do you believe that it is?
In my experience, what I found is that different types of alcohol can cause different strengths. Why? I don't know. And if I was testifying that why that is, we'd be talking about something I don't know or don't have a reason for.
So you would agree that you didn't put down what type of alcoholic beverage?
Correct.
You would agree that there is a different odor if somebody is knocking down gin versus if they are drinking tequila or vodka?
I can't testify to that. I can testify to the strengths. So vodka can be very, very slight, even if they had quite a bit. Whereas Budweiser hits you like a brick wall.
Even if they have one?
Yes, yeah.
Okay,
The
so
strength
wine.
is very different depending on.
Wine, sure as you know, if you're sitting in church, getting ready to take communion, you know whether it's wine or grape juice. Right?
Yes, sir.
Because you can smell wine irrespective of how much, but if they've had it recently, you're going to smell it. Is that correct? Okay. There were no other cover-up odors or marijuana or unusual odors. Is that correct?
Correct.
Now, you had the opportunity during this initial phase 2, during this personal contact, to use some non-standard tests. Is that correct? The alphabet test?
Yes, I mean, that's something that I have the option to do.
Counting backwards.
Yes, sir.
And that's to say, hey, count backwards from 53 to 48.
Yes, sir.
You didn't do any of those, did you?
No, I did not.
Finger to, do the finger test, is that correct?
That is an option, yes, sir.
You didn't do any of those.
Correct.
You felt that you had reasonable suspicion based upon a windshield wiper, odor of alcohol, and bloodshot eyes. Is that correct?
No.
Okay, what else? So let me ask you this, is that enough? Would that be enough for a reasonable suspicion?
Well, you've given me your highlights, but that's not everything that I've testified to.
Okay, let me ask you, is that enough?
I would say that the entirety of what I had was enough reasonable articulable suspicion to continue.
And that includes, we're going to watch in just a second again, this looking for the documents and the conversation about it.
Yes, sir.
Okay. You would agree there was no admission of drinking until you told her to step out of the car. It did not occur before you ordered her out illegally.
No, that's not the way it happened.
That's not the way it happened, you're certain of that.
The way I recall it, I asked her how much she had to drink tonight, and then I said, okay, she started telling me about the events of that evening.
Go ahead, I'm sorry, I didn't mean to cut you off.
It's okay. So I asked her how much she had to drink tonight after I handed her back her registration. And then from there, what happened? Well, she told me she had, oh no, I had one glass of wine. I said, okay, well, I'm gonna have you step up and ask you a couple
Okay,
questions.
so at that point, she had admitted to drinking one glass of wine.
Yes, sir.
Okay. She had exhibited no slurred speech prior to you ordering her out of the vehicle.
That is correct.
As we,
Agent Greenstown, Joyce, I stopped you at your speeds on 55. You have your ID with you?
I do.
now, she already had her insurance in her hand, correct?
I don't know what paper that is, but it was,
You don't recall what it is?
I don't know if that's registration or insurance.
Okay, I'm going to suggest to you that was her insurance.
Okay.
Now, we are required under Ohio law, if you're pulled over, or if you go to court, what do you have to have?
Proof of insurance.
Proof of insurance. She's been pulled over, right?
Yes, sir.
Okay. Would it be unusual for somebody to go ahead and have a proof of insurance ready? Would that be an indicator of impairment if they produce a document they know they're required by law to produce?
Some, occasionally, yes. Other people who are not impaired have had their insurance ready to go.
Okay.
It's not something- usually I'm always the one asking in the meeting.
Okay.
But okay, that's what you're saying.
But she's prepared, here's the insurance.
She's got it ready to go.
Okay.
Oh, I'm just
There's my insurance, okay? She even said that, right?
coming back from the concerns that
Okay, cool. Good deal.
You asked her where she's going, right? License, registration, where you been tonight? Divided attention skill, correct?
Yes, I've asked her for the license and asked her that question as well.
You've commanded her to give 2 documents, as she's handing you a 3rd document that's required under law, and you're asking her to also talk about where she has been that evening, is that correct?
I thought I'd only asked for her ID.
Agent Greenstown, Joyce, I stopped you at your speeds on 55.
Oh, okay.
You have your ID with you?
I do.
Perfect. What brings you out tonight?
What brings you out tonight?
Yes, sir.
Ask her for ID, what brings you out tonight?
Yes, sir.
Okay? Actually, you haven't even asked her for registration yet, have you?
I have not.
Okay.
Oh, I'm just coming back from the concerns that
Okay, cool. Good deal.
So that's my, new insurance,
Okay.
and I'll give you my ID. Sorry.
Is there, you think that that is not conversational? You think that that is an indicator of impairment?
We haven't made it to the part that I referenced yet.
Okay, well, so at this point, she has said, okay, she's talked with you, she turned around, looked at you, went to grabs her purse, she's not fumbling, is that correct?
Correct.
She starts, says, okay, that's my insurance, and then and I'm reaching for the ID. She didn't need prompted again. Is that correct?
Correct.
Sounds good. Take your
It's
time.
not, they'll give me all the people.
That's just not
All the insurance. You gotta do a little cheaper.
Yeah.
Now, she has, it looks like 20 daggone different cards in that whole stack of stuff that she just pulled out of her purse. Is that right?
It looks like a lot.
She successfully navigates all of that. Does she hand you anything other than her ID?
I believe she handed me registration.
I mean, right now, when she just went through this.
Okay.
Did she hand you, is there anything else in her hand right there other than her ID?
It does not appear to be.
Okay.
As long as it's got the coverage, right? Do you have your registration with you also?
Yeah.
Okay, that's the first time you asked her for registration, right? Okay, and she says yes?
You look like you're there for me.
No, I don't need that.
You do?
I save a lot of napkins.
That's all right. Nothing wrong with that.
And it looks like, well, it's not a tiny vehicle. Is that fair to say?
That vehicle? It was a Honda Civic? It's
Yeah,
not that big?
the inside. It's not particularly tidy. She says I have a lot of napkins and she's having to weed through them to get her registration. Is that correct?
That's what she said.
Okay. And then she grabs a whole stack of stuff out of her.
Where'd you guys meet up last night? Oh, nice, okay.
She looks at staff, doesn't see it, she doesn't need so long.
Yeah, I'm gonna make sure this is the right one, so I can put it on.
Okay, sounds good.
And what did she do?
She retrieved the registration.
And said, let me make sure it's the right one, right?
Yes, sir.
Because she said she had others in there, the prior ones.
Yes, sir.
And she wants to make sure she hands you the active.
Yeah. 11/11/23.
11/9 of 23. So presumably that's the expiration date of it. Is that correct?
I would assume.
Okay. F. Okay, Judge, I know there's intervening things. F. Would that be okay? Their videos are labeled A, B, C, D, and E.
Oh, why don't we start with defendants 1?
So defendants 1, okay. I'm going to do what's been marked in.
Opposite whatever the state is.
No, you state 1.
We use 1.
Okay,
just
so
made-
A,
Okay,
defendants A.
okay.
Do numbers with 1 and players with the other.
Well, I guess the videos are already numbered A, B, C, D, and E, but we can adjust those if need be. Okay, you do what's been marked as defendants A.
Okay.
You recognize that document?
This is a registration with Ms. Lively's name on it as the owner.
Okay, and there's an expiration date on there, right?
Yes, 11/9 of 23.
Okay, and it's up there in little print up the top, is that correct?
Yes, sir.
That's the document she successfully navigated to identify and make sure, I apologize, Mr. Hewitt, that is the correct.
I'm over here.
That is the correct document, is that correct?
I don't know if that's what's handy. I don't remember. I'm sure it is.
Okay. So, she successfully navigates, goes through, she's now done everything that you've asked of her, is that correct?
She's retrieved the registration. Oh, that's right.
Thank you. Is this mine?
Yes, let's put it back
Okay,
there.
now, while she was leaning over, you had stuck the insurance back in, she's saying, is it making sure, is that right? Is this my insurance?
Yes.
Okay.
So I just switched that.
Okay, who's that?
Now, right there, she now has grabbed this document and said, oh yeah, and says, okay, I just switched it, that's why it's a new. Right, because normally you get little cards, is that fair to say?
It depends, but yes.
Okay, this is not a card, this is instead a computer printout or something,
Could be, I don't recall.
which you would get if it's a new policy. Is that fair to say?
Yes.
State Farm.
State Farm.
Yeah.
You asked her who it was? She thought? Is that part of her slow speech?
So again, she's examining a document. I don't have to think about Allstate when I tell somebody my insurance.
Okay. Right?
This is good here. You did this. How much you have insurance?
Oh, no, I just got one that's on it.
Okay.
Yeah.
All right. Got the smell on it and that's a little.
I'm sorry, yeah, it is set up for this.
That's okay.
And my mom said ICU, and I've been spending time with her, and just went out and had one glass of wine, that's it.
Not a big deal. The only thing I can do is step out, ask you to do a couple things, but see your safety, drive it anyway, okay?
Okay. So you believe at this point now, you have reasonable suspicion to remove her from the vehicle?
Yes, sir.
Now, phase 2 doesn't end there when you order them out of the vehicle. There's actually some cues that you can observe as they're leaving the vehicle. Isn't that correct?
Yes, it is.
As they exit the vehicle.
Yes, it is.
Do you recall what any of those cues are?
I do not, but I also recall that I did not observe anything abnormal. It's not the exit of the vehicle.
Okay. They could be angry. She's not angry. She didn't have any unusual reactions. She didn't fail to follow directions.
Correct.
She didn't have difficulty opening the door. She didn't leave the car in gear.
Correct.
Had that happen, I think, in a couple of cases. She didn't climb out of the car.
Correct.
She didn't lean against the car if she gets out, stumble.
Not at this moment.
She doesn't keep her hand on her car to walk around it, is that correct?
Correct.
She exhibits none of those cues. So as it stands now, we have this odor of alcohol. She said she had 1 glass of wine. Her back windshield wiper is on. And according to you, she had this slow speech when you asked her. Is that correct?
Yes, sir.
No big deal.
Was your food good at least?
Yeah.
Good. Text the shirt out, so we're gonna mess up.
It's a shirt house, yeah, no. I just started looking on, see why it's supposed to know when I was there. Yeah.
Okay, let's go back and see. 1 glass of white Zinfandel is what you said, correct?
Yes, sir.
Okay.
Good. Text the shirt out, so we're gonna mess up.
It's a shirt house, yeah, no. I just started looking on, see why it's supposed to know when I was there. Yeah.
No problem at all.
You said 1 glass, I'm sorry, I just had 1 glass of wine Zinfandel. Sorry.
Go anyway,
No,
okay.
it's fine. No big deal.
Was your food good at least?
Yeah.
Good. Text the shirt out, so we're gonna mess up.
It's a shirt house, yeah, no. I just started looking on, see why it's supposed to know when I was there.
And that is, you believe, her slurring her speech showing intoxication.
Yes, sir.
Okay, even though that's the only time you allege that this happened during the entirety of the stop, during all of her conversations with you.
Yes, sir.
Now, let me ask you, because you referenced this during Mr. Hill's testimony, she never wavered from, I only had 1 glass.
That's correct.
Is that unusual? That a defendant doesn't waver from that small of an amount of alcohol?
I would say most alcohol would be IRS. Bill would eventually say how much they actually have. I would say most, yes.
Yeah, the majority of them, okay, you got me, whatever, or man, I shouldn't have had to mention it in some form or fashion. She never, not one single time did that, did she?
Correct. But she also would be the first that didn't also give me a full count of her actual consumption.
She said 1, correct?
She did
The
say
whole
one.
time.
Yes, sir.
Okay. So, let's talk about the SFST. I believe this is the one that Mr. Heald.
Stand normally for that.
And again, the progression of this is, on the SFSTs. First, we do HGM. We then determine, based upon the results of that, whether we go on to the walk and turn. And based upon the collective results and observations, then we decide whether or not to go to the 1-leg stand. And then, based upon the observations up to now, whether we do a PBT. And then we decide whether or not to arrest. Is that correct?
No.
Okay? What's incorrect about that?
So in the order of operations, you have the pre-arrest screening for phase 3. You do the Stanford sobriety testing. I've already spoken, though, that the decision to arrest has been made prior to PBT.
Okay. So you make a decision to arrest prior to the PBT?
Yes, sir.
Okay, so before you ever determine whether there's going to be a PBT or not, you decide, hey, I'm going to arrest. Is that correct?
Yes, sir.
Okay. First thing you do before you do any test is grab the PBT, isn't that correct?
That's correct.
Where do you live at?
You're right there. You're grabbing the PBT from your door as well as the mouthpiece. Is that correct?
Yes, sir.
And that's prior to any of the SFSTs. Is that correct?
Correct.
Okay, gotcha. That's the current address and ID, right?
Yes, sir.
What do you go by?
Brittany Lockley.
Brittany?
First thing that court office is actually medical report.
Like right on my insurance, right here on my leg. You actually stand on it.
She had no problem naming off all those different medicines that she's on. Is that correct? Told you what they were. She didn't stutter, she didn't slur, she didn't go through any of that.
She went through all that, yes.
So, let me ask you, when administering the HGM, okay? The mechanics of it. You stand at a bladed position, is that correct?
That's not a requirement.
It's how you're trained, isn't it?
That's advised, but they also advise that you don't expose your gun hip to the person. Me personally, those are recommendations, that's not the manual.
Okay. And you believe that the only reason that you stay in a bladed position is to keep your gun hip away?
I actually stand the opposite, I stand with my gun hip to the person.
Okay, so you do stand in a bladed position, but with your gun hip to the person?
I wouldn't say it's bladed, but that part of my body's closer to the person than the other.
Okay. You have to stand at an angle, is that correct, to properly administer an HGM?
You do not have to.
You do not have to. Okay. So when you do maximum deviation, okay? Well, whenever you do an HGM, it's supposed to be on a plane. Is that correct?
Yes, sir.
Horizontal plane.
Yes, sir.
So if you're bladed, you can do that on a plane, keeping track. Is that correct?
You can, yes, sir.
If you were standing face square, you cannot come out past here without turning your body into that bladed position. Is that correct?
I would not necessarily agree with that.
You think I can move my arm past here?
I'm not standing, like I said, I'm not standing up front, and I'm somewhat positioned. I wouldn't call this bladed, some might, maybe you would call that bladed.
Okay.
I think of bladed as this.
Okay.
I'm more.
You would agree you have to be at an angle in order to properly administer it on a horizontal plane. Is that correct?
If you're standing as you were, I can't do that. You would notice that
You're turning, right?
Yes.
You don't have a choice.
Yes, sir.
Because otherwise, you're going to be rotating your body around, is that correct? Which is going to be bringing the stimulus off of that horizontal plane.
Not necessarily. That's not, why would that be?
Let me ask you this. Is it okay to do an HGM in this fashion where it's an arc rather than across a horizontal plane?
Our goal is to, within the means that we have, keep that on a plane.
Wait a minute. These have to be done in substantial compliance, right?
Yes, sir.
These are standardized tests. If you don't do it in a standardized fashion, then the results are not, they're not correct. Is that fair to say?
No.
It's not fair to say that if you don't do it in a standardized fashion, that the results aren't correct? Can I make up my own instructions?
No, of course not. I'm not arguing that one bit.
Okay? You agree that you are required to do it in substantial compliance.
Yes, sir. Substantial. Not sure.
Okay. So you would agree that it must be done on a horizontal plane? Because you want to be 12 to 15 inches?
Yes.
And that if you're arcing, you're not going to be 12 to 15 inches. Is that correct?
There's going to be, I would imagine, that's why there's also a window of 12 to 15 inches. You know, we're a human being. Human body is not a machine. I can't have it exactly at 12 inches plus or minus 0 because I'm a human being. If I was a machine, I could do that. You have to understand that that's why there's going to be a window of 12 to 15.
But you would agree that I can't go and do an arc when I'm administering HGM. You at least get that, wouldn't you?
Well, I'm saying there's going to be some, we're not robots. I mean, even though some might agree that we are with state troopers, that is not at all what is expected.
Okay.
Our goal is 12 to 15 inches from the person's face.
You never instructed her to maintain focus on the stimulus throughout the test. Is that correct?
If she didn't, I would have redirected her just as I did when she moved her head.
That's not my question to you. My question to you is, did you ever instruct her to maintain focus on the stimulus until the test is over?
I told her that I wanted her to follow the tip of my pen with her eyes and eyes only.
Okay, that's still not what I asked you.
Okay. If you're asking me word for word, if I told her that, I did not tell her that.
You did not tell her to maintain her focus until the test is over. Is that fair to say?
I did not say that verbatim.
That is, you didn't say, follow it until I'm done. Follow it until I tell you not to follow it. Did you?
No.
Okay. And the purpose of that is because we're looking for gaze nystagmus. Is that correct?
Horizontal gaze nystagmus.
You would agree that if I shift my focus from that and then go back, it's going to alter the test.
Yes, but she...
And you have to then start over that test on that pass. Is that correct?
Yes.
Okay. The You would also agree that environmental factors can impact the horizontal gaze nystagmus test, is that correct?
Yeah, the big ones they talk about are we on a level surface? Is it a reasonable surface to expect to be this level? Is there potholes and gravel or something like that? So yeah, environment is relevant, yes, sir.
Okay. You noticed previously when we did the video, she nods and looks away and even says, with a blink. So that blink's going to get me.
She did say that, yes.
Okay. You saw her nod her head.
Yes, sir.
She did it. Clearly she blinked, nodded her head, looked away. You did not start and repeat that pass, did you?
I don't remember at which point she said it. If it was a concern, I assure you, it would have been accounted for.
Okay. Well, not if it's a concern. If you deviate at all, it compromises the validity of the test, doesn't it?
In what sense? What do you?
If you don't give instruction correctly, it compromises the validity of the test.
To substantial compliance, yes.
What do you, no, I'm not asking if it compromises to whether it's substantially compliant or not. I'm asking you if it compromises the validity of the test.
You have to repeat your question.
Sure. That's 2023 manual. So I'm going to show you the 2023 manual, which you said you've been taught under this. You've reviewed it yourself. You're familiar with it.
Yes, sir.
And I'm going to show you page 12, session 8. I'm going to ask you to read the final sentence of the paragraph there.
If any one of the SFST elements is changed, the validity may be compromised.
Okay. You changed it by not telling her to focus on it until the test was over, didn't you? No? Okay. Let me ask you for
In the tracks, yeah.
Okay, we're ready, right?
that should be what?
Okay.
Ready?
Follow this, follow with your eyes only, okay?
You see okay, ready to that point?
Yeah.
All right. Over your head, just follow with your eyes only, okay? Try to keep your head locked in there. When your head, since you call it, see how I'm moving right here?
Yes.
Hold the leg.
I see it, now I see it.
See how I'm moving my head? That's all I'm asking you.
Okay.
Ready?
Okay, and again, that is what we're looking for there on that pass.
Excuse me, I'm sorry.
Okay.
I'm still digesting.
You're the one that was at lunch today.
Lack of speed pursuit. All right, actually, that would be the pre-check, I'm
That was
sorry.
the pre-check, correct? And that's the lack of smooth pursuit, right?
Well, yes, I'm waiting for equal tracking, if that's the pre-check.
I want to make sure we're doing this. I don't want to confuse you.
That's
okay?
fine.
I want to make sure we get this right. That's the pre-check, right?
Yes, sir.
Okay. Now you have your distinct pause.
So you're about to tell me what the blank, what the other one.
So that's supposed to take you 2 seconds to get from center to left, isn't it?
Yes, sir.
It didn't, did it? You're doing it too fast, isn't that correct?
I don't know how long it took. I'm forced to estimate time.
Okay. I'm not going to get into the modified barometer, but let's. Yeah. Let's do this again. Okay. Distinct pause. Okay. 1001, 1002, 1003, back. 1001. You do that far faster than the 4 seconds it would take to go all the way back out in the center. Is that correct?
No.
I'm sorry?
No.
You don't think so?
No.
You don't think that was, you think that was 4 seconds?
I'm saying far faster.
Okay. You would agree that that was not 2 seconds out and back?
I didn't time it. I can tell you what I'm doing in my head at that time.
Okay. Would you like to time it here?
I'm going to object to further questioning on that. It wasn't brought up in the motion.
I said he didn't do it correctly, Your Honor.
We're going to be here till midnight, maybe, till Mr. McCown finishes, so continue. Just put on whatever you want to put on.
The distinct nystagmus. I'm going to ask you to show me at what point you see nystagmus in her eye. Okay? Now, she just nodded right there. Your maximum deviation, is that correct?
Yes, sir.
When she nodded and did that and blinked and lost focus, you should have started that pass. Is that correct?
She never lost focus.
Okay. She never lost focus when she nodded and blinked.
Correct.
Okay. Did you ever see nystagmus in her eye on this video?
The video's not going to show that.
You don't, the answer is no. Is that correct? You did not see it on the video?
Right, it's not possible to see it.
You don't believe it's possible to see it?
Not for this one.
As a matter of fact, they actually show you, when you're going into your training, they show you videos of nystagmus. Is that correct?
Yes, those videos are positioned squarely on that person's face, very close to it.
Okay. Let's take a look at this again from the dash cam. Okay?
Yes, sir.
You're actually rotating around, aren't you?
There is a slight change there. Yes, sir.
You would agree. Okay. Here we go. Right now you're looking for equal tracking, smooth pursuit. At the end, there's this jog that you did right there.
Very subtle, yes.
Okay? It wasn't the same rate. It wasn't a continuous rate of speed. Continuous rate of speed. Turn around and there's a jog and you park it. Is that correct?
I guess I've seen it, yeah. Let's see what he's saying.
Okay.
At what point are we at? I don't even know where we're at then. Please show me.
You restarted it. You're talking to her.
I showed her what I was looking for.
Yeah. And you said, watch this. Equal tracking at this point. Okay. Then you have your distinct pause. Now you're for like a smooth pursuit. Your first pass.
Okay.
Second pass.
Public services and exit.
It's the beginning of max.
So that's the beginning of max deviation. But in each of those passes, you turned, didn't you? You rotated your body, and you went into an arc at the end.
I wasn't watching my body. I was really just watching the
I understand that. Well, there are road conditions and all that. I certainly understand that. And you're trying to maintain officer safety, make sure she's safe. I understand that. But nevertheless, your pin jerked as you rotated and went on an arc. You don't believe so?
Mr. McCown, it is what it is. We see the video. Do we have to go over it and over it and over it?
I will move on, Your Honor.
Thank you.
You're very welcome. When it comes to one-leg stand, you take into account physical factors of the person taking the test. Is that correct?
Yes, sir.
One of those is weight.
Yes, sir.
Somebody's 150 pounds overweight, you got to take it into account.
It says that it can, it should be at least considered during the test.
Did you consider? Well, let me ask you, do you believe she's more than 50, at least 50 pounds overweight?
I have no idea what the limits are for someone of that height or what's considered overweight.
Okay. So by your observation, you're having to make this judgment call. Do you believe, looking at that, looking at the finish, she's more than 50 pounds overweight, and that you should take that as a consideration?
Like I said, I really honestly don't know what's considered for overweight. She said, she refers to herself, I think, as someone who, she might consider herself to be that. However, I'm asking her to do it. If she doesn't feel she can do it, she can tell me no at any time. And two, she said she was a sports player during the walking turn test. Those are all just as relevant as anything else you mentioned.
Well, and I appreciate that, but my question still remains, do you think she's more than 50 pounds overweight, which is what NHTSA says you got to look at? And if so, you consider.
It says that it can be something that to consider.
Did you consider her obesity a factor in this?
So this is the way I've always looked at it. you know, same for someone who says that they have.
Just hold on just a second here, I got to address something. Yeah, I'll do it Monday. You can't get out there. Okay, sorry. It's okay. Somebody in the jail with another warrant other than the one we were apprised of earlier. Go ahead.
Would you like us to backtrack a little?
I'm sorry.
Did you want me to repeat anything?
I can just get to the question.
Just start with the question earlier, please.
NHTSA says you're considerate if the subject is more than 50 pounds.
To consider, yes.
Okay, let me ask you first. Did you consider her capacity?
Of course, but more than that, again, I'm asking her, this is what I've always looked at, whether it be obesity or somebody with a sore knee or something like that, I'm asking them to do it. If they're not concerned enough about it, to actually tell me no, then neither am I.
So, is it fair to say, and stop me if I'm wrong, okay?
Okay.
Your consideration went to the point where she said, I only consider if she said, gee, I'm too obese to do this. But the fact that she did it, you don't consider it then.
I'm saying if she knows her body better than I do, she says she's a sports player for crying out loud. I don't know what that entails, but she referenced that when performing physical tests. If that's relevant to her, then it's relevant to me. If you're so obese that you probably not going to be able to play the sports with you.
20 years ago.
Let me ask you this. Did you consider obesity as a factor when you did one-leg stand and walking turn in this manner?
I did consider it.
How did you consider it?
I considered it in the sense of she said that she considered herself a big girl. I don't know what obesity, the number is, and I don't know her height, so I'm not going to be able to tell you what the obesity numbers are. However, that's not the only thing you take into consideration. This manual doesn't say they cannot do it if they're obese. It doesn't say that.
It says you have to take it into consideration.
It says that you can consider.
And it also says that if they're obese, they may have difficulty performing those tests. Is that correct?
They may.
Is that correct?
It does say that. Yeah.
So,
it does not say that they cannot do it.
you said that you look for consistency. Is that correct?
Yes, sir.
And in the consistency realm, HGN, when we're looking at HGN, as you said, that's the biggest predictor or best predictor of alcohol consumption. Is that correct?
I cited the numbers. I mean, they're all relevant.
So, and what that would indicate that if there is if there are 4 of 6 clues, then it's around 0.08.
They're at least 0.08.
Okay? And likewise with the one-leg stand, if there are 2, it's at least 0.08. Is that right?
Yes.
And how many is it on the walking term that would be approximately 0.08?
2.
So, if we're looking at consistency, if a person were impaired, you wouldn't expect to have 8 clues on a walking term and only a couple here and a couple here. Is that fair to say?
I would agree with that.
You would not agree that those are inconsistent returns?
No.
Those are inconsistent scores?
I would not agree.
So, did her obesity go into your calculations in looking at the consistency of that?
There's no calculation. I'm sure you don't mean that in a number sense, but just to clarify. There's no calculation in that sense if that's what you're referring to. At any point...
By the way, the California study, the validation study, you're familiar with it?
I'm familiar with the numbers. I haven't read the study.
Are you familiar with it? If they arrested every single person in that study, they would have had a 72% success rate.
Now I am.
So if they would have done that, if they just arrested everybody, they would have got 72, but you're saying, well, it's 88% here. Is that correct for the eyes?
I don't, like I said, I haven't read the study. So, I'm going off of what the manual cites.
If I could just have 30 seconds here.
No further questions, Your Honor.
Mr. Hill?
I don't have any more questions, Your Honor.
Okay.
Your Honor, I'm sorry, I would move for admission. I know
Okay.
you're going to rule on
All the
it.
exhibits are good.
And I do have one thing I would like to state kind of in closing. It's up to you, Your Honor, on a legal issue, if evidence is closed.
Why don't we do this, because there's things I want to know. If you want to argue, why don't you let me tell you what my thinking is?
Sure, absolutely.
You give me the stuff I want to look at, and then if you want to argue it after that,
Okay.
then you can. Here's where I am. I want legal authority on what's needed to advance to field sobriety tests, and what's the standard of proof for the state. Here's my thinking. Even factoring in her size, I think the field sobriety tests are bad for her. I mean, just observing the video, I don't have to set aside my common sense. I'm not trained to do field sobriety tests, but I've been around people for a while, and just looking at her, that's the thing that looks the worst in terms of impairment. And if we get to that, then I think she's got a problem. Is there enough to get her out of the car to make her do the field sobriety test? That's what I know. We've got the eyes, the speech, the admitted glass of wine, odor of alcohol, his testimony about divided attention. Is that enough? So I want some legal authority on that and what the standard of proof is, and then I'll make a decision. If you, after hearing that, if you want to make your legal argument now, or if you want to wait until after you.
I've got one other issue that that I would like to brief upon, Your Honor, and that would be State v. Harrington. I don't believe that the NHTSA standards themselves were omitted as far as the testing procedures. And State v. Harrington, which is a 4th District case, states that either the manual has to go in or the officer must testify to each of the standards for them to be admissible. And he testified as to what he did, but in Harrington, they said you have to testify as to actually what the standards are.
Okay, include that. I want to see that case and make that argument.
But in response to that, Your Honor, I think our responsibility is to respond to their allegations.
Well, there's your argument. Come back with an argument. So, the state has the burden of going forward, of course. So, I want you to file something first, Mr. Hill, and let the defendant respond to it, and then you can get a rebuttal. So, file something with me by next week from the state. The defendant gets a week, so that's the 6th.
Your Honor.
Yes.
I'm sorry. If he is to do it on the 6th, my problem is I'm gone. Basically, I'm up here on the 10th, and then I'm out for A-Ride training in Nashville the rest of that week.
Mr. Cummings is in your office.
He's actually attending it as well.
Training is really important.
Mr. Fisher's in their office.
Who does not do DUI work. So, I mean, if he wants 2 weeks, I'm not
Okay,
going
I'll
to.
give him to the 13th.
Okay, and that's fine, Your Honor.
And then I'll give you to the 27th.
Okay.
We'll make it 2 weeks, and then the rebuttal by the 3rd, and then I'll mark this for the 3rd for me to look at it, and hopefully I'll have everything here, and I can make a decision. Do you want to set it for an argument on the 3rd?
We can, sure. I've never been one
So
of
I
the
should
arguments.
have all the briefs submitted. If you want to come back and argue it, or if you just want to submit it, I'm fine with that. But if you want to argue it, I'll set it on the docket on the 3rd. You want to argue it? You don't have
Judge,
to.
you know me, I tend to love to argue, but that's, if that's not evident already today.
We'll set it for 3:30. Make the staff will love that. Your hour and a half argument.
Apparently that'll be a 5-minute at closing, Your Honor.
Now I'll set it, well, let's just set it for noon for argument. And I'll put that down as argument.
Thank you, Your Honor.
That'll be closer to when we will actually get to it than setting it for 10. We sit here all morning. Is there anything else?
Yes, sir. Are we talking to them or asking generally?
them, and then.
Okay, misunderstood, sorry.
Anything else from these folks on this motion?
No, Your Honor.
All right, Mr. Steyer.
I have Mr. Conley still.
Oh,
Drug test.
oh, sorry, I thought this was the last one.
We didn't get the drug screen back until after this had started.
Okay.
So,
Just in case
No,
getting my top from David.
Case number CRA 2343.
Thanks, Trooper.
CRC 2399, and CRB 23411.
Nothing will make you want to give a screen more than listen to Mr. McCown.
Oh,
Go on.
I just heard that, Your Honor. I'll take it.
Wow. Said, okay, I'll go ahead and do it now. He's talking into it, I had to sit and listen to him. Okay, well, we got You've seen it?
I have seen it, Your Honor. He is denying use. I'm gonna ask that, in the meantime, we'll do what we're gonna do. I'm gonna ask that the results be sent off for lab analysis.
Well, we don't do that.
I make the motion and you can overrule the motion.
Overrule.
That's fine.
He can, if he wants to go take a test himself somewhere, he can do that, but.
Well, I'll advise him that if he wants to go in.
These tend to be pretty accurate now.
Well, Your Honor, he gave two samples. The first sample was completely clean, but it wasn't warm to the touch or did not register any temperature on the cup. So I asked him for another one. I physically watched it come out of his body, this one, and that's what it tested for.
Yeah.
The first one I did not actually.
And it's a lot of the stuff that's circulating around in our community. And this is, we've been at this for a while, and he's not made any progress so far. I mean, I think we got to get real about this, or, because he's got a felony here, right? I mean, the other
There is a
alternative
felony,
is just take it to the grand jury and go down to the common police court and take your chances there. And if that's what you want to do, that's okay with me. I've got plenty to do here.
I understand, sir. I just.
But if you want to try to get clean, you know, as I say all the time, this court is for people who want to get in recovery. If you want to get in recovery, I'm all about helping you. But if you want to fight it, go down to the other court and fight with them, and you know, maybe you'll win. But they've got bigger anvils they can drop on your head too than I do. I can't send you to prison.
I understand, sir. Like I said, I just want to get this past me. I know it was a mistake on my part. If I would be obviously willing to do outpatient so I can still work and support my family, because if I do go
I don't see that
inpatient,
you've done anything yet. I mean, we've been at this since midsummer and nothing's happened yet.
I'd just like to get this rectified and move forward. I apologize for your time.
Your Honor, I'd just like to ask to have this set for another pretrial, and I'm going to suggest that Mr. Conley probably get an assessment, and that might guide the state's decision on whether to keep this matter here or not.
Where are you working, Mr. Conley?
Foundation building materials, delivering drywall.
You're driving a vehicle?
No, I'm laborer.
Oh, you're just
I'm passenger. Yeah, I'm a laborer.
Okay, Mr. Hill.
Well, Your Honor, I would like to say some things because we really haven't, it's been a while since I've even had a chance to speak even with Mr. Steyer about it.
I think it was about 2 o'clock.
Well, I mean, I've lost track of what day it is the truth. But we actually, if we didn't have this set for trial already, I spent a significant amount of time reviewing the evidence and the video and everything on this, and I came to some conclusions about what I thought about the case early on. And some of the things that I saw in the video were that Mr. Conley admitted that he'd been having drug problems before this ever arose. And so my thought from the very beginning was I want him to be in treatment. And I want him to do better, because I thought that based on his conversation, this is a lengthy video, by the way, and he speaks for a long time with the officers, and I felt like this is a guy who wants to get help. Now, I'm seeing now that maybe my assessment of it was wrong, but we've got a second offense OVI here, and we've got this possession charge. My initial thought about the possession charge is that they found a pill in the car. It wasn't his car. After a lengthy search through a bunch of garbage and stuff in the car that they found the pill. I wasn't concerned as much about the pill as the OVI. But now, of course, I have other reasons to be concerned because of the drug screen situation and the fact that we haven't had any progress on the treatment. So I guess in order to agree to keep the case here, I think we would need to have a plea on the OVI. And we would agree to delay sentencing and give him another chance and see how serious he is, because, potentially there is we can still take the drug case to the grand jury, or we can ask for the court to put him in jail for a bunch of time.
Your Honor, based on that, and I don't have my file with me. This has a felony pending, so I haven't done discovery. But based on all that's happened, I'm going to veer from my usual position on this and advise that it probably would be best to go ahead and enter a plea on the OVI. Now, this is based on my belief that Mr. Hill's speaking in good faith when he says he's not planning to take this to the grand jury, because, of course, by offering this plea, if he were to go back on that later, I've cut my client's throat in terms of fighting the possession charge. But so I'm gonna put a lot of faith in Mr. Hill to act appropriately here, but I'm gonna go ahead and suggest that he enter a guilty plea on the OVI.
Well, I think that it's staying here is conditioned upon his performance henceforth on treatment.
And with that being said, like I said, I'm willing to do whatever it takes. I do have a fiance and 2 small children that depend on me, and I need to do better, and I know that. And if I could do outpatient so I can still work, I would appreciate that.
Well, I'm going to tell you how this works would be that the court's probably is going to refer you to a provider. You're going to get an assessment from that provider, and the court's going to expect you to do what the assessment says. The court's not going to tell the provider, hey, this is an outpatient case. So if you go to that provider and that provider says inpatient, you're going to have to do inpatient if you want to keep the case here.
Yes, sir. I'll do whatever it takes.
And that should have already happened before now, but it hasn't for some reason. I mean, this is an event occurred July 3rd. Here we are, almost October. I have no record of him getting treatment anywhere. Have you been to treatment anywhere since July?
I've just been waiting to see what you guys would see deemed necessary by the court.
Okay.
I just want to resolve this and move forward.
Well, let's figure out what we can do with treatment. How do you pay for medical services? Do you have a medical card?
I just moved over to Ohio right before this happened, and I'm going to get an Ohio medical card, and I can. And
have you ever had one before?
No, I've had a West Virginia medical card, but I'm actually in. I've got paperwork in the mail stating that I'm filing for an Ohio medical card. So
okay.
That would be my first step.
You live this 77 Township Road?
Yes, I live right down the road, sir.
That's your address?
Yes, sir.
Okay, Taylor? Okay, I'm going to refer you to Bethesda. Do you have any problem? This is a faith-based program. Do you have any problem going to a faith-based program?
No, I believe in God.
Okay, so she'll assess you, and then let's come back. What did I say, October 6th had like 34 pre-trials?
I'm here the 13th, Your Honor.
Preliminary hearings. 13th is the least crowded.
I'm here the 13th.
Okay, so you're going to talk to Taylor, you're going to do what they tell you to do, and come back in 2 weeks, and hopefully we get a good report. And have you seen, you probably haven't seen his screen. Okay, you have seen it, okay.
They'll be clean no matter what from here on out.
That would be great. That would be wonderful.
It's my understanding, too, that there's going to be a plea to the OVI today?
Yes, he's, I think.
Yeah, we're offering a plea to the OVI, a guilty plea.
Mr. Copley, you have agreed that you are pleading guilty to the operating a vehicle intoxicated charge. The felony is just going to stay there, and hopefully down the road it'll get dismissed, because you're going to do really well in treatment. It goes
right.
away.
I've made it to 35 without a felony, and I really don't want that on my record, but I mean, I understand.
Yeah. Not having a felony on your record is a big deal.
Right, it does close a lot of doors when that happens, so.
Jobs you
just-
can't get after you get one of
Right,
those, so.
and like I said, it's not about me, I have 2 kids, so it's not about me anymore.
Now's the time to get serious about this, and you're getting, look at it this way, you're getting a chance to do this, and clear your record, and go on and have a good life, and take care of these kids, and all the things that you need to do, and you're gonna have help doing it.
Thank you.
So, make it work.
I will.
Talk to Taylor, we'll see you in 2 weeks.
Thank you, Your Honor.
What's the date of the next one, 10/13?
10/13.
10/13.
State of Ohio recall James C. Watts, case number CRB 23532 A and B.
Oh, he saw the results.
He must have seen them.
Mr. Watts must have got a peek at the results.
I understand he was informed of the results and he left the premises.
Okay. So there'll be a warrant from this court, because his is a misdemeanor charge, not a felony. And he has an OR bond, not a cash or surety bond. So, be a warrant issued.
State of Ohio versus Jonathan Alexander, case number TRT 231196 A, B, and C.
Judge, thank you. Have a good weekend.
Oh, okay, this is arraignment for Mr. Alexander.
What is I didn't understand that. What does arraignment mean?
Arraignment, well, let me explain it to you. That's the first hearing on a criminal charge, is called the arraignment. Purpose is just to make
That's
sure
what I thought.
make sure you understand what the charge is. This is a misdemeanor, which means it's not as serious as a felony. And I'll be asking you for a plea at the end of when we finish here. And the pleas you can enter are not guilty, guilty, or no contest. Not guilty is always the safest plea to enter, because it preserves all of your rights. You have a right to remain silent, you don't have to say anything. But if you do say things, it's being recorded, it could be used against you if you admit something about your case. You have a right to have an attorney, to have one appointed if you can't afford one, and the right to make the state prove any charge beyond a reasonable doubt.
I didn't even know he was giving me papers. He come to my motel the next day and was like, "Here, I gotta give you these papers." I'm like, "What?"
Okay, so this looks like the sheriff's arrest.
He arrested me.
citation,
Yeah.
which is unusual because they don't.
Very unusual.
But it looks like there was a crash report.
Not run off in a ditch, yeah.
Okay, one vehicle crash, August 21st of this year at 8:30 p.m. in,
This rope road here.
he didn't say what township it is.
You know the road that cuts up behind me?
Fayette Township. The report says Fayette Township.
Lick Creek.
Failure, okay, the A case is failure to display registration. It's a minor misdemeanor. What's the B case? Failure to control. These are both minor misdemeanors. So the good news is, neither one of these are jailable. So you can't get, what I said about getting a court-appointed lawyer, you can't get a court-appointed lawyer because you're not facing jail.
I would represent myself.
You can only get a court-appointed lawyer if you're facing jail time, and you're not. So he should have cited you into traffic
He
court.
shouldn't have a lot of stuff. He didn't
He
do.
didn't cite you in traffic court, he cited you on the wrong day also, right? September 12th, which was a Tuesday. Well, that's probably the right day. At 9 a.m., so that would have been, okay, and you've been sitting here, how long you been?
I've been here since 8 o'clock this morning. I asked her
Do you
what
have to
time.
listen to those lawyers argue about that prior case?
Huh?
Do you have to listen to those lawyers?
Hey, it's all good, man. It's kind of amusing. I mean,
Well, I don't know, we've got
Just parked beside you when I was in and that, yeah.
I thought, oh, I didn't know where to go, buddy.
Mr. Alexander, what I'm going to do, based upon the fact that neither one of these are jailable offenses, he cited you in for the long time, you had to sit here all day and listen to these lawyers, I'm going to dismiss it. You're free to go.
Damn, thanks, brother. Y'all have a wonderful day. For the rest of your life.
I was going to swim in the river. I don't know if that's going to happen. Court's adjourned.